Good morning, everyone. Call this public hearing of the Government Administration and Elections Committee to order. Any remarks from my co-chair? None from me. I believe House Ranking Member has an announcement.
Thank you, Mr. Chairman. Welcome, everyone. We have a nice agenda today. Looking forward to hearing everyone's testimony. Senator Sampson is absent for about an hour this morning. He had other business to attend, but he certainly will be here soon. I just wanted to let everybody know that. Thank you.
Thank you, Representative. With that, we'll get to the witnesses. And it appears the first one we have present is the Minority Leader in the House, Representative Vincent Candelora.
Thank you. Good morning, Chairman Flexer, Chairman Blumenthal, Ranking Member Master Francisco. I'm here to testify in favor of House Bill 5229. You have my testimony, and I'll just summarize. Essentially, what I'm looking to do is requesting clarification of Section 9-167A of our statutes, which in particular deals with minority representation on boards and councils. Essentially, the town of Durham, in which I represent, was put in an awkward situation where the individual who was elected as a minority representation rep had switched parties from unaffiliated to Republican, causing that board to have 3 Republicans sitting on the Board of Selectmen. It happened at a time when the first selectman then retired from her position and caused the Republicans to be unable to fill that slot with a Republican based on the interpretation of the town attorney. When you look at the statute, I think the intention was that when someone is elected, they're elected to serve in the seat that they ran as. In this situation, the individual had been a registered Republican, ran as an unaffiliated, was elected as an unaffiliated. There were no Democrats that had won. And so the town attorney at the time interpreted that to mean that he wasn't affiliated with a party, and therefore, even though he was fulfilling the requirement of the minority party, essentially found that he wasn't subject to those minority representation rules. So it gave him the ability to switch to any party he so chose, thus, I think, frustrating the intent of the statute. Had the individual been elected as any party, Green Party, Democrat Party, Republican Party, the statute clearly would have applied. In talking with the Secretary of State when this issue was arising, their interpretation was that that individual still fulfilled the requirements of the minority representation. And I know in my town, we had this issue come up, and that's how we interpreted it. So I thought we should take a look at this and clarify it so the issue doesn't arise in the future. And with that, I'm happy to answer any questions.
Thank you, Mr. Minority Leader. Are there questions from the committee? Representative Master Francesco.
Thank you. Thanks so much for testifying today and for that explanation. I'm just curious, is the town of Durham, do they elect their people at large, or do they have districts?
It's an at-large. So in that particular situation, you had an election for a first selectman and then 2 selectman seats. So it's a 3-member board, essentially.
And this particular position was for selectmen.
So this was a selectman that had changed their party, and the first selectman resigned. So what effectively ended up happening is, because you had 2 Republicans that were sitting on the board, it essentially only allowed the Republican Party to look at those 2 candidates to replace the first selectman seat. So it gave everyone else the inability to put their hat in the ring, because the interpretation was that selectman who had switched their party all of a sudden fulfilled the majority party seat, and therefore it made only him and the other sitting selectmen eligible to serve as first, because anybody else that would have been appointed if they were Republican would have frustrated the minority representation statute.
And the Secretary of State's ruling on it, can you elaborate on that a little bit more?
Yeah, I think the way they have treated this in the past is that when you're elected to a position of a representative, you fill that slot regardless of what your party affiliation is. So in my town, we have a 9-member board. We had a situation where our minority representation required 3 people in the minority party. And we had a situation where there were 6 Republicans, 3 Democrats. One of the Democrats switched parties to Republican, and the Secretary of State said, interpret that to mean that they're still fulfilling the minority requirement, even though they switched parties. So they didn't caucus with Republicans. They were still treated as the minority representative for the remainder of the term, which the statute is very clear on. But when you have a situation where somebody is elected as an unaffiliated voter, that's where there's ambiguity, I think, in the statute, allowing for those individuals to be able to just fulfill any requirement they want during the course of their term. That's effectively what happened in Durham's situation.
And I'm just curious, it just went to the Secretary of State. It didn't go any further into the court?
It did not go into litigation because what happened was they ended up choosing one of the 2 sitting Republicans to serve as first selectman in order to avoid any kind of a legal challenge. But it was definitely a difficult situation. It caused, to me, I think it caused a little bit of frustration in the process, in that you couldn't look at all the candidates in town in order to seat somebody. It was limited to those 2 individuals.
And in the charter, the town of Durham, do they govern by their charter?
They are. They have a charter, and the statute is what governs, I think, the rules of minority representation.
Thank you. I got to be honest with you. It's not uncommon that sometimes the statutes are not clear and things like that happen. We actually had something like that happen in our town at the last municipal election, where somebody was a registered Republican. They switched to unaffiliated, ran for their council seat on the 3rd line, won, but had switched to an unaffiliated voter like 2 days late. So it ended up going to court. So there is some question of how to resolve things. And I think you certainly bring up a good point. It's not uncommon. I think it happens probably more than we know. But thank you so much.
Yeah, and I think the issue is, in talking with different towns, they're treating this differently. So I think that's one issue that we have, is it is inconsistent in different communities of how minority representation is treated when somebody changes parties. And that's why I think we need to make this clarification so it's uniform across the board and made clear.
Yeah, I agree. It certainly can disrupt the workings of the town and certainly cause a lot of problems. So I certainly agree that it's definitely something we should definitely clarify. Thank you so much for your testimony. I appreciate it.
Thank you.
Are there further questions from the committee? I had one. So just for my understanding, would this bill prevent this person who's not affiliated with a political party from caucusing with the majority political party during their term, or would it just essentially deem them as unaffiliated regardless of what they're?
So I think when you change your party, if you after the 90 days, if you go from D to R to D, you'd have the ability to caucus, but for the purposes of minority representation, you're still counted in that minority. I know in our town situation, we did not have them caucus per se. And the bigger issue is sort of avoiding the litigation to this, because that's the only way to resolve it when these interpretations come up.
Fair enough. Thank you for the answer and for your testimony.
Thank you.
Next up, we're going to make a little accommodation here and change from our normal rules, because we have a rare moment of bipartisan comedy on this committee. So we are next going to have the chair of the Connecticut Democratic Party, Nancy DiNardo, and the chair of the Connecticut Republican Party, Ben Proto, come up to testify together on a couple of bills. And because they're testifying together and consolidating, we're going to give them collectively 4 minutes to testify. And there may be questions after that. We appreciate you being here, Mr. Chair and Madam Chair. Whenever you're ready, you can begin. If you just make sure your microphone is on.
Oh, it's
You
not.
just hit the button there. There we go.
It's-
That's on.
Okay, that time doesn't count yet. Members of the GAE committee, thank you for the opportunity to express my support and the support of the Connecticut Democrats for legislation that will give the voters of our state a stronger voice in choosing a presidential candidate and will update fundraising rules for our party structures. And I'm proud to say that this legislation is bipartisan, that my colleague, the Republican State Party Chairman, Ben Proto, and I have talked together and worked on help to craft these bills. And obviously, we're both here today to show our support for it. Presidential primary season traditionally focuses an enormous amount of attention on a handful of states in January and February. And for too many presidential elections, Connecticut voters have been shortchanged in the primaries by being scheduled in the last Tuesday in April, so that decisions in the field of the candidates in both the Democratic and Republican parties have already been made. House Bill 6908 would move the primary date, obviously, from the last Tuesday to the first Tuesday. And as we all know, 3 weeks or 4 weeks can be an eternity. And this shift in the schedule will give Connecticut voters a greater voice in the process and very likely more opportunities to meet the candidates. Should the legislation be approved, Connecticut's primary date this year happens to coincide with the New York presidential primary. And while in the past, our state hasn't always been a priority in candidates coming, given that we're so late and our small size, the candidates may take a different approach if they're already over one state. And this could elevate the status of Connecticut and could also result in more money coming to our state in terms of candidate advertising and event production for this to visit the state. And we also support the House Bill 6904, which would update fundraising limits for the state parties. State parties identify and nominate candidates for municipal, state, and federal offices and are involved in financing and managing campaigns for offices. As you know, the state parties are not income generating and rely upon donations to fund our work, which is fundamental to our democracy. Fundraising limits have not been updated, I believe, for more than a decade. And over that time, with inflation and other costs, have increased significantly. House Bill 6904 will allow both state parties to raise the funds necessary to operate. And again, I'd like to thank my counterpart, Republican State Party Chairman Ben Proto, for working on this in a bipartisan way to bring the legislation forward.
Well, good morning, Senator Flexer, Representative Blumenthal, Representative Massimo, and the committee members. What Nancy said. Again, support of the Connecticut Democrats and the Connecticut Republicans for 6908 and 6904. 6908 in particular, moving up the presidential primary, as Nancy said, will provide the voters of Connecticut a much greater say in who our presidential candidates are at the end of the day. And that provides for both the parties the opportunity to engage more people within our parties, to engage more people in our process. In addition to that, it's an economic boom for the state. We know that when the candidates come to a state, they spend a lot of money, not only on their media buys, but also within our hospitality industry, on salaries, on staff. So there's a tangential benefit to doing this, to making us a competitive state that candidates want to come to. As we move forward, it may be one party or the other is more prominent that particular year, given who might be the incumbent or who might not be the incumbent, or if it's an open presidential election. So the 6908, I think, provides the opportunity for Connecticut to have more influence within the presidential nominating system, as well as to provide voters more engagement within their party and with their candidates, and would urge adoption of that of 6908. In addition, 6904 would raise the level the maximum contribution limit for the state parties from $10,000 to $15,000. As Nancy said, we do not have a product to sell. We can't adjust our pricing. We rely on the kindness of strangers, as was once said a long time ago. And I know both for the Democratic Party and the Republican Party, our small donors are our lifeblood, and they really make our party hum. But our maximum donors are also instrumental in helping us pay our everyday costs. And like any other business, and we do have a business side of this, our cost to do business has increased over the last 10 or 12 years. And we need an opportunity to be able to pay for those costs as well. And with that, Mr. Chair, Madam Chair, I want to thank Nancy DiNardo and the Connecticut Democrats for working with us. And contrary to popular belief, we work together more often on things than might otherwise be known, but we appreciate the committee's time for entertaining us together. We're happy to answer any questions anyone might have.
Thank you. Any questions from the committee? Oh, Representative Massafrancesco.
Thank you. Thank you so much for coming together and testifying together in support of this bill. It's a rare moment. I certainly would agree with everyone. I'm just curious on the date that would that have any effect on any of the other primaries within the state? If
No.
you moved up the presidential primary?
Our primaries would be it would be an even year election primary. So our primaries for state office would be in August, currently in August of the even year for statewide and federal offices.
So the presidential primary would be when?
April, this year would be April. Currently it's April 30th.
Right.
We're asking to move it to the first Tuesday in April. So this year will be moved to April 2nd.
April 2nd. Okay. Doesn't seem unreasonable. Only a few weeks. And it certainly would be a benefit, I would assume, to both parties
And to the state of
financially
Connecticut.
and for the state
Yes.
to do that. Thank you very much. I just needed a little clarification on the other primaries. Thank you, Mr. Chairman.
Thank you, Representative. I believe Senator Flexer has some questions.
Thank you. Thank you, Mr. Chair. Good morning. Thank you both for coming here to testify today. I just have a couple of questions to just put Connecticut in perspective with the rest of the country. And I don't mean to put either one of you on the spot, but I believe in other parts of the country, there are fees for candidates to be on a primary ballot. There are monies that have to be paid in order to participate in those kinds of elections. Are you familiar with how it works in other states and how Connecticut is different in that manner?
You're talking the presidential primary?
Well, actually just any primary, but the presidential included.
Each state is different. And in Connecticut, for the presidential primary, the Secretary of the State has a tremendous amount of discretion as to who is put on the presidential ballot for both parties. And it's usually based upon polling standards, fundraising, where they are. Are they truly a real candidate, or are they just someone whose name is out there? So in our state, it's based, the secretary has a tremendous discretion. In other states, it's a fee. In other states, it's signatures. In some states, it's caucuses, not primaries. So each state is different in that regard.
And do sometimes those fees in the other states go directly to the parties, that they are elections or primaries that are run by the party itself and not by the government?
Yes.
Okay, thank you. And then is this going to fall in line with both of the major parties' schedules in terms of when the presidential primaries are happening? Is there any potential for penalty? I know in the Democratic Party, there's a conversation about, if states aren't following the newly aligned schedule, that there may be some sort of penalties that a state could face.
Well, ours won't. I mean, they could even be in March, but we chose to do the April 2nd because we felt it would be more beneficial to us. But so the penalty usually is you lose delegates to the state, to the national convention. And I know you're probably referring to New Hampshire, because New Hampshire does still, it's in their constitution. So they feel they want to keep it to being one of the first.
So this proposal for both parties is a way to move us up, but not face any consequences for
Correct.
the voters
Correct.
of Connecticut. Okay, great. Thank you very much for your time and your testimony this morning.
Thank you,
Thank
Senator.
you.
Thank you, Mr. Chair.
Thank you. Further questions from the committee? Just make sure on Zoom. I had one, which is just, hopefully this is a bit of a layup. If you could make the case to the national parties about why Connecticut is an ideal early presidential primary state. What are those reasons
What are the reasons why we would be good?
to be early? Yes.
Yes, well, the diversity in our state and not only, as far as people, but as far as money and our educational values. I mean, we just fit a great criteria for representative of the country. So that's why I think it is really important. Although it is a committee that does, and it also obviously talks to the president and the other state party national leaders for input as to how it's done, but before it came out, but yes.
I would agree with Nancy on the diversity of our population. And also not only our demographic diversity, but our political diversity as well as our geographic location being between the New York and Boston market. I think it would provide an opportunity for candidates to come someplace early where they really would have to show their ability within a diverse population that would also allow them to project into larger markets and more populous states.
But I appreciate those answers. I would also add we're very geographically compact and dense. So high target rich environment for direct contact with voters. So I hope that our national parties will keep that in mind as they're considering schedules going forward. Seeing no further questions from the committee, we appreciate you both being here to contribute your testimony today.
Thank you for your time.
Next up is Michael Brandy, followed by Christopher Davis.
All set? Good morning, co-chairs Flexer and Blumenthal, vice chairs Slappin and Morinbello, ranking members Sampson and Mastro Francesco, and distinguished committee members. I'm Michael Brandy, the executive director and general counsel for the State Elections Enforcement Commission. Before the committee today are 6 bills that are of concern to us. 3 we support and would like to, 3 we support and would like to work with the legislature to improve, and 3 bills we strongly oppose because their effect will be to further erode Connecticut's citizens election program, and one of which would seriously undermine all campaign finance along Connecticut. The bills we support are House Bill 6910, an act restoring citizens election program support, Senate Bill 1225, an act concerning citizens election program grants for gubernatorial candidates, and Senate Bill 226, an act concerning citizens election program and the timing of payment of certain grants. As we set forth in our written statement and support with data, the CEP has been enormously successful since it was enacted in 2005, with consistently high participation rates, high success for candidates to receive grants, and high success rates for CEP candidates winning public office. The only exception to this unprecedented success is the lack of recent participation by gubernatorial candidates in the program. These 3 bills address the perceived barriers to entry in the gubernatorial races. Excuse me. Insufficient grant amounts and the early release of pre-primary funds. These bills propose various solutions to these problems, and we support those efforts. Our concerns with these bills are practical and technical. For example, with respect to Senate Bill 226, we have some concern as to how we'll meet the needs of the gubernatorial candidates. Whereas the voucher program in Bill 1225 allows candidates to collect qualifying contributions while collecting and cashing in vouchers, and then apply for the primary grant after the convention when they have met the aggregate threshold. Senate Bill 226 makes money available to candidates only after they have raised all of their qualifying contributions. Many gubernatorial candidates have told us it is difficult to raise qualifying contributions before they have achieved ballot status. If the legislature is concerned with that some showing of public support is necessary, it could set a minimum number of vouchers that must be collected before they can be brought to into match, rather than requiring that a candidate be fully qualified. We also have one additional concern with respect to Senate Bill 226. This proposal doubles the general election grant available to major parties, but does not do so for the same minor parties and petitioning candidates. Currently, minor parties and petitioning candidates who can raise the qualifying contributions and demonstrate a showing of 20% of support may receive the same grant. We believe these thresholds are sufficient to protect the public fisc, and we are concerned that adding more barriers may reinvigorate the constitutional challenge to the program made at its onset. The remainder of the SEEC proposal, House Bill 6904, deals with smaller changes to the CEP, many necessary to ensure that the adjustments for the gubernatorial grants will go smoothly. We fully support this bill. Next, the bills we oppose: House Bill 5312 and House Bill 1224. The through line between these two bills is that each makes it much easier to qualify for public funds by allowing more money than with fewer constituents. We oppose them both. As with the above bills, we have extensive comments in our written testimony and refer you to that, but we'll keep our spoken concerns as brief as possible. Senate Bill 5312 raises the threshold for qualifying contributions to $1,000 for statewide.
Brandy, if you
candidates.
could, your time has elapsed. If you could summarize the remainder of your testimony, please.
So with regard to Senate Bill 5312, again, we oppose raising that qualifying dollar to $1,000. For example, in for a statewide candidate, this would mean that when you combine it with House Bill 1224, they'd only have to raise $1,000 from 75 people to qualify for $1 million+ in grant money. And we don't believe that that's meets the initial purpose of the program, which was small dollar donors, and to meet a certain threshold for, at that point, a minimum of 750 contributors to meet the basic thresholds. So the Senate Bill 5312 is something we would look to oppose. And the final bill, which I think it's important that we address, is 6904. Again, we've submitted written testimonies. We strongly oppose this bill. This bill will open up the internet to online solicitations for contributions that will completely upend the citizens election program, and we strongly oppose the bill. We're happy to answer any questions.
Thank you. Questions from the committee? Seeing none, we appreciate you being here with us today. Thank you very much.
Thank you very much.
Next up is Christopher Davis, followed by Lucas Rodriguez. And it's good to see you.
Good morning.
Whenever you're ready.
Thank you. Co-chairs, ranking members, and other distinguished members of the GAE committee. My name is Christopher Davis. I am the Government Relations and Responsible Gaming Manager of the Connecticut Lottery Corporation. I appreciate the opportunity to comment in opposition to Senate Bill 1223, an act concerning the State Contracting Standards Board. The Connecticut Lottery Corporation was established in Connecticut General Statutes 12-806 to operate the lottery and sports betting in an entrepreneurial and business-like manner, free from the budgetary and other constraints that affect state agencies. And that's a direct quote from that state statute. Last fiscal year, we generated $410 million for the state, including $402 million to the state's general fund, $4.8 million to offset regulatory costs, and $3.1 million to the state's problem gambling treatment and prevention services. The CLC looks forward to continuing our strong working relationship with the executive and legislative branches and to continue the transparency of our operations. Additionally, the CLC is uniquely situated as one of the only state quasi-public agencies that has direct oversight from a state agency, and that's the Department of Consumer Protection, which has oversight over all of our operations and must vet and license all of our gaming system vendors and suppliers. Currently, the CLC follows robust purchasing and contracting standards outlined in the General Statutes 12-815 and adopted by our Board of Directors, which is made up of the OPM Secretary and the State Treasurer or their designees, as well as appointments from the Governor and legislative leaders. All of our contracts are currently publicly available upon request, and any potential procurement contests are already eligible to be challenged to the State Contracting Standards Board under Section 4E-36 and by the state auditors. We are required by state statute to also have external audits on a yearly basis, and those audits are also regulated by DCP throughout various portions of their regulations. Additionally, the state auditors have performed several audits on our operations, and the most recent report done last year found, quote, "Our audit did not identify any instances of non-compliance with laws, regulations, and policies, internal control deficiencies, or a need for improvement in practices, procedures that warrant attention of management." Though we understand the bill's stated intentions regarding enhanced transparency and oversight, due to our existing transparency and direct oversight by DCP, the CLC has concerns regarding this unintended consequences of this often duplicative and one-size-fits-all approach attempted by the bill. Presently, we have a comprehensive purchasing policy that is also dictated by state statute and put into place by our board members. We feel that the State Contracting Standards Board may not have the experience or the knowledge of our very specific contracts when it comes to gaming systems in particular, as we have various gaming systems now, not just for lottery, but also retail sports betting and soon to be fantasy contests. So it's with that, we believe that these industry specific vendors and policies and purchases that we make would be unduly slowed down by us having to submit to a third or fourth agency, in this case, to the State Contracting Standards Board for any approval of any of these contracts. And with that, I'm open to any questions about specific examples or specific issues with the language of the bill or the type of procurement types that we operate in and are very industry specific that we would no longer be able to do under this bill.
Thank you very much. Other questions from the committee? Representative Branco.
Thank you, Mr. Chair, and thank you, Chris, for coming up for your testimony today. Do you have some specific examples of the impact of the State Contracting Standards Board?
Yeah, so Section 21 of the bill that's before us here today calls for us to basically throw out all of our current statute-driven purchasing policies and adopt the State Contracting Standards Board's procurement policies, and that is to be done by July 1st, 2023. So you can imagine that would be a major issue for us as we're undergoing multiple procurement processes right now. In particular, with that taking place and being put into place, we wouldn't be able to do certain procurement types because we would only be limited to the very few, like I think there's 5 or 6 that are put in statute that are eligible, like a request for proposals and whatnot, which we do use. But we also use requests for qualifications and requests for information, because oftentimes when we're going out, especially for these new products like sports betting or fantasy contests, we may not even have the expertise in those new fields to know exactly what to ask for in an RFP, which is very specific and binding in many cases when someone makes those proposals. So we utilize RFQs and RFIs in order to gather that information in order to be able to properly negotiate in the best interest of the state with those specific vendors. So by eliminating our ability to do those types of things by adopting this bill, not only would prohibit and slow down our ability to operate, but also significantly impact revenue for the state of Connecticut. Additionally, Section 16C of the bill calls for us to have to request a waiver from the State Contracting Standards Board for any purchases under $10,000. As you can imagine, we make a lot of those, and they meet once a month. So this would basically make it so that we can't respond quickly to anything that's going on in the marketplace. And we additionally, not only do we have direct oversight from DCP, which kind of sets us apart, but we're also the only state quasi-public agency that is in the private marketplace. We directly compete with DraftKings and FanDuel, the 2 largest sports betting operators in the world. And we operate directly against them in the private market. And they have none of these constraints. They don't have to follow any of these State Contracting Standards Board or even their own public purchasing policies or anything. So they can react quickly to, say, a Cinderella team winning over the weekend and beating Purdue, right? And they can immediately put out advertisements and purchase things and do things. We have to go through our processes in order to do those types of things. By adding on the need for us to then have to go to the State Contracting Standards Board and request the ability to purchase maybe some placards to go into our retail sports betting facilities, or handouts to hand out to some of our customers, would just completely make it unrealistic for us to generate the revenue that's expected from us from this General Assembly.
Thanks for that answer. And through you, Mr. Chair, do you have any concerns about the privatization contract language in there?
I would. I know that there may be some testimony later on today that says that this does not apply to us, but clear reading plain language of the bill is that it would apply to us because of the change in definition of state contracting agency. And this would be to all quasi-public agencies, not just to us at the Connecticut Lottery Corporation. But some of the issues with that would be, in our particular case, we operate with multiple operators for our sports betting. Not only do we have the one that does a solution for the actual sports book, but then we also have contracts for operating those retail sports books. A very delicately negotiated contract with Sport Tech, who operates the off-track betting facilities, where we have a number of our retail sports betting sports books. So they operate those. We also operate as state employees one sports book currently in the town of Shelton at Aruga's Sports Bar and Grill, where those are state employees that operate that. So under this bill and under the existing statute that we would then be put under this bill, State Contracting Standards Board could be requested by any interested party to then make us do a cost benefit analysis and a business case as to why we would have anyone other than our state employees operate any of these sports books. And as you can imagine, if we have to staff all 15 of our sports books with state employees, not only would we have increased state employees costs, but it would significantly lower the revenue that would be generated for the state, because of those costs would have to be used against that revenue. So we have some concerns there. The bill also would allow them to look back on those privatization contracts that we currently have, so they could open up that Sport Tech contract. And that was done very particularly to avoid any kind of litigation for the state when the negotiations took place between the tribes, us, and the state government. So we have a number of concerns there.
Yeah, thank you for that answer. And through Mr. Chair, one more question. What types of procurement processes that you use would be prohibited?
So I think, to my earlier point, I think the RFQs and the RFIs that we use, a request for qualifications and a request for information, those would likely no longer be able to be used unless the State Contracting Standards Board were to change the statutes, or the General Assembly would, to allow for that. That could cause some significant issues when we go out to request in the future. And it's really important to recognize that these are multi-year processes. In some cases, we are still in negotiation finalizations for our gaming system vendor contract that went out about 2 years ago, a complete conversion turnover that we're going to have later on this year, that will have all 29 of our retailers get new terminals and a whole new system put in place. The players won't notice a difference. You guys won't notice a difference, but as far as systems go, it's a major change that took significant resources to be able to do that. So if we were then to be pulled under the State Contracting Standards Board and have this additional scrutiny on top of what we already have for oversight, the potential of having to add additional employees just to come up with those cost benefit analysis or business cases would be significant for us. We would unquestionably have to hire new employees just to handle those.
Thank you. I appreciate your answers. And that's all I have, Mr. Chair. Thank you.
Thank you, Representative Master Francesco.
Thank you, Mr. Chairman. Thank you, Chris, for coming in. Appreciate your testimony. Just a couple quick questions. You mentioned in your testimony that you do have oversight from the Department of Consumer Protection. What specifically does the Department of Consumer Protection do that would be different from the Contracting Standards Board?
That I'm not sure of, because they actually have the ability to do quite a few things for us. They have direct oversight on all of our operations. So say they, if something were to go wrong and they didn't like it, they could literally just come to our offices and come in, talk to any of our employees, pull any of our files, overlook anything. But in their regulations, they specifically have multiple sections that talk about contracting and purchasing, that would allow them or require us to provide them copies of all of our contracts, have the ability to request audits on those specific parts of those contracts. They can call for very specific changes to those contracts and us to adopt any of the recommendations from those auditors within those contracts. So in our particular case, DCP has nearly all of the powers that already exist within the State Contracting Standards Board. So then add that on top of it would really impact us. Where it's not explicitly written into statute or regulation is dealing with the privatization language and the limits on procurement that I talked about before. Those would be put into this bill and be really restrictive to us, that kind of go above and beyond what DCP has. Now, theoretically, DCP could do those things too, be under their kind of blanket direct oversight, but it's not written in statute or regulation.
Thank you. And through you, Mr. Chairman. So I'm just trying to figure out, what the Department of Consumer Protection does that the Contracting Standard Board has done. So when you are for procurement, do you go out for bid? Do you have, or is it just a negotiation between the Connecticut Lottery and the vendor? Is there any bidding process in your department?
Correct. Yeah, there is. So we follow procurement policies that actually sometimes are stricter than what's currently under the state procurement policies. So we do go out to bid for nearly all of our procurement, especially on gaming systems. So to give you an idea, that's a multi-million-dollar contract, obviously. So that has to not only go out to bid and go through that process of public procurement, but also be approved by our board directly. And they have direct oversight over that contract and the negotiations that take place there. So yes, we do follow public purchasing policies that require either request for proposal, qualifications, information, and then a public process from there.
So when you say the request for proposal, it's just a request, it's just an RFP. In other words, it is an official bidding process.
That would be the official bidding
The
process.
the RFP is the
Yeah,
official
through
bidding
that
process.
process.
And
yeah.
that process that you do with the lottery is the same that's done in other departments within the state, or is the state contracting board? Would that be different, the process for bidding?
Potentially, yeah, because under this bill, we would have to follow whatever they come up with for whatever that process is. So we would have to throw out our current process that's worked for us for 50 years and is dictated by state statute, and gives us the ability to respond to things quickly, and instead adopt a yet to be determined policy by the State Contracting Standards Board. And so that is where there's a concern that could significantly impact our operations and our ability to generate revenue.
Okay, thank you very much for clarifying those questions for me. Thank you, Mr. Chairman. I have no further questions.
Thank you, Representative. Senator Flexer.
Thank you, Mr. Chair. Good morning. Thank you for your testimony. The employees of your agency they receive, you mentioned they were state employees. They receive state benefits,
They do,
healthcare benefits,
correct.
and they're eligible for the state employee retirement system?
They are correct.
Okay. And why is the Department of Consumer Protection oversight there? Can you walk me through the history of that?
Well, we started as a division of the Office of Special Revenue back in about 50 years ago. And we're state employees up until 1996, when the state government decided to spin us off as a public agency or as quasi-public agency. At that time, we were still under the oversight of DSR, the Department of Special Revenue, until about 2011 or 13, when that division was eliminated, and then ultimately the oversight of the lottery was put under the Department of Consumer Protection.
And are you aware of any other quasi-public agency that's under the oversight of another state agency?
Not direct oversight, no.
And
That
what-
I'm aware of, but it's possible that there could be instances where that's the case.
And before, I believe before your tenure at the lottery, there was a lot of controversy and some serious issues that had to be dealt with. Can you just talk through the interaction between the oversight you received from the Department of Consumer Protection and the functioning of the lottery as a quasi-public agency, and how that worked and how that's different than any other quasi-public agency?
Sure. So when we have to go out to bid and we ultimately select vendors, ultimately the Department of Consumer Protection reviews all of that and has to license every one of those vendors and system operators. So it's an extensive process where they do background checks and various other things on each one of the key employees of each one of those agencies. So they're directly involved in that procurement process and the ability to select those vendors. And then additionally, they have oversight over everything we do. So when we do like a lottery drawing, for instance, they're in the room with the employees that are doing the drawing over at Fox 61 Studios. They have people right there on premises. They also work with us closely on various other things like special investigations into any kind of issues that take place at either lottery or sports betting. We have almost daily interaction with them on various different aspects of our process. They oversee our advertising to actual operations. We provide them with information. They have to license every single one of our employees, which I don't believe any other quasi-public agency has to do that. So they vet and oversee each one of our employees when they become an employee and have to give them a license in order to operate here at the lottery.
Okay, thank you. Well, it's no secret that I have been very frustrated with the opposition of quasi-public agencies to this legislation over the last several years. I'm pleased that the Contracting Standards Board is finally a fully functioning entity after years of stalling, frankly. And while I'm disappointed to again be in a position to hear from numerous quasi-public agencies today, you being the first, so you're getting the wrath this morning to this legislation. Once again, I do not understand why sunlight for a quasi-public is any different for sunlight for a regular state agency. But perhaps this morning you've given a suggestion. DCP was a critical partner and frankly overseer of the lottery when there were a lot of issues several years ago. And maybe if the Contracting Standards Board is not the solution for the quasi-public agencies, maybe every quasi-public agency should be partnered like the lottery is with the state agency.
I can't comment about any other quasi-public agencies and their roles and how they operate. And I will say that it's my understanding that those issues that happened previous to my tenure at the lottery were not necessarily directly related to procurement, but other issues that would have been outside of the purview of the State Contracting Standards Board. But I certainly understand your concern. And that's why I think, although I have been, vocal about no quasis being involved, because, we are very uniquely separate in many ways. We do different functions. And in our particular case at the lottery, we have that direct oversight. Unlike any of the other ones, which is why I specifically am advocating for us not to be included in the State Contracting Standards Board bill. But I would also support, the idea that these other quasis have their own concerns and will be testifying today about those concerns.
Thank you. Thank you for your testimony. Thank you, Mr. Chair.
Thanks.
Thank you. Any further questions from the committee? Seeing none. Good to see you, and thanks for being with us today. Next up is Lucas Rodriguez, followed by Stephen Lance, followed by Bruce Putterman. And Mr. Rodriguez, whenever you're ready, you can begin.
Great. Can you all hear me? Yes.
Yes,
Okay.
we can hear you. Go ahead.
Perfect. Thanks. Well, good morning, co-chairs Flexer and Blumenthal, ranking members Sampson and Master Francesco, members of the committee. My name is Lucas Rodriguez. I am a student attorney at the Election Law Clinic at Harvard Law School, and I'm joined in this room by the clinic's director and my professor, Ruth Greenwood. We're here today to testify in support of Senate Bill 1226, an act concerning state voting rights in recognition of John R. Lewis. And we'd like to use our time to focus on the benefits of Section 3, which creates a statewide publicly accessible election information database housed in the Secretary of State's office. So what I'll do is I'll highlight 4 distinct groups that Section 3 will benefit. First, the data that this provision makes publicly accessible will help civil and voting rights activists understand how an election policy might impact a voter's ability to meaningfully cast a ballot. So that analysis in turn informs an understanding of whether that person has a claim under one of the substantive voting rights protections that Senate Bill 1226 creates. And so the data makes it easier to vindicate those protections. Second, the database empowers local election administrators to craft best practice election administration policy because it allows them to see and analyze how effective other jurisdictions' policies might have been. So sort of facilitating a data sharing, evidence-based form of policymaking. Third, the data makes it easier for civic engagement organizations to create voter guides. It centralizes the data that these groups use to match voters to the races that are going to appear on their ballot and to their polling places. So currently, these groups have to request this kind of data from each local jurisdiction in a very piecemeal manner that burdens both the civic engagement organizations, but also the local election administrators. And so a centralized, publicly accessible statewide database alleviates those burdens. Fourth, the database facilitates basically everyday citizens' ability to engage in redistricting processes because it gives them easy access to historical districting information, as well as historical voter turnout data, so they can provide meaningful input to redistricting authorities that are proposing new maps. In sum, Section 3 basically ensures that each of these 4 groups, the civil and voting rights activists, the civic engagement organizations, the local election administrators, and everyday citizens have the tools they need to play their roles in Connecticut's democracy so that democracy continues to work for everyone in an equitable fashion. Thanks so much and look forward to any questions you may have.
Thank you. Thank you for your testimony this morning. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Stephen Lance, who will be followed by Bruce Putterman, who will be followed by Devin Carney. Welcome, Stephen. The floor is yours.
Thank you very much, Senator Flexer, and good morning to you and to Ranking Member Master Francesco and all members of the committee. My name is Stephen Lance, and I'm from the NAACP Legal Defense Fund. I'm testifying, like Lucas, in support of SB 1226. This bill will address critical local needs in Connecticut and make the state a national leader on voting rights. We at the LDF have worked for 83 years to fulfill the Constitution's promise of equal citizenship for Black voters and all Americans. A key tool in this work has been the Federal Voting Rights Act of 1965. But this crown jewel of the civil rights movement, which at one point was perhaps the most successful civil rights law ever, has been chipped away at by the Supreme Court in recent years. And today, its protections are sorely needed. This makes a bill like SB 1226 even more critical. This bill builds on the federal VRA and on state VRAs in New York, California, and other states. And one major component that SB 1226 adapts from both the New York and federal models is called preclearance. This is in Section 5 of the bill. Now, preclearance is a little bit of a technical term, so that's what I'm going to focus on today in my testimony. And preclearance is a review process, essentially, that gives a second set of eyes on certain changes to how elections are run. It applies in places with indicia of prior discrimination, and it stops harmful changes before they take effect. So preclearance was the heart of the federal VRA. For decades, it prevented the need for case-by-case litigation. That saved voters time and pain, and it saved taxpayers money. And several states covered by preclearance, including Mississippi, agreed and said to the Supreme Court that preclearance works because it's efficient, it catches mistakes, it promotes transparency, and it improves election administration. Research shows additional benefits. For example, in counties covered by preclearance, the racial wage gap narrowed as Black workers started getting paid more fairly. And SB 1226 brings this proven tool here to Connecticut. The bill lays out a framework that the Secretary of the State will apply to determine which places are covered. The framework looks at recent voting rights or civil rights violations, current indicators of potential problems, including racial disparities in turnout and racial disparities in arrests. And so during the period that a municipality is covered, the Secretary will take an advanced look at things like polling locations, redistricting maps, and list maintenance practices before they're implemented, just to make sure they won't have discriminatory effects. So this is an efficient way to identify and solve problems before anybody gets disenfranchised. Because when it comes to the right to vote, that old saying holds true, that an ounce of prevention is worth a pound of cure. So that's the principle behind preclearance. One of the key parts of the bill. It's one reason among many that I hope everyone in this committee will support SB 1226. Thank you very much.
That right on time. Thank you. Thank you very much for your time and your testimony this morning and this afternoon. Are there any questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Thank you for your testimony. I appreciate you coming in today. Can you, I'm really not understanding preclearance.
Okay.
Can you give me an example?
Yes. So, okay, let's say that that a covered town is designing its polling places for an upcoming election. And the person designing where those polling places are going to be, for whatever reason, puts all of the polling places on one side of town. Now, imagine that that side of town happens to be a predominantly white neighborhood, and the other side of town is a predominantly Black neighborhood. So if this town is covered by preclearance, the clerk will send that specific policy, that proposed polling place plan, to the Secretary of the State. And they also have the option to go to a court, by the way, for preclearance if they prefer, but they'll send that proposed policy, specifically that map of where they're going to put the polling places for preclearance. And then it'll get that expert set of eyes looking at it and saying, wait a minute, I think you might have goofed here. This plan appears to kind of have discriminatory effects in that it doesn't provide equal access to the polling locations for people of color as it does for the white voters on this side of town. So that's likely a situation where preclearance would be really valuable, and it would lead to a resolution without having to actually run the election and have people be disenfranchised, and also without having to have litigation, which can be very costly for municipalities and voters.
So do you see any of that in Connecticut right now, currently, that there's people that are disenfranchised because of where the polling location is?
Well, I hear what you're saying. So I think it's important to say this is a perspective bill, right? It's looking at potential problems that could arise and basically just putting in a problem solving framework so that when they, if that does happen, it will get resolved. There have been situations in the past in Connecticut in several recent elections where there's been particularly long lines in Black and Latino neighborhoods. I think in 2010, 2016, 2018, and 2020, it was pretty, statewide news. So now I'm not saying that those necessarily would have been situations that this would apply to, but I think it's certainly possible. That's one of the benefits of preclearance is they can look at those decisions, just like the states like Mississippi and the others said back in 2013, that gives you a second chance. If you happen to make a mistake or something in the way that you've designed your election policy isn't going to produce fairness, you get kind of that second check and you can solve those problems before somebody gets hurt.
Right. It just seems like in that particular example that you gave me, it's trying to find a problem that we don't really have here in Connecticut. I have not heard of anything like that. What else would pre-clearance do?
Well,
It gives the authority, I'm assuming, to the Secretary of State, right? So a town would no longer have the authority to determine where their polling, let's say in your example, where their polling locations would be, correct? That authority would have to go to the Secretary of State.
Well, I think there's a couple parts of your question. I want to make sure we cover them all. So you asked about other examples. You asked about the authority to determine where the polling places are. Now, it's very important that the authority remains with the local folks. It's just that the Secretary of the State or a court is going to check it to make sure it's not discriminatory. The Secretary of the State doesn't say, I decide where everyone's things go. It's just that the authority will be at the local level, but they'll have a second set of eyes to make sure it's not discriminatory.
Right. And in your analogy, you are assuming, based on everything that you're saying, that there's discriminatory practices in maybe, let's say, our polling places in maybe Black and brown communities, that they are being disenfranchised as opposed to the other people, as opposed to, let's say, white people.
Well,
is that the whole notion of your pre-clearance?
Respectfully, Representative Master Francesco, I think the answer is no. That's not the whole notion. The part of the thing to remember here is that this is perspective. It's kind of like buying an insurance policy. You don't wait until the tree falls on your house to start calling insurance agents, right? You put this framework in place so that should something like this happen, which we can all agree would be a quite serious problem, there's an efficient, streamlined way for it to get resolved.
Okay. Can you give me a different example? Pre-clearance. Okay, so you talked about polling locations. What else would it do?
Well, thank you. Actually, I can give you a couple of examples that might kind of illustrate things that have been found in violation in Connecticut in the past. So in the 1990s in Hartford, there was a voter purge process that was found to flag for removal Latino voters at a rate twice as high as other voters. So pre-clearance, of course, wasn't in place at that time. But if something like that were to happen in the future, if a local jurisdiction were to say, here's my plan for, list maintenance, just to make sure that I'm removing people who have moved away, and that, also in the Hartford case, the people removed hadn't moved away. So it was flawed in a couple of ways. But if somebody were to propose at the local level a purge practice like that was going to wrongfully purge twice as many Latino voters as others, that's a kind of thing that pre-clearance could also catch. So that's one example. Another one I'd go back to is the case of Bridgeport Coalition for Fair Representation versus City of Bridgeport. This is a case, I believe it was filed in 1993. It ultimately was settled favorably for the plaintiffs in 1995. So this is a redistricting case, a case for involving local city council redistricting. And during the process of developing this local plan, a coalition of Black and Latino voters hired an expert map maker. They proposed to the city a plan that would have provided fair representation to Black voters and to Latino voters, a total of 5 districts of the 10 total, in which Black and Latino voters could have had an opportunity to elect candidates of their choice. But the city ignored that plan. Instead, they implemented they implemented a plan that had only 4 districts in which Black and Latino voters could elect candidates of their choice. And this led to litigation. The plaintiffs, the coalition, sued under Section 2 of the Voting Rights Act, one at the district court level, one at the Second Circuit. Ultimately, the Supreme Court issued another case clarifying a different aspect of Section 2 law while the case was pending. So the United States Supreme Court sent it back down to the district court to keep looking at it in light of that recent case. But the facts remained that the diluted plan had been enacted. So after all that, the city settled and provided exactly the remedy, the plan with 5 districts that were opportunity to elect districts for voters of color that the plaintiffs had sought. But this took 2 years of litigation, and it cost a lot of money, a lot of time, and a lot of pain. An election took place during the pendency of this litigation. At the end of the case, exactly the remedy the plaintiffs had said federal law required was implemented. And the city had to pay the attorney's fees for the plaintiffs. So that's a 2-year process that could have been prevented by preclearance, because it would have caught that problem before any of this harm had happened.
So in that particular case, through you, Madam Chair, I apologize. You want to put candidates up in a specific district based on race? Is that what you're saying? Because it wasn't equal?
Oh, I think there's an important clarification here, Representative Master Francesco. What matters is not the race of the candidate that wins. What matters is the opportunity, the equal opportunity for voters of different races to have the opportunity to elect candidates of their choice. So in this case, what mattered was that the Black and Latino voters in Bridgeport, under this case, were arguing that they had been denied an equal opportunity to get to have a voice in our democracy, to get to say who represents them. So it's really about the right of the. I hope that was clear. If not, what matters is the right of the voters to choose who represents them.
Right. And I understand that. It just seems, and I remember this conversation we had last year, to some respect, that we're picking, the voters have a right to choose who they want. And a candidate has a right to get on the ballot as long as they go through the process, right? And the voters decide based on who they like best.
Right.
But what you're saying is that this process, it would somewhat change that. Is that correct? If I'm understanding it? It's very confusing what you're saying. I have to be honest with you. We keep putting race into this equation here.
Right.
And I'm not understanding it. So the voters put up a candidate. I mean, the town committee, whatever, puts up a candidate, and if somebody else is not that chosen, they have the right through a process to get on the ballot. They get their message out there, and the voters vote for them. And they determine if they like that candidate or not. I'm not understanding what you're trying to say here, how that is wrong.
Well, respectfully, again, nothing that you said just now is wrong, and nothing in this bill would change that process of voters choosing who they vote for. I think what this bill gets at here is situations where either perhaps a practice, a policy, or something like a redistricting plan, or in certain cases, the use of an at-large method of election denies an equal opportunity for the people to have a say in who gets elected. You know, you represent.
Yeah, I think
we can meet afterwards. I'd be really happy to talk through about.
I don't want to get into a debate with you about it. I'm just trying to understand where you're coming from. And in my opinion, I think people do have equal access to, and they have the choice of their candidates. I guess I don't know. I guess that's all the questions I have, but I appreciate you coming out to testify and trying to clarify some of those things. It just seems to me that we're trying to create a problem that we don't have, because I haven't heard any of these problems in Connecticut at all. And that was my concern. Thank you very much. Thank you, Madam Chair. I appreciate the time.
Thank you, Representative. Are there other questions or comments from members of the committee? Representative Haddad.
Thank you. And thank you very much for your testimony. I represent an unusual community. I have a small rural community, and in the middle of it sits the University of Connecticut. And so we have a very large urban like campus in the middle of our rural community. And as a result, we have a very high concentration of 18 to 22-year-olds that sort of dominates the regular or standard, typical voter in our community. Is age a protected class?
Age is a protected class under the 26th Amendment, which granted people between the ages of 18 and 21 the right to vote. This bill directly references the Voting Rights Act's definition of a protected class, which is race, color, or language minority group. So in the bill as written, age would not be a protected class, but in this situation, in some college campuses that are in rural areas, you may find that the college population is more diverse than the surrounding area. And in that case, a claim under the Voting Rights Act or a bill like this that included race as the point of discrimination would very potentially be relevant.
I appreciate that response because I think if you look at the demographics in our community, you would in fact see that the racial makeup of students on campus is much more diverse than what you see in the regular community or the rest of our community. And I just wanted, I've heard this, the questioning with Representative Master Francesco, and I'm not particularly proud to share the anecdote that I'm about to share with you. But I will share with you that in the 2008 election in Mansfield, we have a single voting place for students who vote on campus, and it's shared with votes who have some off-campus voting addresses. And I think, the 2008 election was unusual in that there was a very high level of interest from students who voted on campus. And as a consequence, the typical setup that was established at that voting site that day led to some serious inequities in terms of the way that folks could access their right to vote. So if you were a local voter with an off-campus voting address, you were directed towards one of two tables divided by your street name, as you typically find in many voting places. Students who had an on-campus voting place were directed towards the third voting table. At midday or somewhere around 2 o'clock, you could walk up to either the two neighborhood voting tables and vote in probably it took you 15 minutes. The line for students stretched around the building and was several hours long. And so I guess I wonder if that's the kind of procedure that I'm going to say, like, I think the moderator and the folks who said the polling place were acting based on historical expectations and didn't react early enough to what was clearly an unusual election. But is that the kind of disparity that might be called into question in the way that you're referring to?
Well, I think potentially, yes. Like that's the kind of thing that that advanced review that pre-clearance can provide becomes really helpful for, because it's not the case that the people designing the polling place were trying to do something wrong, that maybe there's some factor they didn't consider. And when you send a pre-clearance submission to voting experts, in this case, in the Secretary of the State's office, you'll get basically their free consulting services. So that kind of thing that can cause a problem could be prevented from doing so.
Yeah, I appreciate that day. There was great resistance to modifying the plan by the moderator that was assigned to that voting place. But eventually, with some intervention, things got better and that line got moving much more quickly. And I'm grateful for that. And subsequent elections, I think our town responded appropriately and sort of staffed up those tables. And so we don't see that problem anymore. But I suppose had we not made those changes, then that would be the kind of systematic barrier that might come into play. Would it also, the Voting Rights Act also apply to Election Day registration?
Well, I think it's Section 2 of the Voting Rights Act applies to any relevant policy, practice, prerequisite to voting. And so I think that this also would potentially apply if there were disparities in access to the Election Day registration process.
Right. And so you've probably heard anecdotes about when Election Day registration was first enacted, that in several communities around the state, and again, mine included, there were lines out the door for Election Day registration. And in fact, many of those voters were dissuaded from joining that line with signs that said, the line is too long, you're never going to get through it. Is that the kind of discouragement and systematic process that might come under greater scrutiny with the legislation in front of us?
Yes, Representative Haddad, it definitely is. And that kind of barrier, that kind of thing that makes it harder to go in and exercise your vote, because people don't have all day to go wait in lines. And you see that many times people put everything else on hold, they'll wait in those lines. But even then, even if they're able to cast their ballot in the end, their rights, I would argue, have still been violated by requiring them to put up with that extra hurdle. The Fifth Circuit Court of Appeals, which is, based in Texas, put this very well. They said that in previous times, some people paid the poll tax and still voted, but their rights were still infringed because they had to put up with that extra hurdle. So I think it's important. Yes.
Thank you for your answers. And I just wanted to give some real life examples of, when well-intentioned people can set up procedures that simply don't work on election day. And that turns into and can turn into a very serious problem. And then the denial of people's right to vote in a prompt and efficient way. Thank you very much. Appreciate it.
Thank you, Representative Blumenthal.
Thank you, Madam Chair, and thanks for being with us today, Stephen. I was wondering if you could describe for us in plain language the concept of racially polarized voting and how it's implicated in this bill.
Thank you. That's a great question. Racially polarized voting is another one of those technical terms that not people don't use it every day. But basically what it means is that there's a divergence in the candidate preference or electoral choice of people of color as compared to white voters. And it's really an empirical question. It's something that experts with PhDs study and determine whether it's present or not in a jurisdiction. And one of the reasons that it's really important to consider in voting rights bills is because under certain conditions, if racially polarized voting is present, it can contribute to a real unfairness. For example, I'll give you kind of maybe a little bit of an extreme example, but imagine a hypothetical town that had 10 seats for town council. And this town has a population of 51% white voters and 49% Black voters. And now let's assume that racially polarized voting is quite significant there, meaning that the divergence between candidate preferences is almost 100%. So in that situation, if the seats are elected at large, all 10 of those seats could potentially be chosen by the 51% of the white voters, rather than the whole nearly half of the rest of the town. So racially polarized voting, especially in what's known as the vote dilution context, whether with unfair district maps or in certain cases with the use of at-large systems, which again aren't always bad, but in certain situations can produce these kinds of unfairness. Racially polarized voting is a key part of evaluating whether that creates an unfairness.
Thank you. And how is it determined whether racially polarized voting exists? You mentioned experts. What do the experts do?
Well, yeah, I should preface that I'm not qualified to do this analysis myself, but so, places like LDF, we hire expert witnesses who make a career of studying this. It's something that political scientists, have been doing for decades, and courts, including the Supreme Court, have recognized as valid and important. There's a Supreme Court case going back to at least 1986, recognizing the importance and the validity of this analysis. But essentially what they do is they look at the smallest geographical unit for which election results can be isolated, and they compare that to the racial demographics of that same unit. And that's a gross oversimplification. It's there's a lot of it's a technique that one of the best techniques is called ecological inference. It's a complex and sophisticated statistical technique that people, again, usually with PhDs will perform, but they can find with a high degree of accuracy the extent to whether voting is polarized along racial lines in a certain election. And the more elections they look at, it's the better the data gets.
Would it be fair to say that basically what you're describing is, and it's, I'm sure, an even more gross simplification than what you described. It'd be fair to say that these are essentially statistical experts that look at precinct data and compare the demographics of those precincts with their choices in terms of who got what votes in those precincts, because obviously we can't know what any in particular individual did in their vote.
I think that's a very fair characterization, and that's important. Yeah, it's not. They look at the election results would show whether a person voted, not how a person voted, but then they look at how the votes were cast in that precinct or that locality.
And so I guess if there's a high correlation between, I guess, the demographics of a particular district and their choice of candidate, that would be essentially an indicator of racially polarized voting.
That's my understanding, and we should caveat that the expert witnesses I've worked with may be watching and saying you're getting, but this is essentially, this for in layman's terms, this is essentially the concept. Yes.
Okay, and so what would this bill do where there's racially polarized voting?
Well, it would do two things. One, as in federal law under Section 2. In that same 1986 Supreme Court case I mentioned, the United States Supreme Court laid out a list of factors known as the totality of the circumstances that together give you a sense of whether the political process is equally open in a jurisdiction. And one of those is, and importantly, is the presence of racially polarized voting, because it interacts with the laws, the policies, the practices in that jurisdiction to help you determine whether there's a fairness. I won't go through the whole list of the totality of the circumstances, but they also include things like socioeconomic disparities in health and education, vehicle access, these kind of things that might impact your ability to get to the polling places. And so one thing, just like in federal law, if a person is filing a case against an unfair districting plan, racially polarized voting is one of the key factors that the court will consider in reaching that analysis of whether, under the totality of circumstances, the political process is equally open. Now, one innovation that this bill makes, which is actually an innovation in the sense that it's not in federal law, but it goes back to 2002 in the California Voting Rights Act, is a more efficient way to challenge at-large elections when there is an unfairness being produced. And so actually, we can go back to my somewhat extreme example of a town with 10 at-large seats and stark racially polarized voting, and a bare majority of white voters whose candidate preferences or electoral choices differ significantly from the Black voters. They have the opportunity to unfairly kind of determine every single seat on that 10-person body, right? So this bill provides a streamlined cause of action against at-large districts, where if racially polarized voting is present, that can be the key finding to determine a finding of vote dilution.
Thank you very much for that answer. And I have one last question. It seems like as we run through this bill, there's kind of two themes here. One is protections of the individual's right to vote, and also protections against the dilution of minority constituencies' votes collectively. Would that be fair to say? And would you point to any other themes beyond that one?
Well, I think
those two.
Thank you very much for the question. I think those are key points, especially with respect to Section 2 of the bill, which is the affirmative causes of action. I think maybe a couple of points that I might point out too, and which I think you'll hear testimony about today. In Section 4 of the bill, language assistance is provided on an expanded basis as compared to what's currently required under federal law. I won't go into the whole details, but it's a very good improvement. It makes it so that more languages can be covered than just the somewhat limited number of languages that are covered under federal law, and that this assistance can be provided in more places where there's evidence of a need. I'd also point to Section 6 of the bill, which includes protections against voter intimidation, obstruction, and deception. This is building on what's already in federal law in Section 11B of the Voting Rights Act, a statute dating back to the Reconstruction period known as the KKK Act, and others. Basically, this gives people an affirmative cause of action if they experience voter intimidation, obstruction, or a deception that interferes with their right to vote. And on this note, I don't want to take too much time, but I should thank in absentia Senator Sampson, because his comments, his feedback on the voter intimidation provision last session in committee were very helpful, and I understand in getting the new text to be stronger and to respond to his concerns. So those are some of the key things this bill includes.
Well, thank you very much for being with us and for your work on this bill and this issue. And thank you, Madam Chair.
Thank you.
Sorry, one more question. I'm not chairing anymore. Thank you, Madam Chair.
Thank you, Representative. Are there any additional comments or questions? Representative Hoxha.
Thank you very much, Madam Chair. So go with your hypothetical example. So what would be the remedy to that type of situation? Would it be just kind of unilateral authority from the state government to determine who the winners ought to be? Would there have to be a new election? And I haven't read the entirety of the bill. I will say that, and maybe it does, offer a remedy somewhere in the bill, but can you speak to that? What would be the remedy in that type of situation, and who would be the authority that gets to basically impose its will on the voters one way or the other?
Well, thank you very much for that question. I think I have to say no respectfully to one of the questions you asked of whether this was going to be imposed on by state authority or overturning election. The remedy would be in a case like this. First of all, it's important to note that this is a case filed. This kind of case will be filed against the system of election, not against a particular election. If that makes sense, that distinction makes sense. So you'd say this system of election creates an unfairness, and it would create an unfairness in a future election. So you would bring that case in court, and the judge would look at the evidence, and if you prevail, if the evidence proves that your vote is being diluted, that your rights are being violated by this by the system in this case, because it's an at-large system, remedies could include districting, taking that at-large system and turning it into a districted system in whole or in part, or they could also include things like alternative methods of election, things that in Alabama, for example, there's a good number of places that use a method known as cumulative voting as a remedy for Voting Rights Act violations. So that I hope that responds to your question. The key thing is that we're challenging the system of election, or perhaps the map. We're not looking at the results of the elections per se.
So the remedy would if there is one, if there is a remedy deemed valid by the courts, it would occur in a subsequent election cycle. It wouldn't be something that would be kind of imposed on the election outcome of said case that is being brought before the judge. Or is that also a possibility of altering the results of the of a particular election that is being contested in front of this judge?
Well,
through you, Madam Chair.
Thank you very much again for the question. I think that altering the results of an election is simply not an available remedy. But yeah, so it'd be the court must find that the remedy is feasible, and that might include, for example, if I were to file my lawsuit on election day and say I want the remedy today, the court might say, I'm sorry, Stephen, that remedy is just not feasible. Right. So you want to file this case with some reasonable time to ensure that a remedy can be implemented.
Thank you, Madam Chair.
Thank you, Representative. For the second time, Representative Mastro Francesco.
Thank you, Madam Chair. I apologize. As the conversation continues, I start thinking of questions. Going back to the remedy, as Representative Hoxha said, so the court would determine that the process, we'll say, maybe needs to be changed going forward. You're saying it wouldn't change the outcome of that current election. Is that correct?
Yeah, if you're saying if in this hypothetical, the election has just happened, and then I file a suit saying, hey, this system of election is unfair, that would really be a prospective remedy. That is to say, for the future, the map or the system of election might change going forward.
Okay, and then let's just say that the process did change. Maybe they threw redistricting, and the same result happened. Then what?
Well, we need to know the facts of the case to really answer that question respectfully.
Well, my point is that when people vote, they vote for a particular candidate. And in this particular bill, it sounds like we are trying to pick a candidate or make sure that there's representation on any board or whatever based on race. Now, there are many towns in the state of Connecticut where maybe the population is maybe all mostly white, and they may have a candidate of a black and brown person that wins the election because they voted for them based on their qualities. The same thing with Bridgeport, Hartford, or New Haven. It's maybe made up of mostly the minority black or brown people, but the representatives of government are not, because they chose that person based on their qualities and not by race. So my concern with this bill is that we are trying to determine outcomes of a candidate based on race. And that is where I really struggle. And that's where I really have the problem with it. And so I was curious to listen to your remedy. If the court ordered that the process is not clear, we need to diversify. Maybe you need to redistrict that area. And at the end of the day, the same outcome, because people in that community, whether they're black, Chinese, or white, they like that candidate based on their qualities, and the same outcome happened, we'd be back to square one, right?
Well, I think that we're on the same page now. If the voters like that candidate, then that candidate is the voters' candidate of choice, and they're successfully electing their candidate of choice. So there would likely be no voting rights issue in that situation.
Correct, and that was the choice of the voters from day one. Doesn't need to be challenged in court. That was their choice from day one.
I absolutely
Follow
agree.
me?
I don't think that case should, I don't think that case should come to court. If the voters are electing the person they want to elect, then that's a good thing. And that's not, that wouldn't be a voting rights problem. This bill would have nothing to say about that.
Okay, thank you so much for your testimony. Thank you, Madam Chair. I apologize for the second question.
Thank you, Representative. Seeing no further questions or comments from members of the committee, thank you again for your time and your testimony today.
Thank you.
Next, we will hear from Bruce Putterman, who will be followed by Representative Devin Carney, who will be followed by Stephen King. Welcome, Bruce. The floor is yours.
Thank you. Thank you, Madam Chair and Co-Chair Blumenthal and members of the committee. I'm Bruce Putterman. I'm publisher of the Connecticut Mirror, testifying in support of House Bill 6347. As many of you know, the Connecticut Mirror is a nonprofit, nonpartisan news organization covering public policy in Connecticut. We're 13 years old. We were formed to fill the void in a shrinking State House press corps that occurred beginning in the early 2000s, and that continues to this day. We do not charge people for our content. All of our content is free. There's no subscription. There's no paywall. There's no barriers to people getting the information they need to participate in democracy just because they can't afford it. I want to thank Representative Farrar for asking me a few months ago, unsolicited, if there was anything that the legislature could do to support local journalism in Connecticut. As you know, state government already funds local journalism to some degree through awareness advertising campaigns that you saw, for example, during COVID, testing and vaccine advertising, through various marketing campaigns, through subscriptions that state agencies pay to daily newspapers, and of course, through public notices. Federal taxpayers already fund public media like National Public Radio. So the question isn't whether government should fund journalism, it's about the allocation of state funding for local journalism. And it's a question of what's the right balance between the state's marketing and communications objectives and ensuring that the full range of local journalism options, including hyperlocals and ethnic media, can be established here in the state. I won't talk now about the importance of local journalism. I mean, for many of us, it's self-evident, but there are other people who will speak to this issue and who've provided written testimony who can cover that. What I'd like to do is make 8 observations. First of all, Bill 6347 is revenue neutral. Secondly, state advertising spending, particularly around awareness advertising, skews heavily toward the out-of-state for-profit companies with out-of-state owners and out-of-state shareholders. So to the degree that there's profit margin in government advertising that is realized by those major newspapers, that's profit margin that's going out of state and not being reinvested here in Connecticut necessarily. Many digital news organizations in Connecticut, like the Connecticut Mirror, like Connecticut News Junkie, and many hyperlocal. So hyperlocal means kind of your local digital only, and in some cases, print and digital news organizations. So in West Hartford, we have WeHa, there's Good Morning Wilton, there's Weston Today, there's the Darianite, there's the Newtown Bee. Is that me already? Is that 3 minutes? So in any event,
thank you. Take it easy.
They don't receive any state advertising or barely any state advertising. So I'll just kind of wrap it up now by saying that we're flexible in terms of there are several models that already exist. One right down the road in New York, one in Chicago, that takes this approach of kind of reallocating or mandating a reallocation of, in New York and Chicago's cases, municipal advertising spending. We're happy to share some details on how that works. And we're flexible in terms of implementation. The only thing that's non-negotiable for us is that whatever funding mechanism is created, if the bill is adopted, could not compromise our editorial independence. That would be a non-starter for us.
Thank you. Sorry to interrupt you, but your time has elapsed. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Representative Morin Bello.
Thank you, Madam Chair. Through you, I have just a couple questions. So what forms of state advertising would not be subject to this bill?
So in general, I would say that any state advertising that's designed to reach an out-of-state audience that the digital nonprofits and the hyperlocals don't reach, for example, tourism advertising and economic development, business attraction advertising, that in our minds would not be considered kind of part of the calculus. What I do think should be considered part of the calculus that may not be evident is social media and search engine platform advertising. So to the degree that state government is trying to reach various audiences through Facebook, through Twitter, through Instagram, through Google, through Bing, that is a form of digital advertising. There are local ways of reaching people as well as those platforms. So that advertising to me would be part of kind of the calculation of what's total advertising for the purposes of calculating a 50% amount that would be mandated or at least allocated to locally owned or nonprofit news organizations.
Thank you. What would the criteria for eligibility be? And do you know how many news organizations would be eligible?
You know, there's including hyperlocals and ethnics and nonprofits, there's roughly 36 news organizations, and that doesn't include community newspapers, which kind of dot the landscape, and we didn't count those out, but many of the community newspapers are locally owned as well. And in terms of criteria, so that's it's tricky, and as a matter of what are the principles that should drive the establishment of criteria, I think one should be kind of regularly publishing news or information that is important to members of communities. So kind of the one person blogger who posts something every couple of weeks might not necessarily qualify. So there are plenty of small nonprofits or hyperlocals that operate. They should qualify. So Nancy on Norwalk is a great example. She is a one-person show for the most part, but she publishes, she is heroic in the amount of work that she puts into serving her community. She publishes on a regular basis. So size of organization shouldn't necessarily be a criterion for establishing eligibility. And, then you get the tricky question of if there's a out-of-state corporation that technically owns an in-state subsidiary, does that count? And because all of the major daily newspapers are actually our customers, I'm not inclined to wade into the answer to that particular question. But I'll leave that as a framework for you all to think about as you, or for whoever implements this, DAS or whomever it may be.
Thank you. Just one last question. What kind of third-party organization could monitor and manage this process?
So that's a great question. So that gets right at editorial independence, right? So the last thing that we want is to write a story that maybe is critical of DPH, and then all of a sudden having health advertising awareness not come to the Connecticut Mirror because of that critical story. The reverse is true, although our culture doesn't let us do but we wouldn't want a chilling effect to occur either that would kind of keep a potentially critical article from ever being published for fear of losing advertising dollars. That's not an issue for us. We're actually not very reliant on advertising at all, but it could potentially be an issue for other organizations. So what is happening in New York is that a group called the Center for Community Media has been created within CUNY, the Newmark Journalism School at the City University of New York, CUNY. And they essentially serve as a watchdog. They address the eligibility questions. They represent, they help community and ethnic media develop media kits, which is a way of communicating with advertising agencies about pricing and what the benefits are and who the audience is for their specific niche news organizations. The Center for Community Media also is essentially kind of a court of appeals if there is a concern among some of the member media that they are being left out or that the formula isn't being applied fairly. They can go to the Center for Community Media, who has a relationship then with the city, who is ultimately in New York, at least, the ultimate payer and distributor of funding. We have a colleague from an organization called Rebuild Local News, which has formed through local journalism organizations all around the country. And she is here with us today. She'll be testifying later this afternoon, and she can provide more details on how some of those third-party organizations work. I will say this, so we have talked to a university in Connecticut about potentially serving as a third-party watchdog. We've also talked to the Connecticut Foundation for Open Government as a kind of neutral third party with an interest in democracy issues and the role of journalism as in advancing democracy. And they both, it's very early and it was a little presumptuous of me to even ask that question of them, but they both said, oh, interesting, and they would consider serving in that role.
Thank you.
Thank you.
Thank you, Representative Master Francesco.
Thank you, Madam Chair. Thank you so much for your testimony. I am certainly all in favor of the state of Connecticut using state money to help our local businesses here. As far as the digital advertising goes, for example, I think the decision is probably based on the user, right? Who is using, let's say Connecticut Mirror, for example, how many hits a day or in a week or within a month go to your website for news?
So we have an average of about 275,000 users per month.
Okay. And then I'm just curious, so it's 275,000. And how many like unique users? They're signing up for the first time, they're one time.
Yeah.
Any idea?
I mean, yeah. So maybe a better way of looking at that is we have 16,000 people who have signed up to receive our morning newsletter. And so that's kind of one metric that we chart. The 200, so the issue with the 275,000 is complicated from a technology perspective in that, Bruce Putterman on laptop is a user. Bruce Putterman on phone is another user. Bruce Putterman on iPad is a third user. So we know how many users there are. We don't know how many actual people there are. That's just a limitation in the way the internet works at this point. So that's why we look at kind of the newsletter signups as a good barometer.
Yeah, and that's why I was wondering what the unique users were to try to narrow down. And I think many times people choose an outfit, whether it's print or digital, based on their users, right?
Sure.
Based on what their audience is, especially state of Connecticut trying to get news out there. It's 3.6 million people here in our state. So I think they're kind of looking for a variety of news outlets that can certainly get that message across to them. And it's possible, like you said, there's corporations from out of state that really running the smaller businesses here in Connecticut, the smaller news outlets possibly. So I certainly can appreciate that. But like I said, I believe I'd love to see the state of Connecticut certainly keep their money in the state. But again, they need to make sure that the users, the people are looking at it and it's certainly used wisely. And obviously, Facebook, Google, Yahoo, all of those are obviously big and they're gonna get more users, more views, more hits than probably our local newspapers. So I can understand that as well. It's important to get the news out there and the message. So thank you very much. I appreciate your testimony. Thank you, Madam Chair. I have no more questions.
Thank you, Representative Santiago.
Thank you, Madam Chair. Through you, thank you, Mr. Putterman, for being here. Advertisements are pretty important when you're dealing with the newspapers. The spending on public notices already support local journalism, and is this something that your newspaper goes after?
So yes, public notices, it seems to me, do fund local journalism. However, the statute, we don't get any public notice revenue. As a digital only news organization, we don't get any public notice revenue. The reason for that, and we've had some conversations with Council of Small Towns and town managers in a couple of cities, a couple of towns. And the reason is that the statute, as I understand it, references newspaper, and it was kind of established back before the digital era, and that no one who places public notices wants to run afoul of a requirement to place them in a newspaper. We would argue that, you know, we are as much a newspaper as anyone else, but in any event, public notices do provide some support for local journalism, but they don't provide support for the digital onlys, including the hyperlocals.
And through you, Madam Chair, one quick question. So that means that some of the state advertising would not be subject to this bill then?
Some of the, yeah, so advertising that's directed out of state, that's clearly directed out of state, you know, advertising in the New York market to attract New York tourists to come to Mystic would not, in my mind at least, would not be subject to the bill. You know, whether the amount of money spent on public notices is part of the calculation of the total state advertising spend, that is an interesting question. You know, I guess at some level, we'll see what happens with the separate public notices bill. But I guess the way I would look at it is, I'm not sure we are looking to be tremendously prescriptive, but just to try to identify how to meet the objectives of the state from a communications perspective, and as well as supporting local journalism. I will say this: the communications of this. What's ironic to me is that a lot of state advertising awareness money and public notice money, for that matter, goes into newspapers for which you have to pay a subscription fee. So there are some people, many people, who by virtue of not being able to afford that newspaper, don't have access to that awareness advertising or the public notices, whereas the digitals and the hyperlocals don't charge. And so it's an equity issue. There's no, you are reaching, truly have the opportunity at least to reach everybody with state advertising, awareness advertising through news organizations that don't charge a fee to consume the news.
Thank you. Thank you for that answer. Thank you, Madam Chair.
Thank you, Representative Haddad.
I'm going to pick up where you just left off with just a question or two. But first, let me just say that, I mean, I think that this bill has a noble goal. As a consumer a voracious consumer of news reports, I find myself on my phone or my laptop more and more, and less with the printed newspaper. And I'm convinced that, my daughter will tell her kids what about a newspaper, and they'll be astonished that at 11 o'clock the night before, they printed it on paper and delivered it to your doorstep. The news cycle works much more quickly now, and we haven't quite figured out how to monetize, I guess, that consumption of news in the same way that we could with newspapers. And so we're struggling to sort of figure out how do we ensure that we have a vibrant journalism sector, and independent journalists are watching what's going on at the same time, meeting those new challenges. So the last comment you made was about the effectiveness, I think, a little bit about the effectiveness of state advertising campaigns. And it seems to me like what we're trying to do in this bill, if it were to pass, would essentially set up a set aside for certain kinds, really adding to our procurement policies around advertising, and awareness campaigns, and maybe even public notices, another goal, which is, can we support local journalism as we're trying to achieve the goals for increasing public awareness? And I just wanted to ask you to talk a little bit about the juxtaposition between those two. I imagine that you will tell me that's an additive process, and that one does not subtract from the other, but wanted to give you the opportunity to put that on the record.
Well, one thing I do want to be clear about, we're not, there's still a role for the for-profit out-of-state newspaper companies. 50% would still be unencumbered by this potential bill. So yes, journalism has historically been funded by advertising, and it doesn't work, right? The market, the capitalism of the model of funding journalism through advertising is clearly not working. What killed it essentially was Facebook and Google, the platforms, especially at the local level. So the platforms consume 75% of all local advertising dollars that are spent. That leaves 25% for the Meriden Record Journal or the Republican American of Waterbury or the Connecticut Mirror or whomever. And that's compared to just 25 years ago. So that's why you see, that's one of the reasons you see this evisceration of local media. I also think that we're looking at this as kind of a body of work of kind of the cumulative impact of all of the different types of smaller, nichier news organizations. So we have somewhat of a niche, right? Although I will say this, when we published, and we were the only news organization that published the story about essential worker COVID relief being made available, and the other newspapers picked up our content, but the response to that story was to crash DSS's website. So the idea that, we only reach kind of this highly educated, higher income policy wonk audience is not really true anymore. So we look at it as a body of work, not at what any one news organization's audience composition is or whatever. But yes, ultimately the state's marketing communications objectives are paramount. And that's what the advertising is ultimately designed for. In lieu of advertising in general, there are other movements in other parts of the country that recognize that local journalism is a public good. The advertising market for funding that is broken, and therefore there need to be other mechanisms for funding local journalism other than just this particular method.
Thank you for your response. I just observed that there are, a lot of our procurement and contracting laws, we have set asides to achieve other goals. And so this seems quite similar to that, right, in that respect. And there doesn't have to be, I don't think, a diminishment of the effectiveness of an advertising campaign because we're trying to achieve this goal as well. So I appreciate your comment on that, and that'll be my final question for you.
Thank you, Representative Blumenthal.
Thank you, Madam Chair, and nice to see you, Mr. Putterman. Thanks for being with us today, as well as your work with the Mirror. Generally, I will try to keep this brief because I'm at the end of a long line of questioners, but I guess I would just say that I agree with you. Local journalism is in crisis across the country and in Connecticut in particular, and it's not because of a lack of local journalists or people who want to be local journalists, and it's not because of a lack of local journalistic organizations. It's because the market is broken. And I think you undersold the case when you said local journalism is a public good. It is a public necessity. It brings necessary transparency to elements of government, but also life more generally in knitting communities together. So I think it's very important that we pursue what methods we can to advance the survivability and the flourishing of local journalistic organizations here in the state of Connecticut. And I guess I would just ask that as we move forward with this bill, there's a number of unanswered questions I think that have been discussed here today, I would ask that you and other organizations in the state continue to work with us to try to craft legislation in the best possible method.
All right, well, thank you for that invitation and we accept. Happy to help.
Thank you very much. And thank you, Madam Chair.
Thank you, Representative. Seeing no further questions or comments, thank you again for your time and your testimony today.
Thank you. Thank you, everybody.
Next, we will hear from Representative Devin Carney, who will be followed by Stephen King, who will be followed by Aaron Choquette. Welcome, Representative Carney. The floor is yours.
Hi, good afternoon, everyone. I know this is the moment you've all been waiting for regarding the Port Authority. It's great to see you, Representative Blumenthal, Senator Flexer, Representative Master Francesco, Senator Sampson, and all of the distinguished members of the GAE committee. I'm here to testify in support of HB 5692, an act concerning oversight of contracts of the Connecticut Port Authority. This bill subjects the CPA to permanent oversight of the State Contracting Standards Board and requires the CPA to be subject to the state's competitive bidding requirements. Currently, there are 16 quasi-public agencies listed in Connecticut general statutes. The initial motivation behind the establishment of many of these was to create an organization that carried out inherently governmental function, but that possessed the flexibility that accompanies a private organization. The state would still maintain oversight of the agencies through a board of directors made up of members appointed by public officials. The unfortunate reality is not all quasi-public agencies function as initially intended, including the CPA. The Connecticut Port Authority has been plagued with problems from the outset. Accusations of nepotism, government resources wasted on frivolous expenditures, infighting among board of directors, ballooning project costs, including at State Pier, which was supposed to be 93 million, is now 255 million, with 178 million of that paid for by taxpayers. And even an investigation of federal criminal authorities. Fortunately, the legislature recognized this back in 2021 with the passage of a bill that temporarily subjected the CPA to authority of the state contracting standards boards in the hope that it would get its act together by 2026. But this bill expands the cleanup of the CPA in two ways. First, it takes the important necessary step of subjecting the CPA to competitive bidding. And second, it eliminates the sunset provision created by the legislation passed back in June of 2021 and permanently subjects the CPA to oversight by the State Contracting Standards Board. The legislature only considered granting the CPA the autonomy over contracts that is possessed by other quasi-public agencies when it can demonstrate that it is no longer in need of an elevated level of state oversight. As of right now, it is not at that level. None of you are from Eastern Connecticut or Southeastern Connecticut rather, but if you were, you would see nearly what was almost a daily reporting of issues going on at the Port Authority. This is an agency that is in desperate need of repair. And for that reason, we urge the GAE committee to support this proposal. So thanks.
Thank you, Representative. Are there questions from the committee? Oh, Representative Labriola, you have the floor.
Thank you, Mr. Chairman. I guess I would just ask you, thank you, Devin, for testifying. I know you're very familiar with this issue. It seems like a good bill. I plan on supporting it. What issues do you think that it would directly address?
I think overall transparency for one. There has been significant transparency issues at the Port Authority, but especially though this competitive bidding process, there was an organization that received a finder's fee essentially of about, I think it was about $700,000. They ended up actually getting about $550,000 from to an organization that a board member is a part of, and that board member was quit the Port Authority, I think 3 months prior to receiving this exorbitant finder's fee. So things like that really are done without the public good in mind. And really just people want to see an open bidding process for anything related to the state pier. There's a lot of concern that there hasn't been. And the Port Authority in general has seen a lot of issues. There was an executive director that resigned in disgrace. There was the second executive director who resigned. I mean, he was doing an okay job. I'm not entirely sure why he resigned. And now there's an interim executive director. So there are things that need to be improved there, and questions that need to be answered. And I think the best way to do that for sure is to have this additional oversight.
Thank you, Representative. Any further questions from the committee? Representative Hoxa.
Thank you, Mr. Chair. Good afternoon, Representative. I just had to do a double take there to make sure that we were in the afternoon. You had mentioned that there's about 16 other quasi-governmental agencies. Can you just name sort of a few of them and kind of just describe to, maybe people in the audience or, anybody listening, how members to these boards are appointed? Is it from the governor? Is there, some sort of, group that handles this, a commission of some kind? Can you just, elaborate a little bit on that?
Sure. I mean, one that's similar to this is the Airport Authority. So that authority oversees Bradley Airport and other public airports. The lottery is another quasi-public agency. And these, the members of the board of directors are nominated by either the governor, Speaker of the House, Majority Leader, Minority Leader, and then they go through the executive nominations process, and then eventually to legislative approval. So that's how they are put on there.
Thank you, Representative. And the reason why I asked you to clarify on that is because, like you said, you live in southeastern Connecticut, but there could be some other people that live in other parts of the state that aren't familiar with the role of the Port Authority. But giving those examples that you did kind of gives people a better understanding of where these organizations exist. So I thank you for that. Back to you, Mr. Chair. That's all.
Thank you, Representative. Further questions from the committee? Seeing none, thank you for being with us today. Good to see you. Next up is Stephen King, followed by Aaron Jaquette, followed by Lawrence Fox.
Good afternoon, Senator Flexer, Representatives Blumenthal, Representatives Mastro Francisco, and Senator Sampson, and elected members of the Government Administration and Elections Committee. My name is Stephen. I am a voter from New Haven, and on behalf of your college Democrats and Common Cause in Connecticut, it is an honor to testify in support of Senate Bill 1246, an act concerning state voting rights and recognition of John R. Lewis. One of my earliest memories involves me standing outside a church with my mom on a rainy day. Couldn't have been fun for her. She was waiting in line for an hour. It was just absolutely pouring. There she was, umbrella in one hand, my hand in the other. Nevertheless, she showed up and she brought me to vote because she wanted me to recognize not only how important it was to make our voices heard, but all of the sacrifices people who came before me made so that a Black young man like me could look forward to the day I cast my first ballot. MLK referred to voting as a crucial right, pushing heavily for a voting rights bill. And once it was passed, then President Lyndon B. Johnson referred to it as his crowning achievement. For good reason. In the immediate years following this bill, registration of Black voters skyrocketed. So to the point where it went from 44% in 1964 to 66% in 1970. Unfortunately, in recent years, the Supreme Court has gutted numerous provisions of this bill, leading to an increase in voting laws, which seem to restrict people's rights in states like North Carolina, Georgia, and Texas. That's why I'm testifying in support of this bill. Mr. Rodriguez already pointed out how Section 3 of it can allow for community members and local organizations to make more informed decisions and spread the word about voting. And we've already heard how pre-clearances are a crucial step in making sure that voting discrepancies aren't caused by well-intentioned laws. I also, however, want to bring attention to Section 4 of the bill, which expands the existing language assistance services so that any municipality with over 2% of voters who struggle with English are eligible for this help. This is incredibly important, especially in a state as diverse as Connecticut, where you can hear languages ranging from Spanish to Punjabi or walking down a street in Fairhaven. For all of these reasons, to ensure that everybody from a young Black man in Bridgeport to a suburban mom in Fairfield to an immigrant now living in New Haven can feel confident in their right to vote will not be abridged, I urge you to pass Senate Bill 1226. Thank you.
Thank you, Mr. King. Is there are there any questions from the committee? Seeing none, thank you for being with us today and for contributing your testimony. Next up is Aaron Choquette, followed by Lawrence Fox, followed by Colleen Murphy.
Good afternoon, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and Senator Flexa in absentia, and distinguished members of the committee. My name is Aaron Choquette, and I am the Chief Executive Officer of the Connecticut Paid Leave Authority. Thank you for the opportunity to offer testimony opposing Senate Bill 1223, an act concerning the State Contracting Standards Board. Senate Bill 1223 significantly undermines the ability of quasi-public agencies to fulfill their legislatively established missions. Each time the General Assembly creates a quasi, it makes the determination that there is both a public need that must be fulfilled and that such mission can best be achieved through the operations of a quasi-public. Quasi-public agencies were created to respond to problems and opportunities more nimbly than traditional state agencies. By making quasi-publics a contracting agency under Title 4E, however, Senate Bill 1223 eviscerates the flexibility and responsiveness that quasi-public agencies were created to have. Under Title 4E, the State Contracting Standards Board has extraordinary authority over contracting agencies, including the right to terminate any state contract, the right to restrict or terminate the authority of a contracting agency from entering into contracts, and the ability to countermand a board of directors' decision as to whether even to contract out for work. By divorcing the authority to make these decisions from the responsibility for the outcome of these decisions, Senate Bill 1223 creates an untenable conflict. As a quasi-public agency, the Connecticut Paid Leave Authority is led by a board of directors, many of whom are appointed by the legislature. These board members owe a fiduciary duty to the authority and are charged with balancing many factors, including budgetary constraints, the legislative mandate, the needs of our constituents and the workers of Connecticut when making procurement, policy, and contracting decisions. The Standards Board, on the other hand, owes no such fiduciary duty. It can't have a fiduciary duty to 16 other entities and has no responsibility for ensuring that the authority is able to fulfill the mission for which the legislature created us. Finally, Senate Bill 1223 is unnecessary to achieve the goals of transparency and oversight. We are already required to comply with FOIA, the Code of Ethics, and the Comptroller's open checkbook requirements. We are required to provide quarterly and annual reports to the legislature, and we are subject to audit by both the auditors of public accounts as well as outside auditors. Our board meetings are held in public. Our major contracting decisions are made by our board in public. This is not what happens in regular traditional state agencies. Sunshine is let in. We also have specific language in our statute regarding our contracting requirements and the standards that we are supposed to use for our request for proposal. I can tell you that if this legislation had been in place when we were charged with creating the paid leave program from scratch in just a couple of years, during a pandemic, as it turned out, thousands of Connecticut residents would still be without access to paid leave benefits. For these reasons, I oppose Senate Bill 1223, and I urge the committee to do the same. Thank you. I'd be happy to take any questions.
Thank you very much. Are there questions from the committee? Seeing none, thank you for being with us today. Next up is Lawrence Fox, followed by Colleen Murphy, followed by Jess Acanino.
Good afternoon, Co-Chairman Blumenthal, Vice Chairs, they're not here, Ranking Member Master Francesco, and elected members of the committee. My name's Lawrence Fox. I'm the chair of the Contracting Standards Board. I have alongside me, just because I want the legislators to get to know them. Both Gregory Daniels, who is the new executive director of the Contracting Standards Board appointed by Governor Lamont, and he comes with fabulous credentials and commitment. And then also the recently hired Chief Procurement Officer, Jonathan Longman, who is also comes with great credentials. Because of the work of the legislature, we are now fully staffed for the first time in the board's history. We have additional members of the board's staff as a staff attorney, an accounts examiner, a research analyst who's also here today, and a trainer, which is the appropriation that we asked for. And it is going to help. This team is going to become a catalyst, I believe, for the state to qualitatively improve the performance of state agencies in procurement and contracting. We're here today to support 3 bills, 5692, which is removing the sunset, which we've had some testimony on already. Bill 6903, which speaks to 3 issues that actually, thanks to local reporting, frankly, surfaced. I know we had testimony about local reporting having to do with success fees or finder's fees, and also having to do with construction managers bidding on work. I'll talk about that in a minute. And the other bill we're here to speak about is Bill 1223, which is a big bill. It has a lot in it, and we've heard some testimony today from some of the quasi-publics about pieces of that bill. We've submitted written testimony, and I encourage the committee members to look at it. I'm just going to talk about 2 or 3 things, and then we'll happily take any questions on any of these 3 bills. The first, I think there's a lot of testimony already that the idea of sunsetting the oversight of the board with the Port Authority is premature, if it should ever happen. There's currently ongoing investigations that we're doing, ongoing investigations that the Attorney General is doing, ongoing investigations that the federal government is doing with respect to the procurement that's happened in the past down there. And some of it, unfortunately, some of those issues continue into the present. The issue of the issue of closing the gaps. There are 2 issues that have surfaced and that 6903 deals with. This whole success fee issue that happened down, we're only aware of it happening once at the Port Authority, but basically it's like a finder's fee, and we just don't see the public benefit. When we contract with someone to do work for us, we ought to set the fee, and the success fee that was done down there, the AG is still looking into it, but I believe the current statute is ambiguous, and the purpose of specifically changing the statute is to say, not in Connecticut. We don't need this. If we hire someone to do the work, let's pay them for the work they do. And if we want them to do the work, that's what we're paying them. And the idea of a construction
Mr. Croft,
manager.
I'm sorry to interrupt, but your time has elapsed. If you could summarize the remainder of your testimony.
Okay.
Please. And I'm sure you'll have questions after that.
Yes, I hope I'll get questions on the quasi-publics. I'm going to summarize by saying that a lot of the testimony that I heard today about the quasi-publics, frankly, is not accurate. And hopefully I'll get some questions where we can get into the details. And I'd also love to entertain a question about another part of that bill, which makes it a legislative requirement for any agencies that putting something out to bid to inform potential bidders, potential contractors, vendors of their appeal rights. We're reading, all of us are reading every day about bidders who weren't the low bid that didn't get it. People didn't know their contracting agencies used to put out those appeal
All right,
rights.
now your time has definitely elapsed.
All right.
Are there questions from the committee? Representative Master Francesco.
Thank you, Mr. Chairman. Well, you certainly piqued my interest. If you can please elaborate on the quasi agencies.
Yeah, I mean,
On
look,
on the testimony that we've heard today.
let me first say, all of the quasi agencies currently in their legislation are required to have the Board of Auditors audit their books. The auditors, we speak with the auditors, we share space with them, and we're going to do more work with them now that we have more staff to do some things. They don't audit their procurement policies and practices. That's not what they're doing. Not routinely. Part of the purpose of covering these agencies, it's not a punishment. It's good practice that we take a look at how are they doing procurement, because the state spends so much money there in these agencies.
Thank you. So if you can just kind of go through with me, what is your process for checking procurement?
Well, and we're going to up, now that we have staff and we're funded, we're going to make it a more robust process. It's to look at what are the policies that are in place? Are agencies doing competitive bidding? Are agencies, is there a level playing field for bidders when they're bidding on projects? These are examples. Has their procurement person in that agency been trained? We're going to implement, hopefully with the resources that we have now, a certification program. I heard twice from the two agencies that reported, they have some belief that if they come under us, under the board, that they will have to get pre-approval before they do any of their procurement. That's not how we work. That's not how we work. We don't, we look at their policies to make sure they have good policies in place. But it's not like a properties review board that you actually have to approve the transaction. They'll do their, we won't hold their procurement up.
Do you, through you, Madam Chair, do you have to approve certain contracts over a certain dollar amount?
No.
On any of the quasi agencies that you will oversee,
None of the quasi, no, now none of the contracting agencies. That's not how the agency works. It doesn't, we don't, our agency, it's not our lane to decide whether a project's a good idea or a bad idea. It's our lane to make sure that if the governing body of that agency wants to go forward with a project, that in fact they use transparent, competitive procurement policies as they implement the project. But we don't have to pre-approve any project.
Okay, thank you. And just one more question through you, Madam Chair. So if they're not using the proper procurement process, have you seen that happen before, and what were your solutions to it?
Well, we've seen it a lot. No, I don't, we've seen it in some of the quasi-public agencies. And we didn't have authority other than to point it out and to work with them. But one of the advantages of the fact that our board is in the executive branch, as opposed to being in the legislative branch, is that if in fact a bidder says, wait a minute, this RFP wasn't a level playing field, they can come to us in real time and we can look into that RFP and say, do it over again. So if in fact there's uncompetitive procurement going on, we don't have to read about it 3 years later and say, gee, I wish we could have done something about it. But they need, the vendors need to know that appeal right exists. Up until a few years ago, it was routinely put out by the contracting agencies. And then for reasons I could only speculate about, it was erased. That's why so that a vendor doesn't know that they have appeal. They have to appeal within 14 days of when they knew or should have known that they have a problem. It could be on an RFP. It could be on the contract was given to someone who wasn't the lowest bidder and they feel they were qualified. It could be on a range of those kinds of things. Part of 1223 remedies that by putting it in statute, making it an obligation of a contracting agency to inform any potential bidder, vendor at the time of RFP, at the time of award of a contract, of their appeal rights.
So currently the statute does not say that you have that they don't have to give approval at this point, correct? The statute does not, but in theory, you can if you want to. Is that correct?
No, no quasi-public, no contracting agency now, or no quasi-public agency when they do a procurement has to submit it to us before they put it out to bid. 0 times. That's not the way the board works. It's frustrating for me to hear that coming from. Now, by the way, I thought the executive director from the lottery made an interesting point that we should follow. If in fact consumer protection is already monitoring their procurement, there's no reason to monitor it twice. But we'd have to learn more. Are they looking at their procurement policies and practices? But this board does not pre-approve procurement. And now an agency could come to us and say, we're not going to do a competitive bid, and we just want to know what you think about that. They could ask us that question.
Okay. Thank you. Thank you for the clarification. I have no further questions. Thank you, Madam Chair.
Thank you, Representative. Are there other questions or comments from members of the committee? Well, I have a few questions, and before I ask my questions, I do just want to express my gratitude for the wonderful people at CTN. Just so you know, despite what you said when you first started, because of CTN, we can hear everything, even if we're not in the room. It's only about 30 seconds behind. And so I was able, and I'm sure all the other members of the committee were able to hear your testimony, even if we weren't physically in the room. And so you were talking briefly about appeal rights, and you were about to expand on that. Can you talk about that a little bit more?
Yes. 4E36, which has been in the statute from its inception, gives the board, the Contracting Standards Board, the ability, if we think that an RFP process has been flawed, if there's a vendor who feels that they were improperly considered in the process, they have 14 days from the time they knew or should have known that there was a problem to appeal to the board, and we will hear that case very quickly. We have to render a decision very quickly. And in some cases, we can say, redo the RFP. In extraordinary cases, we could say, undo that contract. If in our investigation, we thought there was something criminal that occurred, we would turn it over to either the state prosecutor or the attorney general if it's civil or criminal. We don't do that. But the law has teeth in it. But vendors, a lot of these are small business people. They don't necessarily know what their appeal rights. It used to be that OPM and DAS informed bidders of their appeal rights the way they inform bidders of a lot of different things. In recent years, it got erased from what they send out. We're all reading about it every day in the newspapers. Gee, I didn't have the low bid. I had the low bid, and then it was rebid, and then I wasn't the low bid. I mean, there's a lot of things that are questionable. It's a no cost, easy fix for us to build a lot more honesty into the procurement system. One more thing, I just want to say this. And most of the procurement that happens in the state, I'm sure is good. But frankly, we do not have a culture of competitive bidding in our state. It's not good. We should be good. I've lived in the state for over 50 years. I love Connecticut. We should have open, honest, transparent procurement. And I am sorry, I feel badly that the quasi-publics think we're going to destroy their mission. Not so. Like the auditors, like I have a lock on my door at night. It's not because I think everyone's a thief, but we have an obligation, it seems to me, in our state to make sure that we have a process to make sure that we're putting all, and we're going to do more procurement in the future. It's going to grow. We need to have a robust system to protect the public interest in that. And it shouldn't it's not going to slow down their ability to be nimble. Nimble was never about doing crappy procurement.
Thank you. Thank you for that answer. You talked a little bit at the beginning of your testimony about the new status of the Contracting Standards Board and the fact that you're finally almost at the point where you're fully staffed.
We are
Can
fully
you
staffed.
just walk us through what the difference has been with regard to being fully staffed versus how you've operated during the other parts of your tenure, with the board?
Oh yeah, I am hopeful that it's going to be night and day. When we had no staff, except for an executive director, David Gay, who did an incredible job, and we had board members step up, basically we had the ability to respond to things that we read about in the newspaper when the local press covered stuff. Or we would have the ability to respond to a complaint that we received from the public. But when you go back and look at the legislation that was passed by the legislature years ago, it really intended for this board with a staff to proactively build a very robust, clear, transparent procurement system. And so what we're in, one of the highest priorities of the board right now, and it's going to be under John and Greg's leadership, is we're going to put into place a certification system and training system for all of the agency's procurement agents, the folks in the agencies who to be trained and to understand best practices in procurement. And we need to be able to become proactive in providing technical assistance. In the audits that we did, what we found when you say, well, why were over 70% of the personal service agreements and POS agreements, I'm forgetting the acronym, over together representing $5 billion of contracting that we use in the state. Less than 30% of those things, though those kinds of contracts were done through competitive bidding. Now we had the pandemic, and we agree, and the law states clearly that in emergencies, competitive bidding isn't the most important thing. Health and safety is. But we're out of the pandemic now. But even in the last few years, have we made, if the question is asked, have we made progress on competitive bidding? The answer is no. We're not getting better yet. We need to get better. We can get better. We need to have trained procurement officers in each agency that understand how to do it. And we can help them. And we're going to have a staff that can help them.
Thank you. Thank you for that. And in your comments earlier, you also talked about how Connecticut, and I think you were just alluding to this in your answer, that we don't have this robust system of competitive bidding here in Connecticut. So can you talk about how both the fact that you're fully staffed now and the potential for this legislation going into effect could make that a reality for the residents and the taxpayers of Connecticut?
Yeah, I mean, first of all, we'll be able to do outreach. Two of the things that have always been in our legislation, it's another, but we never had the ability to do it, are to build a vendor advisory committee, which is appointed by a combination of the governor and the legislative leadership from both parties. Members of that advisory committee, it's chaired by the chief procurement officer. And that advisory committee gets together with vendors and from around the state that have been selected by you and says, how can we make the system better? What do we need to do to make it better, make it easier to use? That's one committee. There's a second advisory committee, which is an interagency advisory committee, which is also chaired by the chief procurement officer, which has on it major contracting agencies, OPM, DAS, transportation, will include quasi-publics as well under the legislation that you're proposing. That committee will meet quarterly and say, what do we need to do as a state to do a better job in procurement? Third, we're going to put into place a training program for all agency procurement folks so that they're not only trained, but certified. We're going to find some national certifying programs so that, in fact, we can raise our game in terms of what we do. We haven't invested. Now, having said that, there are a lot of agencies that do a pretty good job with procurement. But a lot of them that on the audits that we did, they said, we don't have time. A lot of the reasons when OPM has to approve waivers, a lot of the reasons waivers were approved, they said, well, we just had to get it done. Well, that's not an emergency. This legislature two or 3 years ago put into place a piece of legislation which we had recommended, requiring that OPM post any waivers and issue monthly reports on what 3 years agencies had to talk about what is the contracting you're going to need to do 3 years in advance. Give us a look. It went to OPM. Tell us where you think you'll competitively bid. Tell us where you think you won't be able to competitively bid. Recently, for reasons we don't understand yet, OPM stopped posting. That's supposed to be posted. They've stopped posting their waivers. When I say there isn't a culture of competitive bidding, why aren't we really promoting it as and I'm using competitive bidding as a euphemism. Sometimes there are different ways of competitive bidding. We have a lot of work today to do to build it into the DNA of our state. And there's no reason, frankly, that we can't. So both proactively and in terms of enforcement, where we need to enforce things, but none of these things, none are about pre-approving an agency's procurement stuff. We would need a staff of 100 if every agency that wanted to procure something had to come to us and get approval first. We would be opposed to that legislation.
Thank you for that. Earlier today, the quasi-publics agencies that testified, and there may be more coming. And again, you've been talking about this in the conversation you've already been having this afternoon, but they seem to have a misunderstanding. And I think you're trying to address that with your testimony today of the role of the Contracting Standards Board. So can you talk about what trainings would be offered by the board to any new agencies that were a part or were under the oversight of the board?
Well, with permission, what I would do, if you feel okay doing it, I'd ask our chief procurement officer to address that. Is that okay?
Absolutely. Just state your name for the record, please. Welcome.
Hi, good morning. My name is Jonathan Longman. I'm the Chief Procurement Officer. So as of right now, we're still working multiple channels on trying to develop what that program looks like. We've reached out to internally, what do the different agencies have in place already? There are some good trainings that are out there, but they seem to kind of be scattered around. And I think a lot of this process is going to be forcing people to make sure that they're actually reviewing all those trainings, right? The second part of it is actually to work with accredited bodies that are out there already, like NASPO or one of the organizations that's already out there that can help us build a good foundational layer for all procurement professionals that work in the state. So build that foundation and understand, the basics of procurement. And then the second part of it would actually be the teaching of the specific things that are required to actually do the work in Connecticut, which wouldn't be something that you would be able to bring in from the outside. There are aspects of contracting, for instance, working within Corp, the accounting system, how you would enter all those things into the fields. Those are things that state of Connecticut would have to develop ourselves. So in a combination of working with an outside accreditation body and then building some pieces ourselves, that would be the certification in its entirety, right? And then the thought is over the next few years to also align that with responsibility. So there's different layers of responsibility in the procurement, right? So if a person was just working on some simple acquisitions, they might not need the same level of training that, say, a person would need if they're managing a multi-million-dollar construction project, right? So over the next few years, we would then get different levels in that certification. There would be, we'll say, beginner, intermediate, and advanced, and that would align to their responsibilities. And we would work through the advisory councils that Larry mentioned on understanding where that would be applicable within the different agencies across the state.
Thank you.
You're welcome.
Thank you for that answer. I guess my last question will start with more of a statement. I want to give credit to the quasi-public agencies that come here and that work with the committee and state their concerns, even though perhaps you and I, Mr. Fox, might not agree with them. I want to give them credit for coming here and having conversation. But what I want to ask you about is, this is legislation that in the past has received broad bipartisan support. It received unanimous support, very similar bill last year in the state Senate. And we've seen that in the Senate and the House, when given the opportunity, my colleagues in the legislature, they want to vote for a stronger authority for the Contracting Standards Board. But what happens, despite robust dialogue about this in the media and robust dialogue here in the committee and on the Senate floor, some behind the scenes misinformation, I would say, torpedoes the bill, and a few key stakeholders are able to kill this legislation, and that's why it doesn't ultimately pass. And again, I want to give credit to the people that are coming here today and having a real dialogue to talk about their concerns. But can you address some of the concerns we've heard perhaps more in private about this legislation and how they're wrong? I mean, I'll just say, again, I'm pontificating a little bit more than I usually like to in this setting, but it's been very frustrating to just see this strong opposition that is often quiet, unlike the people who've been here today, to sunlight. It is one of the most frustrating experiences I've had in the time I've been privileged to be a legislator.
Yeah, I think there are some regulatory bodies in Connecticut where in fact they actually require approval for you to move forward beyond them. And I think our role sometimes gets confused with that or concerns about that. There are parts of our mission on privatization where in fact there are some pieces of approval on that, but frankly, it's a red herring for almost all of the quasi-publics because most of them have very few state employees. They're real, the work, and I'd love to be able to talk with them about that. We don't want to hold them up. And if there are things in the bill that, as they're currently written, that would actually hold them up, we should figure that out and fix it. But the people in the state deserve, look, the issues that the representative talked about at the CPA are horrible. And there have been other issues that have come up at a couple of other agencies, which sunlight is required. And if I can, it's sort of in response to this. So first of all, Senator, we would love to deal with, to meet with the legislature and the quasis and try to work through those issues. We need sunlight here. We need sunlight here, but we shouldn't become an undue. If the lottery already has consumer protection doing what we would do, let's not do it twice. I mean, if that's the case. The other thing that's in this legislation, which is very important, I understand, look, I happen to be a Democrat. This role is a nonpartisan role. And I understand that while we're in the executive branch, we have an oversight responsibility that's going to create tension in the executive branch. That's manageable. But it also means that the part of 1223 that gives us some insulation from unilateral gubernatorial reductions to the board in terms of our appropriation is really a critical piece. You need us to come to you candidly, frankly, about issues. And they may be issues about things that OPM is doing that we think, no, that's not right. That needs to change. And so two pieces of this bill are, one of them says that when the executive director, who's appointed by the governor, brings a recommended appropriation to OPM for what should be in our budget, OPM needs to transmit that to the legislature. You have to be able to see what the board was saying. Obviously, there's a negotiations between the legislative and executive branch over our appropriation. But then notwithstanding the governor's ability to line item out after there's a budget under some circumstances, there's a piece here that says, no, when it comes to this appropriation, it has to be done together with the legislature. I think that's prudent. I think that's prudent for the taxpayers. I think it's prudent for us to be in the executive branch so that we have remedial authority. But I think it's prudent to insulate the board against the tension shouldn't find expression in an appropriation reduction.
Thank you. Thank you very much for your time and your testimony today.
Thank you.
Next, we will hear from Colleen Murphy, who will be followed by Jess Zaccanino, followed by Tom Swan. Welcome, Colleen. The floor is yours.
Good afternoon, Senator Flexer, Senator Sampson, Representative Mastro Francesco, and members of the GAE committee. I'm Colleen Murphy, Executive Director and General Counsel for the FOI Commission. I'm testifying very briefly on 5 bills before you today, hopefully in less than 3 minutes. The first 2 are somewhat familiar. They're address exemption bills. You've had a number of them come before this committee. The commission is opposed to raise bill 1220. I would point out that this bill is very similar to raise bill 1157, which was heard already by this committee on March 6th. And for the same reasons we opposed that bill, we opposed 1220. Then we have 6912, which is an act concerning non-disclosure of information regarding election workers. The FOIC is sensitive to the concerns regarding election workers, but as with similar bills, we must object to it, as this will not provide much protection. Moreover, it appears that this bill is broader than the other address bills, making it impractical and difficult to implement. The next bill is about body-worn and dashboard cameras, raised bill 1222. This bill is a work in progress. We have worked closely with the Connecticut Police Chiefs Association, who I see and have come out here today. to my right, and then we have worked to find a fair, balanced, and reasonable approach to charging fees when a police department makes redactions to body and dash cam videos that are authorized and prescribed by law. The bill's proponents have incorporated many of the commission's recommendations to narrow the scope of such fees, but the commission still has some concerns around when the fee provisions will kick in, the need to set a clear and workable cap to such fees, and also the addition of exemptions to disclosure, which were not part of our original discussion or negotiations. The next bill is one that would give the FOI Commission sharper teeth, raised Bill 1221. And we support raising the amount of fines the commission can impose. What the amount should be, we leave to the judgment of the legislature. It has been at $1,000 per violation for many, many years now. Likewise, we support providing the commission with additional tools to deal with recalcitrant public agencies, but some of the language needs clarification. We support requiring agencies to keep a log of open FOI requests. However, we recommend the exclusion of routine requests and making the requirement prospective. And the last bill is raised Bill 6906, which regards conduct at remote meetings. The FOIC supports requiring municipal members to appear on video while speaking or voting on matters before the agency where they are participating remotely. The language too will need some revision, however, since under current law, agency members are permitted to participate completely by telephone, non-video platforms, if you will. So there will need to be a slight revision there. And the FOIC would also welcome a comprehensive review of the remote meeting provisions in general to ensure the greatest transparency and accountability in this new realm that we all work in today. I thank you for your consideration. I'm happy to answer any questions you may have.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Representative Mastro Francesco.
Thank you, Madam Chair. Thank you, Colleen, for your testimony today. I appreciate you coming in. I know you've been waiting a while. And House Bill 6912.
Yes.
And it was about the election workers. Can you elaborate a little bit more on that? Is that hard to implement?
I believe it would, and perhaps would be. Perhaps the other local officials could speak to that, but I think this proposal is broader than the other address exemptions you have. It would require a person to go to basically any public agency they could possibly think of that might have their address and request confidentiality. And then on the other side, the agency, who's the keeper of whatever records that may be under their jurisdiction, upon an FOI request would have to scour every single record that they're about to release and try to ascertain whether there's an address of anyone in this protected class in there. The other address exemptions are a little more narrow in the sense that there's a similar approach to requesting confidentiality of your address, but you're really just looking at lists that already exist, or if somebody is asking specifically for a record that contains the name and address of a person whose address is exempted. So it's broader, I think, and we oppose the narrower ones too, but I think this one would be difficult to implement.
Thank you. And through you, Madam Chair, have you seen a lot of abuse with this? People requesting? I remember we had testimony last time. Basically just like frivolous freedom of information, harassment type of requests. Have you seen any of that?
We've seen some of those, but not relative to this.
Okay.
I'm really unaware of many instances at all where addresses are protected or requested, I'm sorry. And very often when they are, when you speak directly to the requester is typically interested in whatever other data exists in the record, not the address of the person. So the answer to the address part is no, we have not seen abuse or instances of harm being caused because of it. And we also just simply feel that people ought to know what they're getting when legislation is passed. I just fear that people will believe that they've been protected and that not much protection is afforded here.
Thank you. And then through you, Madam Chair, and I can't remember the bill number, the bill where the fine goes from 1,000 to 10,000. Is that something that Freedom of Information Commission supports?
The commission supports raising that fine. As I said, we would leave it to you to decide how much it should be raised. I think we've been seeing a number of cases lately where the commission wanted to look at the existing fines and the structure by which they dispense of fines. So they're not specific to that, but I think the commission is very open to raising that number. I know it would be on par with the ethics agency, for example.
Thank you. And through you, Madam Chair, the House Bill, Senate Bill 1222, it talks about the body and dash cams. I had a couple questions on that one. Would there be a fee charged for everything if they were redacting anything on that dash cam? And
Right.
is there, and how do you determine what that is and how long? So is it free for the first hour, and how would it be, how would it go? How would it be charged going forward?
Right. And thank you for the question. You've hit upon an area that's been a big subject of our negotiation. How much of the time should be free? I think in the proposal you have before you, although we have negotiated after the language you have before you, but I think in the proposal, it's 2 hours are free. And that for involved individuals, 4 hours are free. We had advocated for something a little different, 4 hours free, and if you were involved, free in completely. But there has been a cap built in, and we're interested to see how that cap would work, and we want to have some dialogue around that as well.
Thank you. And through you, Madam Chair, so you mentioned something about an involved person. What is your interpretation of that? Can you expand on that a little bit?
Right. I think we need some clarity around that as well. We were asking questions or going back and forth about, is an involved person in the video somebody who happens to be in the background? Is an involved person somebody who called in a 911 call? So we think either now or if this bill were to move forward, there needs to be some clarification, because if you're involved, that means you get a little more free redaction time.
Gotcha. Okay. And are you in contact with the other agencies on these particular bills to try to iron out, or in contact with the chairs to try to iron out the kinks on some of the language? Have you had the opportunity to?
We have not
reach
been
out?
in discussion with the chairs, no, but we have been in discussion with the Connecticut Police Chiefs Association.
Right. Okay. Thank you very much. I appreciate your testimony. Thank you, Madam Chair.
Thank you, Representative. Seeing no further questions or comments, thank you again for your time and your
Thank
testimony
you.
today. Next, we will hear from Jess Zaccanino, followed by Tom Swan, followed by Annabelle Figueroa. Welcome, Jess. The floor is yours.
Senator Flexer, Ranking Members Sampson and Mastro Francesco, and distinguished members of the Government Administration and Elections Committee. My name is Jess Zaccanino, and I'm the Policy Counsel for the American Civil Liberties Union of Connecticut. I'm here to testify in support of Senate Bill 1226, also known as the CTVRA. Voting is the foundation of democracy, a right through which all other rights are preserved. The gutting of the Voting Rights Act has initiated a rollback of voting rights, but it would be a mistake to think that these problems only exist outside of Connecticut. From its early days, Connecticut has been the least expansive state for voting rights in New England, amending the state constitution to limit the franchise to white people in 1818, while neighboring states allowed Black men to vote. Connecticut was also one of only 12 states using a literacy test well into the 1950s. Literacy tests like Connecticut's functioned as racially discriminatory means of exclusion because they interacted with language barriers and socioeconomic disparities, including unequal access to education. Connecticut only began allowing Puerto Rican voters to cast their ballots without passing a literacy test in August of 1965, and only because the state had no choice after the enactment of the federal VRA, which included a provision drafted specifically to prevent northern states' use of literacy tests to disenfranchise Puerto Rican voters. And unequal barriers of access in Connecticut still exist. Limitations on in-person election day voting disproportionately impact voters of color. Election management practices repeated year after year result in long lines in urban areas where Connecticut's voters of color are most concentrated. Long lines have plagued the same cities and precincts repeatedly, and these are always the areas with the greatest number of voters of color. Because of interlocking systems of oppression, voters who are less likely to be able to get to the polls on election day, people with little job flexibility, people lacking transportation, disabled people, and voters who lack language access are all disproportionately likely to be voters of color. Connecticut's history as one of the most regressive voting rights states in New England demonstrates the need for continued skepticism that any belief that voting rights are uniquely strong in this state. Connecticut is ranked in the bottom of all states, at times as low as the fourth worst for voting options. The CTVRA has the potential to bring these failings to an end forever. The ACLU of Connecticut strongly supports Senate Bill 1226 and urges this committee to do the same. Thank you.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Senator Sampson.
Thank you very much, Madam Chairman. Thank you for being here today, Jessica. I appreciate the history lesson, and certainly there are definitely things in our past as a nation and as a state that are gladly corrected, as of 2023. And I was very curious when you started to mention things that are still in place that might be barriers to voting for different segments of the population. And certainly long lines is something that I am very sympathetic to. I've offered amendments in this committee and on the floor of the Senate to change policy so that goes away. Is there anything else you can think of specifically as a policy? And I know that there are things that we're working on today. We've got an early voting debate going on. We've got expansion of absentee voting. So there are constantly changes going on. But anything that you can think of that might be a simple item to address in our voting laws that is a current problem that we should address through you, Madam Chairman?
I'm sorry, can you clarify in terms of, do you mean in addition to long lines or?
Yes, ma'am. I'm
Sorry.
just looking for examples of things that you feel are policies that we have in the state that create discrimination or the inability for certain segments of the population to participate. Because I'd like to know what those are so that we can address them head on. That's just my first question. I'm going to ask you a little bit about the bill too, but I wanted to start with that at least. Through you, Madam Chairman.
As you mentioned, we are currently still one of 4 states without early voting. I know, this legislature is working on a plan to address that. But even though we are in the process of setting up early voting, the effects of not having early voting and accessible vote by mail reverberates through generations, right? And then we also, as you mentioned, need to address a lack of no excuse absentee voting because it is really difficult for folks specifically that are working people, more often end up being lower income voters of color, struggle to get to the polls. And then when they do, many precincts like certain ones in New Haven and Bridgeport and others that are cited in my written testimony, experience long lines. So even if you're able to get a little bit of time off to vote, you might be faced with a line that is much longer, than you can take that time off for.
Yeah, thank you very much for that answer. So certainly early voting, mail-in voting, those are topics that we've been debating here for a number of years, and it looks like they're going to come to fruition. Mail-in voting, it was certainly we had significant participation in recent years. I think Connecticut's voter participation is actually pretty substantial, even if there are impediments to it. And if I could point to one thing, I would say that certainly in urban environments, the access to the polls is the number one thing beyond any of the other things we could even talk about. I think the failure to have enough polling locations that are conveniently located and to prevent the long lines is the number one thing that we could probably do to encourage participation. Because I know how somebody might feel getting in line, to vote and stand there for. I hate lines. I don't do traffic. I won't even go visit people at certain times of the day. I'm like, no, can I come see you at 7 instead of 4? Because I really don't want to be doing that. So as far as the bill goes, we've had this bill before us in recent years, and, I appreciate the intent of this bill. I became a Republican because of Abraham Lincoln. That is to me the driving force behind my political roots. And for me, the key ingredient was always that we were trying to live up to the promise of the founding of this country, that all men are created equal and that we have equal rights and so forth. And it's a work in progress, obviously. And Lincoln, got us a giant step forward. And so have a lot of other people, Martin Luther King Jr. Over the years, we've done better and better. It's certainly the various civil rights acts that have existed through time certainly have advanced us as well. The bill I'm confused by though, because it seems to, I don't understand it, I guess, is the biggest problem. Because it seems to say that when a judge is going to determine whether or not there is a racial disparity occurring in an election, they can use all of this criteria, but the one thing they cannot use is whether or not there was any indication of racism. The only thing that they can actually use is the results. And I was listening earlier. I apologize. I was at the dentist's, and so I was zooming in for part of the day listening. But I heard the exchange with my colleague, Representative Master Francesco, with another person on this bill, and I just, the conversation really interested me, because it seems to me it's like, if a district elects someone that someone doesn't think they should have elected based on their race, that's a cause of action, even if that person was duly elected. Maybe you can help me understand what the goal of this bill is, so I can really get my head around it.
Yes. So
Thank you,
I would
Madam Chairman.
definitely, sorry. I would definitely recommend that you go back and listen to the exchange with Stephen Lance and Rep Master Francesco, because I think his answers were really on point. But sorry, let me gather my thoughts. So really this bill is more of a proactive approach, right? We're trying to note where possible instances of voter discrimination could occur before these policies are put into place. So yes, I'm sorry, I've lost my train of thought. Could you repeat? I'm sorry.
Yeah, it may be because I didn't ask you a very clear question. I'm looking for the substantive reason to support this policy is really what it is.
Yeah.
I mean, I've heard that this bill is, designed to fight discrimination, and certainly I'm in favor of fighting discrimination, but I'm reading through the bill and I can't find the substance that tells me this is going to fight discrimination. I just can't. I see that there's a lot of policies put in place to measure the results of elections, but it seems to make a determination that racism existed even without any evidence that that's the case. And I guess the part that I misunderstood from the conversation with your colleague that you mentioned and the representative was really the situation where if a person is duly elected by that district, then they're duly elected by this district. So how do we know that that was the person that should not have been chosen to begin an action? And then how do we justify an action?
Yeah, so there are a lot of circumstances that the Supreme Court has noted, that could include discrimination. These are called the totality of the circumstances. And that is a long list of potential factors to consider. However, as Stephen discussed, a lot of the analysis goes through some very talented PhDs and a lot of more substantive research on that.
Forgive me. I'm just reading through the bill and trying to follow the definitions of racially polarized voting and things like that. I guess I'm going to have to do a little more homework, and I don't mean to put you on the spot, but I was hoping someone could tell me, looking at this bill, exactly where the sentences are or the policy decision that's being made and how that will combat discrimination. Because I haven't seen it in the bill. I am certainly open to making policy determinations, as we talked about from the outset, is the long lines, the failure to have enough polling locations in urban environments with high populations is the key one thing that I would address. Some of the other things that you mentioned we're working on. I think there's some dispute about the benefits of early voting and mail-in voting to any population or the validity of an election, but I'm sympathetic to the notion that more access is better. So anyway, if you've got anything to add, I would really, truly appreciate it. And certainly I'm going to try and catch up with Stephen. I know we've been corresponding. So I'm just hopeful that I can get some understanding of the bill. So if there's anything you want to add, you're welcome to. Otherwise, I won't put you on the spot. And thank you, Madam Chairman.
Thank you.
have nothing to add.
Okay, thank you, Senator. Representative Hoxa.
Thank you, Madam Chair. And the question that I want to ask you, well, first of all, thank you for coming. We certainly appreciate it. And not to, assume that, that I, not to assume anything that, Senator Sampson was inquiring about, but I believe that what he was trying to get at, and I had a similar question, was that this concept of, correlation, not necessarily meaning causation, right? And I think I share the same belief that he shares, which is that, this bill seems to really only be looking at the results and then assuming a correlation that may or may not exist. So, there's plenty of instances with, things being correlated and seeming like one is causing the other, but that there's no actual evidence that one causes the other just because of the correlation that is occurring. Can you speak to that as far as, the example that the gentleman gave earlier in, the hypothetical town where you have, let's say 51% of the registered voters are white, 49% are people of color. And there's this, hypothetical scenario where 10 out of the 10 city council seats are elected, are people that were elected by the simple majority, right? Can you explain why that is automatically a cause for concern?
I'm not, is that it would be automatically a cause for concern I'm sorry, I've just totally lost my train of thought. So that the correlation rather than causation is what you're asking, or
So if I may, through you, Madam Chair, what I think we're trying to get at here is that we don't really know which way, we can't tell which way people vote, right? Unless, exit polls are, a good indicator sometimes, with people who volunteer to disclose, who they voted for. But there really is no way of telling, just because a particular slate of candidates were elected for those city council positions, it's not necessarily given that 100% of the 51% of the rate of a particular racial makeup voted for 100% of those people voted for these 10 people that ended up winning. And there's no way of knowing that the 49%, ethnic or racial minority, that 100% of those people voted against the people that ultimately ended up winning. So what I'm really trying to get at here is that what sort of statistical scientific evidence can you or anybody else for that matter show us? Because I know you reference these people that have PhDs and have looked at this issue. Where can you show us that that the correlation between the racial breakdown, the racial ratio must mean that there is some sort of injustice that was done insofar as the people that were actually elected to these positions?
Yeah, so I think the CTVRA gets much more at specifically voter access, right? So if we're thinking about historically how certain towns that may be more wealthy, more white, might have had more funding for things like public transit or all of these infrastructure investments versus maybe neighborhoods that might be more predominantly people of color don't have that same level of investment, and it makes it harder to get this example that I'm using is public transit and that sort of thing. So that's one example of conditions to look at.
Thank you, Madam Chair. That's all I have.
Thank you, Representative. Seeing no further comments or questions, thank you again for your time and your testimony today. Next, we will hear from Tom Swan, who will be followed by Representative Annabelle Figueroa, who will be followed by Sarah Sanders. Welcome, Tom. The floor is yours.
Thank you very much, Senator Flexer, Representative Blumenthal, members of the Government Administration Elections Committee. My name is Tom Swan. I'm the Executive Director of the Connecticut Citizen Action Group. On behalf of our thousands of member families, I want to thank you for letting me comment on several items before you today and for your commitment to strengthening democracy. My colleague Helen Humphreys will be speaking on the Connecticut Voting Rights Act that you're hearing today. So I'm going to primarily focus quickly on some of the campaign finance reform bills before us. Connecticut really should take a lot of pride for our campaign finance system. It is arguably the best in the nation. And it's something that has moved more recently on a bipartisan effort than even earlier. Everybody acknowledges through their participation in the program and all that it works, that it needs some tinkering, but that it's a really good program. And I want to give a shout out to Senator Flexer, that over the last few years as co-chair, she's played an instrumental role at beating back bad proposals and helping to advance some positive ones that we think we will be able to do again this year. First bill, SB 226, AEC, the Citizens Election Program and timing of certain grants. We agree with the idea of giving candidates for governor access to some resources prior to the conventions. We also agree with the concept of increasing the grant amounts for gubernatorial candidates. That when we first passed this legislation, we had triggers for independent expenditures and self-financing of candidates. The activist Supreme Court struck some of those down. So we really need to make those types of adjustments for the more modern day elections. We also believe, though, that other constitutional officers, that their grants should be raised. I think it could be argued that those have consistently been underfunded right from the beginning for competitive races, and some tinkering there too, I think will allow for more competitive government. We oppose the provision in this bill that has smaller grants for minor parties. We think it would open us up to more litigation. We'd be back the proposal that this was discriminatory before and that it could put the whole program at risk. We have a rigorous process for people to meet that. Nobody's done it yet. It's not impossible, but we think that if people on a minor party meet those thresholds, that they should be treated equally going forward. The next bill is Senate Bill 1225. Again, this is actually where the prior to state conventions, candidates have, we also are intrigued by the voucher proposal in this bill. It is something we see that it has worked in other locations. We're just not sure yet that we understand how it would work here and get implemented. Something like a pilot project to go first, we would be very open to saying. 6904,
I'm sorry to interrupt,
sorry.
but your time has elapsed. So if you
Okay.
could just briefly summarize.
Yes.
How about this? Your time has elapsed. Are there any questions or comments from members of the committee? I have a question. What other bills did you plan to testify on
Okay,
today?
thank you. I almost asked you to do that. We believe on 6904, the online provision here, we need a change. We're hopeful it can be done in a regulatory manner, but we've got to protect the First Amendment and the rights to association of groups that organize themselves online. If it can't be done administratively, we're going to need legislation at some time. And we also agree on the need to give SEEC greater flexibility to extend investigations. The last bill I'm going to comment on in my verbal comments is we address the need. I did a bunch of that. We support the proposal to have the grants increase based on the consumer price index going forward for the grants, but see no need for contributions and organizational expenditures to increase, let alone have the increases tied to the CPI. We appreciate how this bill looks to ensure candidates can avail themselves to the CEP in the event of adjourned primary or court-ordered do-overs. I think I missed a bill before that had increase in contribution amounts up to $1,000. Again, we think this could put the whole program at risk, and we oppose that provision. Yeah, I think it's against the original intent of the legislation. Thank you, and I'm sorry that it went over.
Thank you. Thank you for your time and your testimony today. Are there any questions or any additional questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Representative Annabelle Figueroa, followed by Sarah Sanders, followed by Thomas O'Day. Is Representative Figueroa here? I do not see her. So Sarah Sanders, I believe you are joining us online. So the floor is yours. Welcome.
Thank you very much. Good afternoon, Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and distinguished members of the Government Administration and Elections Committee. Thank you for the opportunity to submit testimony regarding Senate Bill 1227, an act concerning the bonding authority of the Connecticut Municipal Redevelopment Authority, the reporting of material financial obligations by state agencies, tax-exempt proceeds fund references, and notifications of the sale or lease of projects financed with bond proceeds. My name is Sarah Sanders. I'm the Deputy Treasurer for the state of Connecticut. Unfortunately, Treasurer Russell is traveling today and was able to be here in person. Thank you for raising this important bill, which would make several changes to enhance the operations of our office and ensure appropriate notice and review by the Treasury when necessary. First, the bill would amend the bonding authority of the Connecticut Municipal Redevelopment Authority, MRDA, to align it with the bonding authority that other quasi-public agencies have. Currently, the statute for MRDA has the authority for the agency to issue bonds that are automatically guaranteed by the state. Generally, quasi-public agencies have limited bond issuance authority that requires the establishment of a special capital reserve fund and review and approval by the state treasury. This bill would remove the unchecked authority to issue bonds backed by the full faith and credit of the state, and instead give MRDA the same bonding authority that other quasi-public agencies enjoy. Second, the bill would require state agencies to notify the Office of the Treasurer of reportable financial obligations to ensure the state's compliance with U.S. Securities and Exchange Commission disclosure requirements. In February of 2019, the SEC implemented new regulations governing public disclosure requirements for public debt issuers, such as the state of Connecticut. The new regulations require additional reporting upon the occurrence of a material financial obligation or other commitment. Failure to report this information within 10 days requires the failure to report that information to be disclosed in our bond offering documents for the next 5 years. And that undermines investor confidence in our overall disclosure process. Currently, there's no mechanism for the state treasury to be alerted of significant financial obligations that may be undertaken by other state agencies that we need to report. This bill will create such a mechanism. Next, the bill makes clear the review and approval of the treasurer is required before the sale of property that is financed, sale or lease of property that is financed in whole or part with the proceeds of tax-exempt bonds. And again, this is allows us to comply with federal IRS requirements regarding tax-exempt bonds. And this is necessary to preserve the tax-exempt status on our bonds. Currently, the requirement of the Treasury is not totally consistent, and so this section is designed to close the gaps. Finally, the bill repeals statutory references to the tax-exempt proceeds fund, which was closed in the fall of 2011, no longer exists, and also removes the treasurer from the Regional School District Committee, which studies issues related to potential withdrawals or dissolutions of a regional school district. The Treasury has no expertise in the dissolution of school districts, and it's not clear what the intent was when the treasurer was added to the committee.
Thank you. I'm sorry to interrupt, but your time has elapsed, so can you please summarize?
Well, thank you again for bringing up this important bill, and it's really a lot of technical things and things that will improve the efficiency here at the Treasury. So thank you.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Seeing none, Thank you again for your testimony.
Thank you.
Next, we will hear from Representative O'Day, followed by Isabella Morales, followed by Neil Dreif and LJ Fusaro. Is Representative O'Day here? Okay, I don't see Representative O'Day, but I do see Isabella Morales. Isabella is also joining us remotely. Welcome. The floor is yours.
Thank you so much. Good afternoon, Senator Flexer, Representative Blumenthal, ranking members, Senator Sampson, and Representative Mastro Francesco, and other esteemed members of the Government Administration and Elections Committee. Thank you so much for having me here today. My name is Isabella Morales, and I'm a student and resident of New Haven, speaking here today as a member of the Yale College Democrats. I'm testifying in support of Senate Bill number 1226, an act concerning state voting rights in recognition of John R. Lewis, a bill whose importance I cannot stress enough. Ever since the Supreme Court gutted the Voting Rights Act at the federal level, Black and Brown voters across the country have become more vulnerable to voter suppression tactics employed by their state and local governments. Connecticut is definitely not immune. Whether it is longer wait times or districts that dilute minority voting power, or until recently, a lack of early voting, Black and Brown voters in Connecticut, like everywhere else in the United States, face additional barriers to being able to vote. For example, only 10 towns in Connecticut are required to have language assistance at the ballot box for voters who need translation services to vote. This seems like a small issue, a minor inconvenience, but as the granddaughter of Mexican immigrants who mostly speak Spanish, but who vote in each and every election, I understand how detrimental that policy can be. My grandparents are not less capable of making choices in the voting booth than any other citizens simply because they haven't mastered English, but policies, or rather a lack of policies like this, which limit access to the polls to people like them, signal that we as a society believe exactly that they are somehow less worthy, and as a state, we need to do better. And that's just one barrier that people face. Like I said, many people can't access the polls due to inaccessible poll locations or voting hours, or their political power is diminished through gerrymandered districts, all of which we know disproportionately affects communities of color. And while some of these issues seem small, they are giant to those they block from being able to vote. And while it might be difficult to address each instance of voter suppression one by one, with the State Voting Rights Act, we can provide the people most informed and aware of the problems with the tools to fight back. If the federal government won't step up to protect these rights for vulnerable communities, the least we can do in Connecticut is protect our rights here at home. And with that, I urge you to do your part to please pass SB 1226 so Connecticut can lead the way in the fight to protect voting rights and show our citizens in Connecticut of all backgrounds that we care. Thank you.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Seeing none? Thank you again for your testimony. We appreciate it. Okay, next we will hear from Neil Dreif and LJ Fusaro. And then after the two of them, we will hear from Anna Posniak and then Ron Lizzie. Welcome, Neil. Welcome, LJ. The floor is yours.
Good afternoon. Thank you, Senator Flexer and ranking members, Master Francesco and Senator Sampson. I'm LJ Fusaro. I'm the police chief in the town of Groton. Joining me here today is Chief Neil Dreif from the town of Cheshire. He is the president of the Connecticut Police Chiefs Association. I'm one of the vice presidents. And we're here to talk to you about Raise Bill 1222, an act concerning fees for copying, reviewing, and redacting records created by body-worn camera equipment and dashboard cameras. Now, one of the primary reasons we're here today is to request your assistance in providing an avenue that enables Connecticut's police departments to continue to provide the public and interested parties with information and videos that are not exempt from disclosure, while also providing agencies with a fee structure that does not currently exist for video. CPCA has supported the wholesale implementation of body-worn and in-car cameras for Connecticut's law enforcement community, as it provides both transparency as well as an accurate and independent evidence of many aspects of our investigative efforts while demonstrating the professional activities of our officers. However, while there's long been the ability for agencies to charge for written records under the state's Freedom of Information Act, there is no such provision for agencies to charge fees for the considerable time and effort used to reproduce, redact, and furnish requesters with that digital media. In the case of body-worn cameras and in-car camera video recording, some agencies have had to hire additional staff in order to address this new requirement. Other departments may use existing sworn or civilian staff who dedicate countless hours to reviewing, redacting, and copying digital media. This can be burdensome, especially in matters of expense for those agencies that have limited staff or maybe no one dedicated to do this. By way of an example, a simple video that is short in duration with little or no redactions may take an hour or two for staff to review, redact, and reproduce onto a disk or thumb drive and to provide it to a requester. On the other hand, an incident that has multiple recordings, maybe from several officers, and contains images that we are required to redact may take up to 16 or 20 hours or more of staff time in order for it to be suitable for release. In addition, with the rapid increase of this technology, there is often additional features, equipment, and costs that departments have had to invest in order to reproduce this material. Yet there's no way for these costs to be offset by reasonable fees. This bill will help to change that and help strike a balance between providing the public the information they want from law enforcement agencies while establishing a structure that allows the public agencies to offset this rapidly increasing cost associated with technology. I believe Chief Dreif now has some comments about another aspect of this bill.
Thank you. Chair and members, we appreciate the opportunity here. And I just want to piggyback first off something that Director Murphy said a short time ago that we have.
Chief, I'm sorry to interrupt. Can you just identify yourself by your own name?
Sure. I'm sorry. Neil Dreif. I am the police chief in Cheshire, and this year I serve as the president of the Police Chiefs Association.
Thank you.
Director Murphy testified a short time ago that we have been working closely together. And I can't stress enough that we have been doing that, and that we certainly appreciate the time that the Freedom of Information Commission staff has already put into this. And again, we hope to continue to do so and possibly work with members of the committee if you deem that appropriate. I wanted to touch very briefly on one of the other aspects of the bill, which is that the exemptions that are in there. And we support the narrow exemptions that this proposed bill creates to protect the personal privacy of Connecticut residents. Specifically, the bill allows the redaction of video footage of the inside of a private residence or video that shows a person in a state of undress or nudity. These are common sense exemptions that allow residents to maintain the privacy and sanctity of their homes, even if they have occasion to request police services. And obviously, Chief Fusaro and I welcome any questions from you or any members of the committee.
Thank you. Thank you for your time and your testimony this afternoon. Are there questions or comments from members of the committee? Representative Mastro Francesco.
Thank you, Madam Chair. Thank you so much for your testimony. You mentioned about the redaction of video from inside someone's home. Would that be the person's, could it be the home of a victim, or maybe the person being accused?
Either one.
Either one.
Yes.
Okay. And how complicated is it to do that, to do the redaction? I mean, how many hours could it possibly take?
So that's one of the concerns that we really have is the difficulty of that. You take your, a domestic violence incident, for example, which is not an uncommon thing to be called to someone's home for that. Those are high risk calls for police officers. We normally dispatch at least 2 officers, and in many cases, a supervisor also. So bear in mind that under, current state law, every patrol vehicle that goes has a dashboard camera that's running as they're responding. And then every officer who arrives at the scene is wearing a body worn camera. So in the case, there's already an exemption in statute for a domestic violence victim. So if 2 officers and a supervisor arrive at the scene, enter the residence, and all are interacting at various times with maybe the suspect, if that person is still there, or the victim at various, times, every single body camera video from each of the 2 or 3 people who respond has to be reviewed. And then there's a software program for doing it, but then their face has to be redacted from all that video already. So it's quite an extensive process. There are, depending on the company and the software that you're using. For example, if I was speaking with you and then I turned away to address someone else and then turn back to you, I have to go back in now and identify your face again and redact your face from the next segment of video that I get. So that's why, as Chief Fusaro said, sometimes it's taking 16 to 20 hours to go through and just make what we would determine are routine redactions from video.
So, thank you. And through you, Madam Chair. So I'm assuming the redaction is not being done, let's just say in the Cheshire Police Department. You send it out to a company to do it, or do you do it yourself?
We have the capability of doing it. That's kind of an add-on that not every town has purchased. I don't know how other towns are getting around that, but we did buy that capability when we recently updated our body worn cameras.
Thank you. And I'm assuming that the officer involved that has the body camera has to sit with the person redacting the information. I'm assuming because there's some communication going back and forth as to what happened, so that person redacting can understand. But is that
Not necessarily. That may happen in certain instances, but not necessarily. In the case of my department, we have a civilian who does this exclusively. He may contact officers to get some clarifying information. If there's a complex video, he may ask them to come in. But it doesn't necessarily require two people, although on occasion it might.
Okay, so there's some departments that do it internally and have somebody from staff to take care of that. And then there's some other departments that have just a civilian that takes care of this. And are they part of the staff at the police station?
I can tell you, and I don't know if my colleagues' experience is the same, but it varies from department to department. We have Eastern Connecticut, we have smaller departments that may be around Hartford County or New Haven. So they may not have someone dedicated to do that. Some of the smaller agencies may have a sergeant, a lieutenant, a captain, someone who's part of the patrol staff doing it. My department has had body worn cameras since 2017. After the implementation of body worn cameras, we found it necessary to hire a civilian to almost exclusively work on this. He has other duties as well, but this takes up a considerable amount of his day, responding to requests, making sure that everything that is released has been cleared and vetted. As Chief Dreyfus said, it isn't totally independent, meaning you don't have a software that's foolproof. They have to be reviewed before it goes out. He usually catalogs it and keeps a copy of it, so we know what's been released. So there's a video that is unaltered. There's the video that went out to the requester in a mirrored copy that we retained for our records, so we know exactly what's been released. And in addition to not just faces, but there's other information that we were required to redact. For instance, if an officer's on patrol, they activate their body worn camera. They have a mobile data terminal within inside the vehicle that has information that can't be shared with the general public through some of the communication systems that we have in law enforcement. That has to be redacted as well. So there's a whole host of work that goes into this behind the scenes before that video that someone requests is reproduced and handed out to the general public.
Thank you. And then the fee involved in that. Can you give me an example? So it's 2 hours and you don't charge, and then there's a fee after that?
That's what the existing bill has, as Chief Drive indicated. We have been working with the FOI Commission to kind of to strike a balance. We do appreciate the fact that people want this, and we have no objections to providing information and videos to the public that they're entitled to get. However, it has been burdensome and almost somewhat cost prohibitive for agencies to do this. There is no way for us to currently assess a fee. Whereas if you ask me for a report and you come to the police station to pick it up, I can charge 50 cents a page for each copy. That doesn't exist with the body worn camera footage. So we're investing a lot more time and energy in producing that end product for someone to have when they come to our records division to pick it up. There's no way for us to calculate a cost to that. There are some suggested language that we've provided that have ended up into a bill that says, hey, for the first couple of hours, we won't charge you for searching for it, but if it's going to be a complex video where multiple officers have responded, we have video from body worn cameras as well as in-car cameras that takes, several days to go through and to redact, there has to be some type of compensation for that time, right. Not making it cost prohibitive, but making it reasonable. Right now that doesn't exist. So the person that I have on staff doing this, he could sit there for 2 or 3 days. Whatever other assignments that we've given to him have to take a back seat till he gets that video done and awaits the next one to come in. And there's really no compensation other than, there may be the cost of the thumb drive, which is $10 or $5 for a CD. But those hours and hours of time that have gone in and quite frankly, many of the times that we're getting these requests, they're coming from the same individuals over and over again for a multitude of different things. And it creates a burden for our departments where our records divisions aren't equipped to handle this, and there just isn't enough personnel and enough hours in the day for them to complete this.
Thank you. And through you, Madam Chair. So the biggest sticking point on this bill is the compensation and the time that it's taken to do the redaction. Is that correct? Is that the main part of it? And then I'm hoping that you're going to continue to work with the Freedom of Information Commission to iron those things out.
We will, and we have. In fact, on the break, we were out there discussing
Good.
this with them. So they've been very collaborative, and we do appreciate that, and we'll continue to work with them.
Okay, good. Thank you very much. I appreciate your coming in and your testimony. Thank you, Madam Chair. I have no further questions.
Thank you, Representative. Senator Sampson.
Thank you very much, Madam Chair. And thank you guys for being here today. Appreciate the testimony. This is very helpful. Just one thing you mentioned, and this has happened before in other arenas too, certainly even with paper documents. It seems like it always comes down to one or a couple of different people that are generating the majority of the work and the cost. And I'm just curious, does it seem like those instances are people that genuinely need this paperwork, or or it's being done in a malicious kind of way? I'm just curious, maybe because there is another answer in this equation to prevent the malicious asking of freedom of information documents without any purpose or something like that. Before I let you answer, I just want to, for anyone listening, I'm totally in favor of making sure that we provide these documents and we can hold people accountable, but at the same time, we have to have some sort of limitation if it's being abused.
Yeah, I don't know if the act or the intent was to ever prohibit anyone I believe the whole idea of transparency is allow people to kind of look behind the curtain to see what's there. I can speak for my department. We have some people that we hear from all of the time about a variety of matters that may or may not involve them. But as a sense of, wanting to know what's going on, that could be something as simple as something happened at your neighbor's house and someone wants to know what happened. And I think what Chief Dreif was describing might be an example of that, where, hey, the police responded to my neighbor's house. I want to know what happened. So I'm going to ask for a copy of that video. And I've never been invited to my neighbor's house. I'd like to see what their living room looks like. And I'd like to know what kind of, furniture they have and things like that, where, we scrupulously honor that in law enforcement. We have to have a legal right to go into someone's home and to conduct searches under the Fourth Amendment. Yet we're allowing that avenue to exist right now for people to be able to go into any one of our homes if police get called there, maybe for something innocuous as a roaming dog, or, maybe there's a noise complaint or someone had a burglary in their neighborhood. So you're canvassing the area and going into a bunch of different homes. Right now, as it exists, we don't redact that information, or we're not required to redact that information, which, quite frankly, I could respond to your home for something that has nothing to do with anything that you were involved in, but yet they'd be able to see inside of your residence and, understand what's in there.
Senator, one of the challenges that we've discussed with the Freedom of Information Commission is the vexatious requester part of the act already, but the bar on that is set pretty high. And again, look, I think need is in the eye of the beholder, right? We have an ongoing, or had, fortunately, they have left our jurisdiction, but we had an ongoing neighbor dispute. Because of the nature of the calls there, we would send 2 officers every single time that the call came in. One of the parties to the neighbor dispute came in and requested every single time that we went there. Some of our colleagues in other departments have had people come in and say, I'd like every single body camera video from your 3 to 11 shift last Tuesday. And, if you're running 2 officers, maybe that's not the end of the world. But if you're in Hartford or New Haven or Bridgeport and you've got 27 to 35 cops on the road, that can be a tremendously burdensome thing, as you can imagine, to go through every single one of those calls.
Thank you very much for that information. It's very, very, very helpful. I appreciate it. Thank you, Madam Chairman.
Thank you, Senator. Representative Bronco.
Thank you, Madam Chair, and thank you, Chiefs, for coming in and testifying today. And I'm just wondering, that now that body worn cameras are basically universal, are you seeing an uptick or a rise in requests for body cam, video? And if you could speak to that a little bit, the amount of requests and such.
We certainly have. like Chief Fusaro said, we were also early adopters in that we went with the first round of state funding. Thank you very much for the provision of that. But we've had them since about 2017. And as the public has come to understand that every time a police officer responds to a call for service, they're wearing a body camera. It now becomes, if somebody's look, I need a copy of that report, and I also want a copy of the body worn camera and the cruiser camera. We're starting to see this all the time now from attorneys who work in who represent people involved in car accidents. It's not enough now just to get the police accident report. They want the cruiser camera and the body worn camera of every officer who responded. I imagine so that they can conduct a more thorough review of the facts and circumstances of the accident for their clients. But now something that involved at one point having your records clerk hit print and print out the accident report now takes sometimes hours, maybe even longer than that. If you have a serious accident with multiple responding officers, driving a car that has a camera in it and then wearing a camera for the entire time that they're out on the scene, and they want every statement, every interaction between people involved in the accident. I'm sure they're looking at position of vehicles and things like that when they're reviewing that. But it's certainly ramping up, and I think as people continue to gain an understanding of the fact that every police officer they deal with in almost every context is wearing a body worn camera, we're going to continue to see that number increase.
Thank you for your answer. Through you, Madam Chair, just one more question. I represent Naugatuck, and we were one of the earliest adopters of body worn cameras. And so we kind of got the jump on purchasing, but even now with a lot of the new laws, we've incurred some additional costs, quite a bit, just for all the housing, for saving all the videos and being able to store all this video footage. So I understand that, the request for some sort of compensation to help alleviate, the balance there. And just in understanding the fees, I'm wondering if it sounds like it's still to be discussed, but do you see like a sliding scale based on time to procure the video, that you get the first 2 hours free and then some sort of sliding scale and cost after that? I'm just wondering if you have talked about that.
That's what's in the bill right now, that there is a certain amount that's free. Then after that, it would be charged based on an hourly rate. I think the way the proposal reads now, it would be whatever we charge for an hourly rate for the lowest paid employee that can perform that task. We're open to certainly the thoughts of the legislature on how this should be done, but it has become considerably more expensive to police in Connecticut in the last several years because of this. Both our agencies have had body worn cameras for several years, but every year my budget isn't going down. I've got another employee because of this. There's additional cost for added software, for features that enable us to, mesh the videos together. So if there is an incident and people want to get that, try and put some of this together. But the cost of policing is going up, and this is one of the unintended consequences, I believe. We embrace the transparency and accountability stuff that these bring with us, because I think what I've seen in my department is that when I've gotten an officer on body worn camera and there's a civilian complaint that comes in, it clears it up pretty fast. We know what the facts are. And by and large, almost exclusively, it proves officers are out there doing what they should be doing. But yet there's a sizable cost. And I don't know that the small amount of money that we're talking about here will offset all of those costs. I don't think they will. But it is something that we're getting for the work that's being done in our agencies that right now isn't getting addressed through any type of fee.
Yeah, thank you for your answer. I appreciate your testimony today, and that's all I have, Madam Chair. Thank you.
Thank you, Representative. Are there any additional questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony and all your work on this legislation. We
Thank you, Madam
appreciate
Chair.
it.
Thank you.
Next, we will hear from Senator Looney, who will be followed by Representative O'Day. Welcome, Senator Looney. The floor is yours.
Thank you. Thank you so much, Senator Flexer, Representative Blumenthal, members of the Government Administration and Elections Committee. I'm Martin Looney, State Senator of the 11th District, representing New Haven and Hamden. And it's always a pleasure to appear before the Government Administration and Elections Committee, of which I was the House Chair back in the 1987 and 1988 term, when my co-chair was then State Senator, later Congressman Jim Maloney. So that year, our major theme had to do with absentee ballot applications after there having been a scandal in the Democratic gubernatorial primary in Waterbury, I believe, in 1986. So it was much in the news then about trying to provide greater accountability and oversight of the distribution of ballot applications. But this is a committee that does valuable work every single term, every single session. And I want to congratulate all of you for the labor that you put in, the thoughtfulness that you give to the work here. The bill I'd like to speak on today is Senate Bill 226, an act concerning the Citizens Election Program and the timing of payment of certain grants. I understand that the House Republican leader, Representative Candelora, has put in a separate bill similar in this in regard, but with somewhat different increases in the contribution limits that he provides. I certainly commend him on doing that. I put in this bill because I'm gravely concerned that we are seeing a lack of participation by the major party candidates who were successful in receiving their party's nominations and not participating in the Citizens Election Fund. Since the fund went into effect 2010, I believe, was the first gubernatorial election to which it applied. That year, Governor Malloy and participated. Mr. Foley, I believe, did not. 2014, both candidates participated. But unfortunately, that year, there was more outside spending by Citizens United enabled private PACs that actually exceeded the amount spent by the two candidates under the public financing system. And then, of course, in 2018 and 2022, neither Governor Lamont nor Mr. Stefanowski participated. And I think that's a bad thing for the system. I think that it works well for every other office, for all the constitutional offices and for the General Assembly, but not for the office of governor. And that's why I proposed a significant increase both in the primary grant and in the general election grant. Now, it seems to me, and I think that campaign studies have proven it out, that candidates don't have to match a better funded campaign dollar for dollar in order to be competitive. Certainly, we saw that in the U.S. Senate races in 2010 and 2012, where Senator Murphy and Senator Blumenthal were significantly outspent in both of those campaigns by Mrs. McMahon, probably by a tune of about 3-1, and they were still able to win and get their message out. But there is a certain threshold, I think, that if you don't reach that threshold, you are at a significant disadvantage, especially against a self-funder who has an infinite capacity to, or close to infinite capacity to spend money into on his or her own campaign. That's why I think this bill is necessary. I think also looking at what happened in 2018 in pursuit of the Republican gubernatorial nomination, I think the candidates who were looking to participate in the system, especially Mayor Boughton at that point, proved to be at a very severe disadvantage to Mr. Stefanowski, who was able to begin significant spending very early on, was on television early in 2018, while Mayor Boughton and others were still contacting delegates about getting the nomination and working on getting the qualifying funds. And that's why, as a part of this proposal, I would suggest that not only should the grants be increased, but that a candidate should be able to access some of the public funding money earlier in the process, namely when he or she files a completed application that's vetted by SEEC and is deemed eligible for the grant. As you know, right now, no matter how early the candidates finish their fundraising, they're not eligible to receive the grant until after the convention, whether they might be the convention nominee or someone who qualifies with 15% of the convention or someone who petitions to get on the ballot after the convention, having not qualified through the 15%. So I would suggest that that candidates be able to get a quarter of the qualifying amount probably in the spring of that year when they file their application. The balance, the other 3/4, should be available immediately after the convention to those who are endorsed or those who are the 15% candidates. And then for the candidates who qualify by virtue of petitioning, of course, they would have to wait until their petitions are verified to get their portion. But that's it in a nutshell. And I think it's critical if we're going to keep that part of our system viable, and not just assume that we're only going to have self-funded candidates being successful in pursuit of major party gubernatorial nominations. Thank you, Madam Chair.
Thank you. Thank you for your time and your testimony today, Senator Looney. Are there questions or comments from members of the committee? Seeing none. Thank you again for your testimony, Senator.
Thank you so much.
Next, we will hear from Representative O'Day, who will be followed by Anna Posniak, who will be followed by Representative Annabelle Figueroa. Welcome, Representative. The floor is yours.
Thank you very much, Chairs Flexer and Blumenthal, who actually I think I just left in Judiciary, Vice Chairs Marinbello and Slapp, and then Ranking Members Sampson and Master Francesco, and members of the Government Administration and Elections Committee. My name is Tom O'Day. I represent the 125th District, and I'm here to speak in favor of Bill 6385. This actually was an idea that came to me from a constituent who asked me not to use their name, but apparently there was a complaint made to a social media platform by a state employee, let's say, and they ended up being censured in their social media platform. And so that's the impetus of this bill. And the bill is very simple. I apologize, I didn't submit written testimony, but I will try and do so. It's very simple. Before any state agency or state employee can reach out to a social media company to have them censured or blocked, there has to be a hearing. And they have to give an opportunity for them to be heard, unless it's emergency. Obviously, if there's an emergency situation, there's someone that's a danger to themselves or others, then the 48-hour hearing requirement or notice wouldn't be necessary. But generally, what this does is it requires an agency or a state employee through an agency to have a hearing before they reach out to a social media platform to have them censured. And I will tell you, and if they are censured, the person believes if they were unfairly censured because of that state agency or actor, they can appeal to Superior Court. I think we saw what happened nationally in governments getting involved, or the federal government getting involved in social media platforms and censoring individuals. I'm a big, as I think all of us are, big proponents of the First Amendment. I was frankly surprised, dismayed, and shocked that the ACLU came out against 6385, this bill, because I think they misread the intent of it. My intent is to encourage First Amendment speech, and because we want people to feel like they've been heard. I think if you look back at the problems that some of the people, whether it's a mental illness or some other snapping for some reason, it's because they feel like they haven't been heard. So one component is we want people to feel like they've been heard. And so having a state agency reach out to squelch that free speech, I think is really bad for many reasons, not the least of which is we want to know if somebody has hate in their heart, so to speak, or somebody has an axe to grind against an agency or an individual. We want to see that out in the open forum so that maybe they can be stopped or intervention can be had. This bill actually encourages free speech, doesn't squelch it. So I'm not sure if the ACLU is going to be speaking today, but I would encourage you to ask them why they came out opposed to it, because if you look at the end of their testimony, they say that the ACLU opposes this bill because it goes against the First Amendment, and that was not the intent. It actually is trying to encourage it. So I'm happy to answer any questions if there are any, and I appreciate the time and attention.
Thank you. Thank you for your time and your testimony today, Representative. Are there questions or comments? Representative Master Francesco.
Thank you, Madam Chair. Thank you, Tom. Nice to see you.
Good to see you.
Thanks for testifying today. The constituent that you had, was that report, it was filed from a state employee. Did it go through the misinformation specialist that the state had hired back in 2020?
You know, I can't answer that question. I don't believe so, because I don't think it did, but I can't answer definitively on that. I will try and find out and get that answer to you.
Okay, yeah, so this state employee did go through an agency within the state of Connecticut. And then that agency reported it to, let's just say, Facebook, social, Twitter, Instagram, or whatever.
My understanding is there was a complaint made from a state agency to Twitter. about comments made by an individual. And the individual didn't find out about it until after their account was shut down.
Gotcha. Okay. Yeah. Thank you for that clarification. Because I know Connecticut back in 2020 hired a misinformation specialist that was actually contacting Twitter with what they felt was misinformation that somebody could have posted, which I had grave concerns on. But that answers my question. I was curious where that came from and if it actually went through the misinformation specialist. Thank you so much. I appreciate it. Thank you, Madam Chair.
Thank you, Representative Hoxa.
Thank you, Madam Chair. Welcome, Representative. Good to see you.
Good to see you.
What I'd like to ask you is kind of the intent or the spirit of this bill as you crafted it. If I'm not mistaken, is the aim here to really kind of bring to light the fact that it is not generally as a matter of, general kind of good policy to be able for a state employee to be able to leverage their agency's name in order to kind of inflict some personal or to satisfy some sort of like personal grudge that they may have towards an individual, whether on social media, online, whatever. Is that really what, the spirit of this bill is, to make sure that when a complaint is submitted to, whatever, so Twitter, Facebook, whatever social media's, board of, complaints or whatever, that the fact that it's coming from, like a governmental agency email doesn't give it more weight and more legitimacy? Because I kind of have seen that in the past where things like that have been done. And it tends to be my perception that those sort of complaints are taken a lot more seriously. But when, the shoe is on the other foot, it almost seems like nothing ever really gets done. So can you speak a little bit more to that? And is that really kind of just like what the aim of this bill is?
Yes, thank you very much for the question. Absolutely. So in other words, a state agency going in and telling Twitter or Facebook, you need to take Tom O'Day's account down. We believe that they're violating public policy issues with the state and inciting violence or whatever. That will carry more weight than if, Steve Smith complains that, hey, Tom O'Day, I believe, and I've never worked for Twitter or Facebook and their truth-telling agencies, but, it is the intent that I think that a state agency would carry more weight. I'm not saying that a state agency can't complain, by the way. If it's an emergency, they don't even have to do the hearing right away. But before they do, they have to give the person notice that they are going to report them so that they don't find out so the person doesn't find out they're shut down without any notice beforehand. So a private citizen can go in and complain all they want, but if it's a state agency, like you said, it's going to carry more weight. At least that's my understanding. When a social media company receives a complaint, a state agency or state actor would carry more weight, and that's problematic in my mind. Again, the whole intent of this is to encourage free speech, encourage knowing what somebody's saying online, and intervene if necessary, not to discourage free speech. So I'd be curious as to if the ACLU misread the intent of the bill, as to why they're opposed to it, because the other testimony was all in favor of it. But thank you very much for the question.
Absolutely. Back to you, Madam Chair.
Thank you, Representative. Are there any other comments or questions? Seeing none, thank you again for your time and your testimony today, Representative.
Thank you, Madam Chair.
Next, we will hear from Anna Posniak, who will be followed by Representative Figueroa, who will be followed by Ron Lizzie. Welcome, Anna. Thank you for your patience. The floor is yours.
Thank you. Good afternoon, Senator Flexer, Senator Sampson, Representative Mastro Francesco, and distinguished members of the GAE Committee. My name is Anna Posniak, and I am the Windsor Town Clerk and co-chair of the Legislative Committee for the Connecticut Town Clerks Association. As currently drafted, CTCA opposes HB 6908, an act concerning elections, presidential preference primaries, and deadlines for minor party nominations. A portion of this bill seeks to provide minor parties an extended period of 9 days to file their nominations with the town clerk for municipal elections only. This extension will create a further hardship for clerks to prepare ballots and for printers to print the ballots and to deliver the ballots to us. We've seen a shift in the number of voters seeking to vote by absentee ballot. That, coupled with the current tight timelines under the election calendar, are currently straining our printers to meet these new demands for ballots. Presently, those municipalities that do not have a municipal primary may proceed to order their ballots at an earlier time frame, accordingly taking the pressure off our 2 state printers. With the proposed new deadline, 169 towns will simultaneously order ballots in mid-September, which will overwhelm our printers who are trying to meet the statutory deadline. All orders would become rush orders, incurring increased fees for printing and delivery of the ballots. CTCA proposes an amendment to use the same language included in the bill for state elections. This deadline would not only afford the necessary time to prepare the ballots, but also to print them, and will also offer consistency between elections, making it easier for our minor parties too. Lastly, I'd like to speak to SB 1221, an act concerning enforcement of violations of the Freedom of Information Act and reporting of open requests. The CTCA applauds the spirit of the SB 1221 to hold towns accountable for public information requests. But we have concerns that towns might struggle to meet the reporting and posting requirements, especially our small towns. Software will be needed to monitor the status of these requests and to create reports. The annual cost for the software will impact our already stressed municipal budgets. Additionally, there is no threshold for what constitutes a public records request. We fulfill many requests on a daily basis and are not currently documented. If routine requests are removed, our residents will receive a skewed picture of what public records request had been fulfilled that past month. This could unintentionally influence our residents' perception of town services and further impact their vote on our annual municipal budgets. The CTCA is open for further discussion regarding this proposal. Thank you for this opportunity to testify.
Thank you. Thank you for your time and your testimony. Are there questions or comments from members of the committee? Seeing none, thank you very much for your testimony.
Thank you.
Next, we will hear from Representative Figueroa, who will be followed by Ron Lizzie, who will be followed by Helen Humphreys. Welcome, Representative Figueroa. The floor is yours.
Thank you very much. Good afternoon, Senator Flexer, Senator Sampson, Representative Francesco, and distinguished members of the GAA committee.
Representative, I'm sorry to interrupt you, but can you turn on your camera, please?
I am trying to, but it's not letting me. I apologize.
Oh, that's okay. Let's see if we can figure this out. Can we send the good representative a request to turn her camera on? Did that come through, Representative?
Yes, right now.
Great, thank you very much.
Oh,
the floor is
okay,
still yours.
yeah. All right, thank you so much. Should I start all over again?
No, that's okay.
Okay, today I am here to support House Bill 6909, but I am also testifying and asking for the Latinx word not be used in any government-official documents. As immigrants, upon arrival to the United States, we found ourselves being classified as Hispanics, a term many of us did not know, neither did we used to call ourselves before. Later, there was the option of using Latina, Latino, which is my preference, because it highlights my Latin American origin and not only the fact that we speak Spanish. Americans have a tough time pinning us down. We have been branded with label after label, each tag trying but failing to sum up in a single word the 60 million of us with Latin American and Caribbean ancestry who have made a home here. In just a half century, appellations have been applied like stickers. First, we were Hispanics, then Latino, and lately Latinx. Domingo Garcia, president of the League of United Latin American Citizens, LULC, the largest and oldest Hispanic membership organization in the United States, announced the group's decision to drop Latinx from its official communications because it is so unliked by most Latinos, he stated. LULAC, L-U-L-A-C, always represents Jose and Maria on Main Street in the barrio, and we need to make sure we talk to them the way we talk to each other. In a recent poll conducted in November by Bendixen and Amandi International, a Miami-based Democratic firm, showed that 68% prefer Hispanic and 21% favor Latino. But most important, this poll reported finding a whopping 40% of the participants finding the word Latinx offensive. The Miami Herald said in an editorial reacting to the survey, that's the irony of Latinx. It is supposed to be inclusive, but erases a crucial part of Latin American identity and language and replaces it with an English word. Furthermore, and perhaps the most ironic failure of the term is that it actually excludes more groups than it includes. By replacing O's and A's with X, the word Latinx is rendered laughable, incomprehensible to any Spanish speaker without some fluency in English. It is incredibly important to remember that the word Latinx has been included in the English dictionaries like Oxford and Cambridge, but not in the Royal Spanish Academy known as RAE. The Royal Spanish Academy is Spain's official institution with a mission to ensure the stability of the Spanish language. Señores y señoras, Mr. and Mrs., it is not a secret. The Hispanic Latin community have spoken out repeatedly. Over nearly 2 decades, our preference has been consistently stated and shown. We want to be identified by our nationalities, our individuals' histories, traditions, customs, languages, and dialects. We are Mexican Americans, Colombians, Salvadorians, Puerto Ricans, Brazilians, and so on. We admit it will be a messy task for the census to sort all of us out. It will confuse the media, which already have enough difficulty differentiating between ethnicities, and it will be unproductive for ethnic and racial movements that depend on unity and numbers. Yet, we must admit, we cannot always be lumped together under a collective name. We are a blur of colors and languages, histories and faces. No one word can capture that all, especially Latinx.
Thank you. Thank you for your time and your testimony this afternoon. Are there questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Thank you, Representative, for your testimony. What does the X stand for? Is it supposed to be gender neutral?
That is my understanding, and I apologize if I may finish. So today, we are respectfully requesting for the Latinx word to be dropped from any official communication, not only because it is not recognized by the Real Academia Española, but out of respect for the fact that this word is very offensive to most Hispanic and Latin descendants. And to answer your question, yes, the X is gender neutral, and that's why it is being used. But I think that is the intention of.
Thank you. You know, it's interesting. I haven't until recently, I really didn't hear that term before. And then actually went online to look, and it's not common. I mean, this just started back in 2018, I think, when a lot of the language has changed. And I have to tell you, Representative, I truly sympathize with you. I feel the same way about when we take the word like pregnant mother and change it to pregnant person. You know, everybody, I'm offended by that as much as you are offended by the Latinx. I truly understand it. And really didn't know that it was just somewhat new, starting in 2018. So I sympathize with you. I truly understand it. Like I said, everybody gets offensive on certain things. I'm offended that I'm no longer a mother and that I have to, and I totally get it and I appreciate it. Thank you so much for your testimony.
Thank you for your understanding.
Representative Santiago, followed by Senator Sampson.
Thank you. Thank you, Madam Chair. Can you hear me?
Yes.
Yes, we
Okay.
can.
Great. Thank you. Latinx has become more politically favorable and not used by the majority of the Latino and Hispanic voters and folks. It sounds non-Hispanic because the letter X really does not exist in the Spanish language. So people are trying to change our language. So my question to you, Representative, is they're starting to use more the word Latine, Latine, because they're changing the gender from Latino, Latina to Latine. And I think the word is catching up more with even the younger generation. So do you think that going back to the community is a good idea, especially when words like Latinx are changing the whole language, the whole recognition of the Latino community, for the state to go back and go back to the community and say, okay, what word do you want to say? Do you want to be recognized as? So do you think my question is, do you think Latin will be more acceptable?
Thank you for your question, Representative Santiago. After speaking to so many of my constituents and coworkers as well, we stand to the point that Latinx or Latin, like you say, with the E at the end, is still changing our words, right? We are Latinos, we are Latinas, and that's exactly how we want to. You could call me Hispanic if you want to, but no matter what. And when it comes to the being gender neutral, no matter what, whether you are in a position, if you're a female, you are Latino, you are a male, you are Latino. And if you are into a relationship, which is not, out of, if you are into like a gay relationship, because I do have so many friends, they also, within their own community, they also identify as a man or as a woman in their relationships. So no matter what, we have to continue with the O and the A, which is what really identifies our genders, and not only into the genders, but rather an object. Because when I call la mesa, how am I going to call la mesa? So I don't think it's good. I think we should continue using the Latino and Latino Hispanics. But again, I think it is very important for the Hispanic community to drop the Latinx from any official documents. As I said, this is offensive to our community, and no one should be making a decision on behalf of our community to change how we are called.
Okay, great. Thank you. Thank you, Representative. Thank you, Madam Chair.
Thank you, Representative. Senator Sampson.
And thank you very much, Madam Chairman. And thank you, Representative, for being here. And thank you, Representative Santiago, for your comments also. I just wanted to say that I appreciated your testimony very much, and I'm in full agreement. I guess what I want to ask you about is the bill more than anything. But I do want to say that I certainly share this concern. I know a great many people from all over this world, and I think there's many ways the people end up categorized ineffectively and incorrectly, and sometimes in ways that are inappropriate and sometimes offensive. And I think that Latinx is one of those examples. I don't really care for the fact that we use the term Pacific Islanders either in a lot of the laws that we draft. Each one of those countries is an individual country with a heritage and an important place, and people should be recognized for that and not lumped together in some artificial category. I was just actually out of curiosity looking up the definition of Latin America to try and figure out exactly what qualifies, because to me, Latin America seems to be the countries that are in Central America, maybe South America, maybe the Caribbean islands. It's interesting though, because not all of those countries necessarily are Spanish speaking. At Brazil, which is a Portuguese speaking country. I don't know, maybe some majority of people in Brazil consider themselves to be Latin American, or maybe they don't. I don't really even know, but I don't think it's right for our state government to be coming up with these kinds of terms to kind of lump people into categories. So I'm very much in agreement. But the question I have is about the bill, because I think the bill doesn't have enough teeth, if you ask me. It simply says that prior to a state agency commencing the use of any term to describe or identify a particular community based on ethnicity, it says that that agency shall attempt to solicit feedback from the members. And I'm just curious, I mean, is that a satisfactory solution to you, Representative? I mean, for me, I would just say, no, they can't do it at all. But I'd be curious to hear what your response is. Through you, Madam Chairman.
Thank you for your question. And I think you already answered your own question. And I think this is one of the reasons why I am testifying and saying no to any changes. I don't think that, it should be done and they should not be reaching out to any members. We are already expressing our discontent, or should I say our opposition to making any changes. So my answer will be no.
Excellent. Thank you very much. I appreciate that, Representative. Thank you, Madam Chairman.
Thank you, Senator. Seeing no further comment. Oh, Representative Rosario.
Thank you, Madam Chair. I have no questions, but I do want to thank Representative Figueroa for bringing up this very important piece of legislation. I throughout the last few years, especially the last 6 years, throughout my district, I can't speak for anybody else's. I do know that this topic has come up, and especially in the Puerto Rican community, a lot of people feel they're offended by the term Latinx, and even those in the LGBTQ community would prefer the term Latine, which is something that is phonetically correct. Latinx is phonetically incorrect. And I thank the good representative for her feedback on this bill. Thank you.
Thank you.
Thank you, Representative. Seeing no further comments or questions, thank you again, Representative Figueroa, for your time and your testimony. And I haven't had the chance to meet you in person, but congratulations on your election. And again, thanks for your time today.
Thank you for allowing me to speak on behalf of this bill, and I do appreciate everybody who was listening. Thank you again.
Thank you. Next, we will hear from Ron Lizzie, who will be followed by Helen Humphreys, who will be followed by Suzanne Allen. Welcome, Ron. I believe you're here online. The floor is yours.
Thank you, Madam Chair and members of the committee. My name is Ron Lizzie. I'm an author and engineer from Bethany. I have advocated for reform of the unclaimed property program for years, and my work has led to changes in Connecticut and Colorado. I support SB 382, an act modifying the process for claiming and returning unclaimed property held by the treasurer. This bill is based on my proposals. It incorporates the best practices of other states, including automatic return of unclaimed money without claims, and payment of past due child support by matching cases with unclaimed money owners. There are several problems with the bill's text, however, and I've proposed amendments to address them in my written testimony. With those amendments, this bill should return millions of dollars to the rightful owners, which is the program's mission. The bill will benefit people, businesses, nonprofits, and municipal governments. Utah lawmakers just approved a bill to enable automatic return of unclaimed money with zero opposition and with the support of their state treasurer. That's what should happen in Connecticut. I see that the treasurer has objections to this bill on feasibility grounds, but the main provisions of this bill have already been implemented in other states. Thank you for your efforts on this issue. I welcome any questions.
Thank you. Thank you for your time and your testimony this afternoon. Are there any questions or comments from members of the committee? Senator Sampson.
Thank you, Madam Chairman. Ron, I just wanted to take a moment to thank you for all of our communication in the past. You're one of the reasons why the bill is before the committee today, and your consistent communication and ideas have been invaluable to me. And I'm going to take a good look at your testimony to make sure that if there's anything else that we can help to improve the proposed bill that we're looking at, I'm certainly going to try and address that with the chairs and see if we can incorporate it into a final bill. But I just wanted to personally thank you for your efforts on this issue. You're with any luck, you're going to end up being able to save many citizens of Connecticut a few bucks, and maybe more than a few bucks in some cases. So thank you very much. Thank you, Madam Chairman.
That is certainly my hope. Thank you for the comments and thank you for your sponsorship of the bill. I do encourage you to take a look at my written testimony. I have 5 areas of concern. My proposed changes, some are very simple. So I hope you'll consider them. I did take a very quick look at the testimony, the written testimony from the state treasurer. I'm sorry to say that I disagree with a lot of it. He raised issues about potential fraud. If you have any questions about that, if anyone on the committee has any questions or concerns about his testimony, I invite you to contact me and get my input. I may send it to you anyway. But some of these are red herrings, in my opinion.
Thank you. Seeing no further comments or questions, thank you again for your time and your testimony this afternoon.
Thank you.
Next, we will hear from Helen Humphreys, who will be followed by Suzanne Allen, who will be followed by Jameen Davis. Helen, welcome. The floor is yours.
Thank you. Chairs, ranking, and esteemed members of the Government Administration and Elections Committee. My name is Helen Humphreys. I'm the Communications Coordinator for Connecticut Citizen Action Group. As my Executive Director, Tom Swan, mentioned, CCAG and its thousands of members have been fighting for a more equitable and just Connecticut since 1971. We're a member of the Connecticut Safe Vote Coalition, Unrigged Bridgeport Coalition, and work with a number of grassroots organizations and activists to bring Connecticut's restrictive voting laws into the 21st century. I've personally worked on voting rights and the democracy reform space for over 5 years. And both in Connecticut, around the country, I've come here today to testify in support of what I would consider to be one of the most important pieces of legislation for voting rights, SB 1226, an act concerning state voting rights and recognition of John R. Lewis. Named after one of the greatest civil rights heroes in U.S. history, the John R. Lewis Voting Rights Act of Connecticut will establish the state as a new nationwide leader in the movement to revitalize American democracy. Decades ago, civil rights activists marched, organized, and died in the fight for Black people to have equal and access to the ballot box. The Voting Rights Act of 1965 was a crowning achievement of their work to ensure fair and equal access to the ballot box. However, over the years, court decisions chipped away at the laws, and in 2013, the Supreme Court gutted the Voting Rights Act. Consequently, several states have enacted voter suppression laws that restrict early access to early and mail-in voting, reduce minority representation, and purge millions from voting rolls across the country. And despite Connecticut's progressive reputation, there are still discriminatory barriers to equal participation in our democracy for voters of color and for people whose first language are not English, especially at the local level. Recently, the Center for Public Integrity observed that Connecticut voters still face some of the biggest obstacles outside of the South. In fact, Connecticut has some of the most restricting voting laws in the nation, with Black and Latino voters facing limited access to absentee and long voter lines. I voted in Suffield and I voted in Bridgeport, and my experiences were very different. Voting in Suffield takes 10 minutes. Voting in Bridgeport, I waited in line for at least over an hour. If you continue to listen to community members, my experiences are not unique. At its core, voter suppression is white supremacy, and this act is a crucial step in the fight against legalized racism and discrimination in our elections. Our federal government has failed to protect the right to vote for so many Americans. So now it's up to all of you to stand up for your communities. The legislature must pass SB 1226, the Connecticut Voting Rights Act, to codify state-level protections for voting rights. Thank you very much for your time, and I welcome any questions.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Representative Mastro Francesco.
Thank you, Madam Chair. Thank you so much for your testimony. and I'm sure you know that, Connecticut has come a long way changing access to voting, right? We have pretty much no excuse absentee voting with our new rules about sickness. Anybody can really use an absentee ballot for sickness. We've just passed early voting. The voters did, so we'll be voting on that policy. Last year, they loosened the requirements to obtain an absentee ballot. So if you're out of work, you're working for the day. So it's not just within those timeframes. So there's been a lot of change here in Connecticut when it comes to voting. You mentioned in your testimony that voter suppression is white supremacy. Can you give me an example of that?
Yeah, absolutely. So when we talk about, first of all, the history of the Voting Rights Act, this was to ensure that Black people had the right to vote in the United States. And that Voting Rights Act, those laws have been repealed at the federal level. And so now we need to make sure that those laws are instituted at the state level to protect Black and brown voters and their right to the ballot box. That in itself, if we don't have those protections in place, as people have said, there are majority Black and brown communities that struggle with long lines. They struggle with the ability to access. We don't have early voting yet. We don't have as expansive as no excuse absentee voting as I would prefer. But there are ways that we continue to suppress the vote of Black and brown voters. And I believe that these codify some state level protections that would keep a system that protects the right to vote for white voters just as much as they do for Black and brown voters.
Thank you. And through you, Madam Chair. So it seems to me that you did mention something about discriminatory barriers. I guess when I'm specific, because you're here testifying in Connecticut, we're talking about Connecticut laws. So can you give me something specific in Connecticut that as a discriminatory barrier or something?
Yeah, absolutely.
And a couple examples, that would be great.
So as I mentioned, I have been a resident of both Suffield and Bridgeport. I've voted in both places. Suffield is a majority white town. It's more rural and suburban. Bridgeport is a majority person of color town or city. The difference in voting is very, very different. I was able to park my car, walk in and out within 10 minutes in Suffield to vote. In Bridgeport, I waited in line for over an hour. It's a majority Black and brown city. It's not an unusual circumstance for people to be waiting in line that long. And I would consider that to be a significant barrier, especially for people who don't have access to a car and have to rely on public transportation, for people who have to work 2 or 3 jobs, for people who have families, people who work outside of their legislative district that they vote in. I think that there's a lot of different ways that it's not going to be overt, right? It's not, people aren't going to put signs up like they used to. It's going to be systematic. And I think that's what this bill specifically targets, is the system as a general election system in Connecticut to make sure that those protections are in place and that people feel like they have a voice when it comes to being able to fight for their right to vote.
So how is somebody waiting in line for a long time? And I get it. Nobody wants to wait in line for a long time. How is that discriminatory though?
I would say because of just the way that the system is set up, those long lines are generally not in majority white towns. And just if you want to look at systematic racism in the United States and Connecticut as a whole, you really have to think about it as a system as a whole.
Right.
You got to think about the fact that there is discrimination within the way that our cities are set up, the way that our towns are set up, the way that our public transportation, all of it all works together to make sure that we need to make sure that we understand those systematic racism issues and that we make sure that we have an election system that acknowledges that and protects the right to vote for people who are people of color.
Well, and I would say that in the cities, they're far bigger. There's far more population and people coming out to vote than the smaller towns, which would be a reason why someone would wait in line longer. Now, should the city, let's say Bridgeport, for example, have you gone down to the register of voters or with the mayor's office or somebody there to complain that, look, you need to find out if you can open up more polling locations so people don't have to wait in line, as opposed to assuming that everybody in the state of Connecticut is a racist, that we're discriminating against people, and every town that has white people in it are privileged. Have you gone down to the Bridgeport and asked those questions?
I have not.
Thank you very much. I have no further questions.
Any further questions or comments from the committee? Senator Sampson.
Thank you very much, Mr. Chairman, and thank you for being here today. I've followed your testimony very closely, and I appreciate a lot of what you said. I don't know if you were here when we've had similar conversation on this proposed bill, and I'm looking for help. And you seem very well spoken on this subject matter, and I'm hoping you can help me. As was mentioned, certainly in the past, there were definitely things that were in the law that were wrong. There's no question about that. And the country has definitely come a long way in trying to address those things and still has a ways to go. And the state of Connecticut is no different. We're working hard every day here to try and achieve that. And I would agree that there are still certain barriers that are significant. I also would distance myself from those barriers since I serve in the minority in a state where I've had very little say over the policy affecting elections over the last 25, 30, 40 years. And I want to see it better. And one of the ways you mentioned, and I think it's the most critical thing that I think people have brought up, is the lines in the cities. I've actually offered that amendment here in this committee and on the floor of the state Senate, and it's been shot down on a party line vote. So I'd just like to make sure that you're aware of that, number one. And I've asked several people who are testifying in favor of this bill, which I'm on the fence on the bill. Certainly the desire behind the bill, the motivation for the bill is something I agree with. And I think everybody would. The question is whether or not the bill actually achieves its stated goal. And that's where I'm really wondering. So let me just ask you a quick question. You said that the Voting Rights Act was gutted. And I presume you mean that to mean the pre-clearance statute that existed prior to that. Is that correct through you, Madam, Mr. Chairman?
That is correct. Yeah.
Okay. Yeah. All right. So that's good. And this bill seeks to restore that kind of pre-clearance policy. I'm just curious, if it was determined to be unconstitutional before, how are we going to manage that now by trying to make it a state law?
I would say willpower of the ability to really understand that these are extremely important issues and that we need to find a way to make sure that people have the right to vote and that they have the right to, come forward and speak out and say, this happened to me, I felt discriminated against in an election, and we need to make sure that moving forward, these specific policies that local governments are trying to put into place are not discriminatory. And so I think just making sure that I understand that your question is about constitutionality, and I am not a constitutional scholar. And so I would leave that more to policy experts, but I would say that if the federal government is not going to protect our voters, I'm looking to all of you to protect our voters.
Well, I certainly can appreciate that, although have you read the decision when they removed the pre-clearance, the Supreme Court decision?
No.
Yeah, you don't know what their reasons were?
Not off the top of my head.
Have you read this bill?
Yes.
Okay, so you do know that it doesn't have anything to do with someone saying I was discriminated in an election. It's about someone, it's about reviewing potential policy before it becomes law.
I apologize. I thought that was what I said, but I must.
Yeah, which is the notion of pre-clearance.
Yes.
The issue I have with this bill is that effectively it sets up several things which I consider to be racist. It sets up this notion that somehow there is something called racial polarized voting. It creates a definition for that. Are you familiar with that?
Yes.
Maybe you can tell me what that is.
Racialized polarized voting, essentially the fact that there are polarizing policies in place that make it so it's more difficult for Black and brown voters to vote instead of white voters, and that white voters have more of more sway or more.
Right. I mean, you've made that point several times, but I mean, as far as the bill goes, we're talking about the bill and you're advocating for the bill, and I'm not trying to put you on the spot at all, but the bill definitely defines racially polarized voting as voting in which the candidate or electoral choice preferred by protected class members diverges from the candidate or electoral choices preferred by other electors.
Mm-hmm.
The thing is, that requires somebody to get inside the head of every single voter and assumes that people vote based by race. And I don't know that that's necessarily true. And I don't know that that's necessarily more true for one race than another.
Yeah, I couldn't speak to that as much as I don't think that we can get inside everyone's head as much as I would say that if this is an issue that the community is speaking about, and this is an issue that was protected and is now not, I would look to the community and what they're saying. And I believe that this is something that the community wants. And so I would support
And
that.
I'm talking to a member of the advocacy for this proposal right now, and that's why I'm trying to do.
Yeah.
Because I agree with your sentiment in your presentation, but I am trying to understand what this bill actually achieves in that goal. I mean, my feeling is that we should just simply have a bill here that eliminates long lines in the major cities. I would think that would be an instantaneous step in the right direction. We could actually achieve something that we can measure, and we could say we did it. We had a victory. Let's do it. I don't know that this bill achieves anything, and that's what I'm looking from someone who's here testifying. You took the time today to come and tell us that this is a good bill. The community wants it. We should support it, and I just don't see how or what it does.
Yeah, absolutely. So I would say launching the plea clearance program that requires local governments with recent records of discrimination to prove that proposed voting changes will not harm voters of color is an important part. I would say expanding language assistance for voters with limited English proficiency is a very important part. I would say creating strong protections against voter intimidation, deception, and obstruction would be an incredibly important part, and establishing a central hub for election data and demographic information that will empower officials and community members to ensure accessible elections are a very big part of that. And so I would say that those specific points are very big issues that I think that this bill touches on. I hope that answers your question.
Yeah, I mean, that's a summary of the bill, and I certainly have that too. But the thing is, the summary of the bill it doesn't actually match with the language of the bill very much. And I guess we're going to have many, many opportunities to talk about this going forward. And I think that, I would just keep an open mind. I would recognize that there are people on this committee who want to do the right thing, and they want to support legislation that achieves the stated goal of protecting against discrimination. But we also don't believe that necessarily the solution to that is to come up with a mechanism to see discrimination where it doesn't exist, or to assume that discrimination exists where it doesn't, or to suggest that somehow if the result of an election cannot be correct based on the race of the people voting or the person who was elected. And I think that's what a lot of this bill does. And it strikes me as shocking to the degree that it goes into that effort, instead of simply recognizing that people are individuals and they're going to make individual choices on who's best for them. And the number one thing I think to most voters, regardless of race, is who they feel is the best candidate. I mean, this country, a predominantly Caucasian country, elected a Black president twice in a row by significant pluralities. I mean, I just don't see the level of racism in our election policy that this proposes to see. And if there are things that we can identify, like the long lines, we should go right at. We don't need, some kind of process to do it. We can all see it with our own eyes that if that is a bad policy, it's discriminatory, we should fix it. But I appreciate you being here, and I hope we can keep the conversation going, because I want the best possible result.
I hope so too. And I think I just want to make sure that when this conversation happens, I hope that there is a larger understanding of systematic discrimination within our country and within our state, and that is always a part of that conversation as well. And so I really appreciate your
and
time
I completely agree with you. I mean, all you have to do is travel to any of our major cities, and you can see that there's systemic discrimination going on. I just would suggest that it's happening from the sources of supposed help are not always helping. Thank you.
All right, thank you. Further questions or comment from the committee? Seeing none, thank you very much for being with us today.
Thank you very much.
Next up is Suzanne Allen, followed by Jameem Davis, followed by Doris Dumas. Is Suzanne Allen with us? Not seen. Jameem Davis. There you are. Whenever you're ready, you can begin.
Great. Good afternoon, Senator May Flexer and Representative Blumenthal and all of the esteemed members of the GAE committee. My name is Jameem Davis, and I'm the co-director of Bridgeport Generation Now Votes. At Gen Now Votes, we're on a mission to strengthen democracy in Bridgeport and increase voter turnout in our local elections. We are members of the Legal Defense Fund's Coordinating Committee and members of the Connecticut Safe Vote Coalition. And we also organize our own Unrigged Bridgeport Coalition. We are here today, or I am here today, to testify in support of Senate Bill 1226, an act concerning voting rights in recognition of John R. Lewis. Sadly, Connecticut has a record of voter suppression. Prior to the passage of the 15th Amendment to the United States Constitution, Connecticut rejected amendments to the state's constitution to strike the word white from qualifications of electors. Connecticut was also the first state in the country to enact a racially discriminatory literacy test for voting, and among the last states in which literacy tests were still in use in the 1950s. It's not a secret that the Federal Voting Rights Act of 1965 has been drastically weakened by the courts. Subsequently, states around the country are trying to pass legislation that threatens Black and Brown citizens' right to vote. Connecticut's restrictive election rules continue to suppress minority turnout today, and legislation that would expand voting rights and cure long-standing systemic obstacles have been met with partisan opposition. It is also no secret that Connecticut's towns and cities are susceptible to vote dilution. In 1994, Black and Latino voters in Bridgeport brought Section 2 vote dilution claims against the City Council's district map. A federal court held that the ability of minority voters in Bridgeport to elect their chosen representatives was inferior to that of white voters, leading to a settlement agreement in which Bridgeport agreed to redraw its council districts to ensure that the city's Black and Latino voters would have an opportunity to elect candidates of their choice. In short, Bridgeport's very recent history of racial discrimination requires that Connecticut voters of color must be protected. The Connecticut Voting Rights Act has two key provisions that I want to highlight. One, a new private right of action against voter intimidation, deception, and obstruction. And two, a pre-clearance program modeled after the Federal Voting Rights Act of 1965. In 2019, our organization helped voters in Bridgeport sue campaign and government officials. Evidence collected during the pre-trial showed that paid political operatives targeted, intimidate, and manipulate some of our most vulnerable voters. That's our elderly, disabled, low-income, Spanish-speaking voters, all for the purpose of controlling their votes. Despite overwhelming evidence, under current state election law, we were granted very limited narrow standing and therefore could not be granted appropriate relief. In that ruling, State Superior Court Judge Stevens said, quote, "The evidence as provided indicates very serious matters and warrants legislative consideration. We believe such legislation considered is in part addressed by the Connecticut Voting Rights Act, and it would grant a new private right of action against voter intimidation, deception, and obstruction. And since Bridgeport officials..."
Sorry to interrupt, your time has elapsed. If you could summarize the remainder of your testimony briefly, please.
Okay, I will. I'll just say no one in Connecticut should come between a voter and their right to vote. And in order for us to really create a truly inclusive, multicultural democracy, we should pass SB 1226. Thank you.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, thank you very much for being with us today and for contributing your testimony.
Thank you.
Next up is Doris Dumas or Dumas.
Dumas,
You'll
thank you.
correct me. Followed by Mackie Dykes. Ms. Dumas or Dumas?
Dumas.
Whenever you're ready.
Yes.
Dumas?
Thank you.
Okay.
Yes.
Thank you.
Thank you to all the members. I am Dory Dumas. I live in New Haven and I am the president of the Greater New Haven NAACP. I am here today in support of SB 1226, an act concerning the State Voting Rights Act for John R. Lewis. A lot of what the previous person said and others have said is why I'm here. The time is now. Connecticut is lagging behind. We need to make this right. We need the strength of this act so that we can protect the voters in our communities. Many of us on this Zoom or in person have the luxury to take time off, to stand in line if they have to, or to do other things. There are barriers to people in our communities, and we need to remove any barrier, and every person deserves the right to vote and to have the access without barriers. And there are barriers. And for people who have the luxury, quite often you need to come maybe into some of the communities and talk to the people who complain and say why they can't vote or why they're not voting. And we just want to make sure that Connecticut steps up, does the right thing. We have the opportunity to strengthen and to expand the access and to make it easier. And we need to do that. The time is now. We are in full support of SB 1226, and we hope that others will see the importance of making sure that this goes through and that it happens now so that the Black and Brown communities will have the access without any obstacles. Again, the time is now.
Thank you very much for your testimony. Are there questions from the committee? Seeing none, we appreciate you being here.
Thank you.
Next up is Mackie Dykes, followed by Kimberly Okiki, followed by Marla Weston. Do we have Mackie Dykes present? There he is. Whenever you're ready, you can begin.
Great. Thank you, Chairman. Chairman Flexer, Chairman Blumenthal, Ranking Member Sampson, Ranking Member Mastro Francesca, and members of the committee. Thank you for the opportunity to testify before you today. My name is Mackie Dykes, and I am the Vice President of Financing Programs for the Connecticut Green Bank. I'm very sorry I couldn't be there in person, but woke up quite ill, so I wanted to spare you my germs. I'm here to testify in opposition to the passage of HB 6903. The Green Bank has strong concerns regarding sections 2 and 3. Section 2 would prohibit construction managers on quasi-public agency projects from self-performing work on such projects and require them to give notice of opportunities to submit bids on project elements on the state contracting portal. This would interfere with a portion of the solar market, particularly in the Green Bank's work with affordable multifamily properties. Because of the way federal tax incentives are structured, many solar projects are financed in a way that makes the Green Bank the owner. Section 2 would, we believe, unintentionally apply to these solar projects. These solar projects are developed and brought to the Green Bank for financing by what could be interpreted as the construction manager referenced in this section. This would prohibit these managers from doing the work on their own projects for their own customers. And with the recent passage of the Inflation Reduction Act at the federal level, government-owned and developed solar projects can now receive a direct payment subsidy from the federal government. This represents a significant opportunity, and this proposed bill would hinder our ability to develop these types of projects and bring these federal dollars to Connecticut. Section 3 would prohibit the Green Bank from working with outside partners through a success fee structure. The Green Bank interprets a success fee as paying these partners when a transaction that they have facilitated is finalized. We believe that the success fee model is a prudent and ideal model for developing many of the clean energy transactions that the Green Bank finances. As a lender, our transactions involve loaning homeowners and business owners money for clean energy projects. In addition to the clean energy benefits that the state receives, these loans are paid back and earn a return for Connecticut electric ratepayers. A success fee model aligns incentives with our partners developing the project and ensures ratepayer dollars are spent wisely. The dollars are spent wisely because no funding is expended unless our capital is also being deployed, which, as I mentioned, earns a return for the ratepayer. For example, our commercial property assessed clean energy program. We've worked with partners who develop projects and bring them to the Green Bank for financing, paying them a success fee only when that financing closes. One partner we work with now has around $18 million in solar projects they're working on. If all those projects close with a success fee of 1% and a hard cap of $40,000 per project, as we've structured the contract, the Green Bank would spend just $113,000 while earning $11 million in income from these projects, more than covering the success fees. This model is ideal because unless those revenue earning opportunities materialize, there's no cost for the Green Bank and for ratepayers. Without a change to this bill, we would have to switch to a structure that isn't performance-based and spends ratepayer dollars.
I'm sorry to interrupt, but your time has elapsed. If you please briefly summarize the remainder of your testimony.
Yep. So as I conclude, I just make note that I've incorporated our suggested substitute language as part of my written testimony, and I thank you for the opportunity to testify before you today.
And thank you. Are there any questions from the committee? Seeing none, thank you very much for being with us today and sharing your testimony.
Thank you.
Next up is Kimberly Okiki. There you are. If I mispronounce your name, please correct me. And whenever you're ready, you can begin.
Yeah, it's OKK.
Sorry, okay.
Senator Flexer, Representative Blumenthal, Ranking Member Sampson and Master Francesco, and members of the Government Administration and Elections Committee. My name is Kimberly Okeke. I live in East Hartford, and I'm a congregational organizer at the Collaborative Center for Justice, a Hartford-based social justice organization sponsored by 6 communities of Catholic women religious. I stand here with you all today to show my support for the passing of the Connecticut Voting Rights Act, also known as Senate Bill 1226. As a member of the Collaborative Center, a registered voter, and a Black woman, the passing of this bill is important to me because I believe it will help eliminate structural and racial barriers that occur for Black and Brown communities when elections are happening. Some of these barriers include things such as lack of language assistance for non-English speakers, inaccessible voting poll locations, unfairly drawn voting districts, lack of investigative resources for voting rights abuses, voter intimidation, and more. These barriers stem from Connecticut's long-term relationship with discriminatory voting practices. Connecticut has always had a history of harmful voting practices dating back to the 1800s. For example, in 1818, the Connecticut Constitution was amended to limit the voting franchise only to white people. In the 1950s, Connecticut was one of the only few states in the US to force registered voters to take a literacy test during the process of voting. This was before it got prohibited by a federal law during the 1970s. Currently, Connecticut's election management practices have resulted in long lines, especially in areas that contain Black and Brown populations. This harmful history of voting practices has made voting for people of color extremely difficult. There are so many other social, economic, and environmental issues in Black and Brown communities that could be addressed through voting. However, Connecticut is denying these communities access to their constitutional right. I believe by the passing of SB 1226, this will reverse the effects of these harmful practices. It will do it by creating a pre-clearance program that ensures changes in voting will not harm protected classes of people. It will provide legal tools and resources to further protect the voting rights of citizens. It would provide a language assistant tools for non-English speakers. It will create stronger protections against voter intimidation, obstruction, and deception, and it will create a central hub for election data. With this being said, I believe that SB 1226 needs to be passed because it will unwind, acknowledge, and rewrite Connecticut's inequitable voting history. I support SB 1226 because there are so many unspoken issues within the Black community today. I support SB 1226 because everyone deserves to have full access to pursuing their constitutional right, regardless of the intersectionality of their backgrounds. I support SB 1226 because I'm a woman. I support SB 1226 because I'm Black. Thank you.
Thank you. Are there any questions? Seeing none, thank you again, Ms. Okeke, for your testimony. Next up is Marla Weston, followed by Ann Minuski. Is Ms. Weston with us? I do not see her on the Zoom. Ms. Minuski, whenever you're ready. Ann Minuski. Is Travis Woodward with us?
Yes, I am.
Whenever you're ready, you may begin.
Senator Flexer, Representative Blumenthal, Senator Sampson, Representative Mastro Francesco, and members of the GAE committee. My name is Travis Woodward, and I'm a resident of Hampton and an engineer in the Connecticut Department of Transportation. I'm also the president of CSEA SEIU Local 2001, a labor union representing over 23,000 state, municipal, Board of Ed, active and retired public and private sector workers. I offer the following testimony in support of SB 1223, an act concerning the State Contracting Standards Board. I submitted full written testimony, but I'm going to abridge my spoken testimony just for the sake of time. Over the years, I have come before this committee many times to advocate for legislation to improve, enhance, and expand the operations of the State Contracting Standards Board. With Connecticut spending over $5 billion on purchase of service and personal service agreement contracts during fiscal years 2021 and 2022, over 55% of which were awarded without competitive bidding, we need the State Contracting Standards Board more than ever. And now with the board finally properly funded and staffed, it is well positioned to deliver for Connecticut taxpayers. The bill before you would further improve the effectiveness of Connecticut's contracting watchdog. With billions of dollars sent to Connecticut through federal pandemic and infrastructure legislation, now is the time to give the board the tools and resources it needs to continue providing the crucial oversight for which it was created. Thankfully, SB 1223 does that. For instance, just to highlight a couple of critical sections of this bill, Section 1 of the bill protects the board's funding. It gives the executive director of the board the responsibility to recommend its funding level and any necessary adjustments to the Secretary of the Office of Policy and Management, or OPM. Instead of being at the mercy of OPM funding recommendations, the board will be able to determine for itself what it needs to do its work. And Section 2 will give the board needed oversight over the contracting of quasi-public agencies. This will bring necessary transparency to these agencies while eliminating any doubt over the board's authority. These two sections will be game changers. After years of the board being underfunded and understaffed, SB 1223 will not only protect the board's funding, but put protections into statute that will ensure it has the funding and staff it needs while given the authority to review the contracting practices of the full scope of state contracting agencies. While we wholeheartedly support SB 1223, we have a recommendation that'll make this legislation even better. We proposed an addition to Section 4E16 of the general statutes. Now that the State Contracting Standards Board is fully staffed, thanks to the bipartisan efforts of the General Assembly, we believe that cost effectiveness evaluations should no longer be filed with OPM, but rather with the board directly. Cost effectiveness evaluations under 4E16 are required by a state contracting agency prior to contracting out work that has been previously privatized. For work that has never been privatized, a cost-benefit analysis is filed with the board. We believe the appropriate recipient of both of these types of evaluations is the State Contracting Standards Board. It would create consistency and efficiency.
Excuse me, sir. I'm sorry to interrupt, but your time for testimony has elapsed. If you could please briefly summarize the remainder of your testimony.
All right. On behalf of the members I'm proud to represent, I encourage you to pass SB 1223 and say no to any efforts to weaken or diminish the ability of the SCSB to deliver accountability and transparency for Connecticut taxpayers. Thank you for hearing my testimony.
Thank you. Are there questions or comments from the committee? Seeing none, we thank you for being with us here today.
Thank you.
Next up is Callie Heilman, followed by Michelle Jacqueline, followed by Liz White. Ms. Heilman, I see you. Whenever you're ready, you can begin.
Hi, good afternoon. My name is Callie Gail Heilman, and thank you for having me this afternoon. I am testifying in support of Senate Bill 1226, an act concerning voting rights in recognition of John R. Lewis. Again, just thank you, Senator Flexer and Representative Blumenthal and the ranking members, Senator Sampson and Representative Mastro Francesco and all the esteemed members of the GAE. My colleague, Jameem Davis, testified earlier, and we submitted written testimony, so I'll keep my oral testimony short. I did want to say, however, that there's very strong current reasons why we need the Connecticut Voting Rights Act. As Ms. Davis testified earlier, Bridgeport officials and partisan actors within our city have a very recent history of discrimination, misinformation, deception, and intimidation. And we believe strongly that the pre-clearance program could mean that Bridgeport voters would be protected from certain changes to voting and election policies before they go into effect. And to bring this question to the forefront and give a concrete example, the legislature and this committee are debating the state's plan for early voting this session. And although the constitutional amendment was passed overwhelmingly by Connecticut voters, the plan for designing early voting is left in your very capable hands. One important question that you all must answer is whether to mandate multiple sites for in-person early voting for towns and cities with large populations like Bridgeport. Currently, the bill language leaves the decision for multiple sites up to our partisan elected registrars. Under that law, as currently written, what recourse will Bridgeport voters have if these officials decide they do not want additional sites? In theory, a predominantly white small town like Westport would have one in-person early voting site, and so could Bridgeport, our largest city, which is 70% Black and Latino. This is why we need the Connecticut Voting Rights Act. No one in Connecticut's democracy should ever feel entitled to come between a voter and their freedom to vote. We urge you to pass SB 1226. Thank you.
Thank you. Are there questions from the committee? Senator Sampson.
Thank you very much, Mr. Chairman. Thanks for being here again. I've appreciated our interactions in the past very much, and they've always been very enlightening. I'm just asking, maybe you could share with the committee maybe an example of how the language that is in the Voting Rights Act bill that we're referring to would maybe correct the issue that you mentioned in the city of Bridgeport. I just think some of us need a little help putting the dots together so we can understand how one thing connects to another. Through you, Mr. Chairman.
Well, I'm not a legal expert on the bill, so I'm not here to, I cannot explain the bill, but I can say that, that in Bridgeport, both in the early 1990s and also, as recent as our 2019 mayoral primary, there is evidence of local partisan actors who exploit rules and regulations around voting, and they target voters based on certain identities. And one of them is their language. So, for example, somebody is a monolingual Spanish speaker, and evidence that was presented at trial that Ms. Davis had referred to earlier showed that these partisan actors, when they went to discuss voting with voters, lied to them about the rules governing absentee ballots in order to basically be able to track and control their vote. So that is going on. We've testified about that, Ms. Davis and I, many times before this committee. And so we know that issues related to voter intimidation and manipulation are happening currently in Connecticut, and that voters deserve, particularly Black and Latino voters deserve protections because there is it's almost like vote dilution and disenfranchisement happening.
Yeah, I appreciate that answer. Thank you very much. Yeah, and I certainly don't disagree with any of the things that you said. I know that we've discussed some of these items in the past, and I appreciate you coming before this committee on numerous occasions to point out cases of wrongdoing in elections, whether it comes all the way to being described as fraud. I will leave that up to you. But to suggest that there's no problem would be wrong. And I completely agree with you. And I know that the city of Bridgeport has had some very questionable elections as far as local primaries and so forth. When you say partisan actors, are you referring to Democrat versus Republican, or are you talking about maybe in a primary election? Because it seems to me that our previous conversations and the things that I'm aware of are more or less exclusively regarding primary elections. Is that right through you, Mr. Chairman?
Well, that's certainly the evidence that we collected prior to 2019, was after the 2019 mayoral primary, the Democratic primary in Bridgeport. But I think that, you know, the issue of, you know, voter exploiting voters and intimidating voters and, you know, the desire to suppress voting knows no party line.
Right. No, I couldn't agree with you more. That's why I didn't understand why you used the term partisan, because it almost sounded like, you know, one political party was doing this against another political party. And that certainly can happen. There is no question about that. But in the specific instances that we're referring to, that didn't happen to be the case. It happened to be a primary election. I don't know. I mean, you started by saying that you couldn't explain the bill to me, so I guess I won't ask you. But that's what I'm hoping for, is that someone comes along to explain the bill to me, because I'm in complete agreement with the folks that have testified in favor of this legislation and the comments that they have made. But I don't see that those comments align with the bill itself. The bill, as far as I can tell, is about determining whether a policy could potentially be discriminatory in the future, which I have no problem with that either. But the mechanism that it uses to determine that, I find completely flawed. And in fact, I find it racist. I will certainly bring that up and raise my objections when the time comes in the committee. I would much rather work with people like you who are concerned about these issues on finding real solutions. So to understand what happened that you're referring to in Bridgeport, and be able to not only pass a law, because I think the things that you're referring to are already a violation of law. So we don't really need to create a law, but we need to have a mechanism to actually prosecute people when they are engaged in this type of activity. And it's got to matter. It's got to stick enough to prevent it from happening again. But I thank you very much for your testimony today, and look forward to speaking again at some point. Thank you, Mr. Chairman.
Thank you.
Thank you, Senator. Representative Hoxha.
Thank you, Mr. Chairman. If I recall correctly, you closed off your opening statement with something to the effect of nothing should ever get in between, you know, a voter and the polling place, probably in reference to or what you may have had in mind, and correct me if I'm wrong, it's part of the question that I'm asking. Did you have some sort of like governmental institution in mind as that potential thing that could get in the way between a voter and, you know, the polling place, if not for the passage of this bill? And if so, can you name me an instance of, you know, a governmental institution, you know, in the modern age being able to get in the way here in Connecticut, get in the way of a voter from voting?
Sure. I mean, I think that there's a lot of examples of government getting in the way of the access to the ballot, you know, both in the United States in our history, but also just baked into Connecticut law, right? Which is why we have to come before you all and advocate for expanding access to voting. And so, you know, the way that voting is laid out in our Constitution required that we had to amend our Constitution to allow for in-person early voting. That's one example of an incredibly high hurdle placed between voters and the access to the ballot. And we know that the voters that are most impacted by these hurdles are voters who have historically been oppressed by the United States government. So it is first and foremost Black voters, and then it is voters for whom, language access has always been a problem, and so forth. So, there's no shortage of examples and even very recently of federal and state government and city government coming between voters and our access to voting.
Well, through you, Mr. Chair, I mean, I would argue that there is a shortage of examples because I gave you an opportunity to name me some and you didn't really give me any examples. So I'll rephrase the question. It is the year 2023. Short of passage of this bill, is it your belief that there are institutional forces at play that are preventing people from voting today in the state of Connecticut?
Sure. Well, I just gave you one example from, the debate that you're having in the legislature right now about multiple, like whether to mandate multiple early voting sites in towns and municipalities that have a population of over, like, let's say 50,000 people. That is you all deciding who and how and when people get access to in-person early voting, which the voters of Connecticut overwhelmingly approved. If you choose not to mandate multiple sites in large cities, you are effectively restricting the access to the ballot for people who live in large cities. And in Connecticut, the people who live in large cities are predominantly Black and brown individuals, voters. So that's one very concrete example that is happening right now, currently in the legislature.
Okay, well, I appreciate you, being able to come up with a type of example there. And through you, Mr. Chair, just, one last sort of, remark here. It's easy to continue to move the goalposts further and further away from this kind of abstract goal of, making it easier, infinitely easier for voters to vote. I've worked on campaigns, statewide campaigns. I've been to virtually almost every single town or city in the state of Connecticut, including the Bridgeports, New Havens, Hartfords, Waterburys. And, it really doesn't seem to me, at least from what I've seen, that this issue really, exists to this extent that that it seems that you're making it out to be in support of this bill that you argue is a remedy to this issue that I personally don't see. We recently passed via referendum the ability for the legislature to legislate an early voting kind of procedure. And prior to that, it seems like you're saying to me that anything prior to the next kind of advancement we make was a sort of oppressive system that we had in place. So it just seems to me that there's really no kind of clearly defined objective to this bill or the argument at large, because it just seems like the goalposts are always continue to move, no matter how many good faith attempts anyone makes at alleviating some legitimate concerns, which, like Senator Sampson brought up, the issue with, potentially long lines and things of that nature that have tangible remedies, which I'm all for in instances where it could be shown clearly that is an issue. So I appreciate, you offering those examples and, the example of, how, language could be a barrier for some voters and that, having signage in different languages and things like that can make it easier for people to vote. But I just really don't see this, the way you see it. But either way, thank you very much. And back to you, Mr. Chair.
Thank you, Representative. Are there further questions from the committee? Seeing none, thank you very much for being with us today and contributing your testimony, in addition to all the work you do in Bridgeport to ensure that everyone has access to the franchise. We appreciate it.
Thank you.
Next up is Michelle Jacqueline, followed by Liz White.
Distinguished members of the GAE committee. My name is Michelle Jacqueline. I'm the legislative co-chair of the Connecticut Council on Freedom of Information. And I'm here today to speak in opposition to Raise Bill 1220 and Section 1D of Raise Bill 6912, and to express our concerns about the language in Senate Joint Resolution 42. I have submitted lengthy testimony, which I urge you to read. And you've also heard today from Colleen Murphy about her reservations about the 1220 and 6912, including her explanation of the unwieldy nature of 6912. So I won't repeat any of that, and but I would like to make some points in the next couple of minutes. Concealing the addresses of classes of public employees, federal, state, and local, has become something of an annual exercise of this committee. And each year, CCFOI and the FOI Commission has come and testified in opposition, yet each year the list continues to grow. And I would just like to point out that these laws accomplish almost nothing, but they do promote a false sense of security. And I'd like to give you an example. I have served as an assistant registrar of voters in my town of Glastonbury for the last 8 years, so I would be covered by 6912. So as an experiment, I put my name into a Google search with the letters CT. And what I found was not only can you find my address on the internet, and by the way, I'm not somebody who has a presence on social media. I don't do Facebook or Instagram or anything like that. But not only could you find my address, but you could find my previous address, my age, my political affiliation, family members, the addresses of some of my family members, my work history, some of the boards and commissions I am a member of, et cetera, et cetera. And for a small fee, somebody could also look to see whether I have a criminal record. Fortunately, that would be a waste of money because I do not have a criminal record. But my point being that that the horse is already out of the barn. Continuing to do this to conceal the addresses of public officials accomplishes almost nothing, as I said.
Ms. Jacqueline, your time is elapsed. If you could summarize the remainder of your testimony, please.
Okay, sure. I would just say that on the Joint Resolution 42, we find the language to be very confusing with the addition of the right of additional privacy. And if the intent of this committee is to guarantee a woman's right to reproductive freedom, that the resolution should probably be written to say that and not confuse the issue and open a can of worms by including the right of individual privacy. And I will stop there. And thank you for your consideration.
Thank you for your testimony. Are there questions from the committee? Seeing none, thank you very much for being with us today.
Thank you.
Next up is Liz White. Followed by Anna Brugman.
It's red. Okay, it's on. Okay. Hi, everyone. Thank you to the Government Administration and Elections Committee for calling this important hearing, and to committee co-chairs Senator Flexer and Representative Blumenthal, and ranking member Senator Sampson and Representative Mastro Francesco, for hearing my testimony, and also to the other committee members as well. My name is Liz White, and I'm the publisher, executive vice president, and 5th generation family owner at Record Journal Media Group in Meriden. And we cover 100% of the homes in 9 towns in central Connecticut. And our company is an innovative, audience-focused news organization with a rich history as a 156-year-old family-owned company. We are committed to providing quality local journalism and fact-based reporting that informs and empowers our community. I'm here to endorse HB 6347, an act concerning the purchase of print and digital advertising by the state. Directing state advertising dollars to Connecticut-owned news organizations that have significant local and regional reach within Connecticut would help support sustainability of trusted local journalism in Connecticut that our companies want and need. State advertisements and all of our products would help the state achieve its marketing goals, and it would be budget neutral, while also supporting our media, our news organizations. We have delivered proven marketing results throughout our history for local businesses and nonprofit organizations. Our local, regional, and targeted marketing is extremely effective for providing results to businesses, nonprofits, and organizations. As evidence, we have submitted 38 written testimonials from businesses and nonprofits who have advertised with us, describing the positive results from our marketing. All of them, actually, I'll read 2 of them quickly here. And like I said, the rest I've submitted in writing. Barbara Gibson, owner of Super Soup, said this advertising helped bring awareness to my brand. The well-placed ad in the Record Journal generated new customers, and the optimized website that was built has brought a fresh way to increase website traffic. The outcome has been beyond my expectations. All in all, a much needed connection to my potential customers has been achieved. Success. And then the second one, really quickly, is Rose Servetnik of Silver City Strategies. And she said, this advertising was tremendously helpful in growing my business. It helped me take on new clients, and I'm extremely grateful for this opportunity. In closing, I urge the Committee on Government Administration and Elections to submit a favorable report on HB 6347. It will not only help my company and other Connecticut-owned news organizations in the communities we serve, but all Connecticut communities. Thank you very much.
Thank you. Are there questions from the committee? Seeing none, thank you very much for being with us and contributing your testimony.
Thank you.
Next up is Anna Brugman, followed by Valencia Richardson. I see, it looks like we have Ann Minuski back, so you can go after Ms. Richardson. Ms. Brugman, whenever you're prepared.
All right. Hello, my name is Anna Brugman. I'm the policy director at Rebuild Local News. We're a coalition of more than 3,000 local newsrooms across the United States. All day, every day, I think about how to support the local press via public policy, which is why I'm here to support HB 6347, which would allocate a portion, as y'all know, we've been talking about it. My friends Liz and Bruce already gave you the specifics of how this would work in Connecticut. But I just want to underscore a couple things that we've already talked about. One of those things is the third party. So as this policy has been implemented in New York City, it's also been adapted in Chicago. I get called about it every day. In other cities, I'm really interested in Connecticut because it's at the state level, which I think where it could be incredibly transformative and use state funds more efficiently to reach Connecticut residents. And to do that, it's kind of like a 3-legged stool of a policy, which is why it's really smart way Bruce is already thinking of it this way. If you have publishers, you have the folks who would receive the advertising, you have the government, and then you have a third party that kind of acts to make sure that this is happening efficiently, that it's happening effectively, and it's maintaining the independence of those news organizations. I also want to underscore the importance of independence of this case. We've kind of discussed it earlier during Bruce's testimony, but I want to say that I'm a former local journalist. I don't want to put any journalists in a position where they are having to undermine their independence in order to appropriately serve their communities. And you can implement this bill in a way that maintains journalism independence by setting up during implementation, not so much in the actual writing of the bill, a series of qualifying factors. You can work with your local community members to make sure that this doesn't undermine independence. And we've actually seen this work in New York already. And we also saw the effectiveness of this policy in New York. When New York mandated that 50% of 50% of these advertising dollars be spent in community media, Some agencies went above that and even went to 80, and they maintained it for 2 years. And New York City measured this very detailedly, so you can see it in their reports. Some agencies spent their 50% and thought they'd be better served by other means, and they spent it with other means. But other agencies, particularly, I believe it was Health and Human Services, spent 80+% of their advertising budget in local media. So again, my friends Liz and Bruce, many folks who have submitted written testimony have already gone into detail about how this would support Connecticut communities. They will say that better than I can as an out-of-towner, but I just want to speak to what I believe could be a very efficient and effective way to support Connecticut local media, which is ultimately supporting local democracy in Connecticut. So I'm here to support 6347, and thank you for hearing my testimony.
Thank you very much for your testimony. Are there questions from the committee? I have one, which is you mentioned, first of all, did you submit written testimony?
I did, yes.
Did you you mentioned some studies from New York? Were those included in the written testimony?
They were not, but I am happy to follow up with them. If you go to Center for Community Media at City University of New York, they did a baseline case study, I believe in 2013, that established how much funding was going to local media, and what they found was not a lot. Much of it was going to folks like the New York Times. And when I say community media in New York City, I mean like neighborhood specific square block radiuses of local media. And they still, when they implemented this policy, found that that was an effective way of reaching New Yorkers. And then the other two pieces were the other two studies, excuse me, were to measure its efficacy. And they were one of my favorite lessons from New York. I really like this policy, guys. One of my favorite lessons from New York was that they were able to show who got the money. And when they, in the first year, realized that some qualifying newsrooms weren't, they went to them and asked why. And in the second year, they did it again. And so they're so detailed, which I think provides folks who are like you, who are interested in scaling this policy up or sideways or down. It gives y'all such a roadmap to understand how to implement the policy, as well as how to improve it. Frankly, no policy is perfect. And so if you're taking another run at it, why not make it better?
Well, thank you very much for being with us today. And if you could send those studies to us or a link to them, that would be terrific.
Absolutely. Thank you all for hearing me out. Have a good one.
Thank you. Next up is Valencia Richardson, followed by Robert Hale, followed by Ann Minuski, followed by Robert Hale.
Good afternoon, members of the committee. My name is Valencia Richardson, and I am legal counsel for voting rights for the Campaign Legal Center, a nonpartisan organization that defends and promotes voting rights and also successfully settled the first case brought under the Washington Voting Rights Act. I am testifying today in support of SB 1226, a bill that would benefit local governments and voters alike by making it less costly and less burdensome to enforce voting rights for communities of color. And as I explain in my written testimony, the provisions of the Connecticut Voting Rights Act improve upon the Federal Voting Rights Act. They are based on lessons learned from decades of lawsuits under the federal VRA. First, the CTVRA contains provisions that encourage voters and local governments to work together to remedy potential violations before resorting to expensive litigation. Before they can file lawsuits, prospective plaintiffs must send local officials written notice that their voting rights have been violated and give them time to proactively fix things. The bill also provides for cost reimbursement for those pre-lawsuit notice letters, since they often require community members to hire experts to perform expensive statistical analysis. And these expenses shouldn't discourage people from enforcing their civil rights. SB 1226 also streamlines the process for determining whether a community of color has been denied the right to vote. It clarifies which communities are eligible to bring these claims, establishes the different types of proof they can provide to demonstrate how voting systems or procedures can discriminate against people of color, and sets out practical guidelines for courts to assess whether the community has been denied an equal opportunity to participate in the political process. SB 1226 will consistently make it easier for courts to interpret state and local election laws. It provides a clear standard to determine whether an election law denies or impairs a disenfranchised community's access to the ballot. It specifies that whenever possible, courts should interpret state and local election laws in favor of protecting the right to vote. And it empowers state courts to consider a wide range of locally tailored remedies and choose the one that's best suited to help the impacted community, which corrects an egregious flaw in the Federal Voting Rights Act that has led to courts to defer to the remedy proposed by the government body that violated that community's voting rights in the first place. If enacted, a Connecticut Voting Rights Act would be a critical tool that goes above and beyond the Federal Voting Rights Act to protect voters of color from discrimination and help make the dream of truly inclusive and equitable democracy a reality. We urge you to support SB 1226 and thank you for your time, and I'll answer any questions that anyone may have.
Thank you, Attorney Richardson. Are there questions from the committee? Senator Sampson.
Thank you, Mr. Chairman. Thank you, Counselor, for being here. You probably have heard some of the back and forth that we've had with other witnesses that are here in support of this legislation. And you probably heard me say that I certainly support the intent of the legislation, which is somewhat ironic considering the actual words that are in the bill. I guess my concern with this is and to be totally honest with you, I'm operating mostly based on my recollection of the bill that we had in this committee last year. I think it was Senate Bill 471, and I've only just begun to really kind of go through this language, and I'm really focusing on Section 2 more than anything else. I don't know how well you know the language that is in the bill before us, but I guess the concern I have is that I totally agree with the way this all starts out. Like Section 2 starts out and says, no qualification for eligibility to be an elector or other prerequisite to voting may be imposed. No ordinance, regulation, or other law regarding the administration of elections may be enacted, and no standard practice, procedure, or policy may be applied in a manner that results in an impairment of the right to vote for any protected class member. Agreed. We all agree with that. I think that's beyond question. But then it gets into the way this will happen, and I just can't believe what I'm reading here. Maybe you can start by helping me understand this concept of racially polarized voting as a start. And I'll just share the definition that's in the bill, which says means voting in which the candidate or electoral choice preferred by protected class members. And I assume that means the definition in protected class above that, which is people who are referenced as a race, color, or language minority group, diverges from the candidate or electoral choice preferred by other electors. I think that merely that definition assumes that people are voting based on race. And I think that applies to everyone as well. They're suggesting that Caucasian people are going to prefer a Caucasian candidate. And I think it says that minority voters might prefer a minority candidate. And I don't think that's true. And I think that's an assumption that's made throughout this bill. And am I misunderstanding what racially polarized voting is and how it's used in this bill is my question. Through you, Mr. Chairman.
Yeah, and so if I may, I'd like to answer your question in two parts. So the first part that I heard was the question about intent. And I'd like to just make a note that if there was evidence of intent in any sort of election procedure or practice, that would certainly be covered by the provisions of this act, both implicitly and explicitly in certain parts of this bill. And so just wanting to keep that in mind, but also racially polarized voting, you mentioned the definition, actually a racially polarized voting analysis. And I, just like my colleague Stephen earlier, I am not a PhD in statistical analysis, but as a litigator who has used racially polarized voting in voting rights cases, I can explain to you from a legal perspective and a lay perspective. Racially polarized voting does not assume racial preferences as an initial part of the analysis. It actually does the opposite. It doesn't look at all it doesn't assume anything at all with respect to if racial minorities vote a certain way or racial majorities vote a certain way. It actually answers that question. So if there is racially polarized voting, that means the answer is that that divergence has occurred. If there is no racially polarized voting, then that means that there's not an evidence of that divergence. I hope that makes sense. But in just as an initial matter, racially polarized voting analysis does not begin with that assumption whatsoever. It looks at the history of elections by precinct. It looks at the history of the racial demographics of those precincts, and then it draws those conclusions based on electoral histories, and then it tells us whether or not racially polarized voting has been occurring or has occurred.
Well, I appreciate that answer, and that is somewhat helpful. I do want to point out that the reason why I said that it was ironic about intent is because in section B of that same section 2 that I was referring to, subsection B, it says, in determining whether racially polarized voting by protected class members in a municipality occurs, you go down to subsection V and it says, shall not require evidence concerning the intent of electors, elected officials, or such municipality to discriminate against protected class members. And I understand why, that it's more about the results. And I get that that's what we're at here. But I don't know that you can determine anything by the results of an election unless you were able to interview every voter and find out what their actual reason for casting a particular vote is. And I think that that's the flaw in this legislation, is it assumes racism where I don't know that it necessarily exists. As I had pointed out before, you know, this is a predominantly Caucasian country. I don't know what the statistics are, at least 60%, maybe much higher than that for all I know. But yet you would assume if that was the case, and that Caucasian people prefer a Caucasian candidate, then Barack Obama would not have won election twice as president of the United States, but he did. And I'm sure the converse is true also. And I mean, I think you can look around all over this country, and particularly when it comes to concentrations of minority voters in urban cities, even here in Connecticut. I mean, there are plenty of Caucasian or Hispanic people elected to office, as well as African Americans. I think there's a blend of people, and I would suggest that they choose their candidate more on the politics of that person than they would on their skin color. I mean, am I wrong about suggesting that that's what this is all about? Is that there's a suggestion that we have to combat the problem that people are making a vote based on skin color versus qualifications? Because I will tell you, most every Democrat person I know is going to vote for the Democrat over the Republican, regardless of the race of either party. And the same would probably happen for Republicans as well. So, I mean, I don't think that race is that important to the decision making that people make for elections. But anyway, I don't want to monopolize the conversation. I'm really just trying to get an answer from you, so I understand. That seems to be what this bill is trying to combat, which is racially polarized voting and people choosing candidates by skin color and the game being rigged, so that's who they end up with. Is that correct through Mr. Chairman?
I can answer this in several parts. So I'm going to try to be concise. But I'd point out a few things. So with respect to racially polarized voting, for example, you pointed to the election of Barack Obama. That election is actually a pretty exemplary example, sorry to be repetitive, exemplary example of racially polarized voting that is used in most racially polarized voting analyses, because the election of Barack Obama was extremely racially polarized. It did not mean that he did not win elections, but it does mean that there was evidence of an extreme divergence between voters of color and most white voters in those elections, such that racially polarized voting occurred despite his victory. And it doesn't, and I think I would caution, a conflation between racially polarized voting and just and liability under the particularly section 2 you're referring to, and point out section 2 of this act actually mirrors Section 2 of the Federal Voting Rights Act in many ways, but it improves upon it. And one of the ways it improves upon it is by providing a very holistic, explicitly holistic approach in identifying if a system or a voting practice or procedure has the effect of discriminating against protected classes of voters. And one of those things includes RPV, but you see in later sections, including in section C1, there's an entire totality of the circumstances analysis, which includes many different factors, which would go into understanding whether or not a system is discriminatory. So the history of discrimination in a jurisdiction, the extent to which protected classes suffer from the effects of discrimination, and things of that nature that all go part and parcel with the actual discrimination of the entire of the election system at issue, or the voting practice or procedure at issue. And so it's not about the analysis of racially polarized voting. Two things: it doesn't end the conversation about how a system discriminates against voters, but it also does not, we can't conflate it with other parts of the bill.
I appreciate that answer. You started by saying that, you mentioned the word liability, like whether or not you'd be liable under this bill for committing the crime effectively of discrimination in setting up a election policy that is discriminatory. But what really surprised me is reading in section B and section C of section 2 that there are many factors that are restricted, that cannot be taken into consideration, and I'll just name them. I already mentioned that they cannot consider evidence concerning the intent of electors, or elected officials, or the municipality to discriminate against protected class members. To me, I think that's the number one thing that you would want to consider, is if that was what the intent was. Number 2, shall not consider evidence of explanations for voting patterns and election outcomes other than racially polarized voting. Well, what if there were many other reasons why people chose a particular candidate? One of them was better on foreign policy, and we were potentially going to be in a war, or God knows what the reason might be. And then the next one says, shall not consider evidence that subgroups of protected class members have different voting patterns. And it goes on. There's other things too. I've never seen a situation where so many things directly related to the issue at hand were excused from being considered as part of the conversation. And then I certainly listened intently to what you were saying about the totality of circumstances issue, which I can certainly understand the desire to. But if I read through this, these things are not relevant. The history of discrimination may play a factor in the world we live in today, but I don't know that it has a factor in determining whether someone's committing a particular act or policy that's implemented today. B, the extent at which the protected class members have been elected to office. This is like, the chicken or the egg thing. It's like, well, we're saying if not enough people of a certain skin color were elected to municipal office already, that is proof that there is discrimination going on, and therefore that's evidence of the total picture. So therefore we have to assume. I think this policy, well, I get it. No one wants discrimination. We want people to be treated equally in this country. We want people to be judged on their merit and to be afforded every opportunity. I just feel like this bill goes very dangerously down the road of looking for discrimination and racism where it may exist or may not exist, but the factors that are used to determine it here, I think, are somewhat predisposed to being racist themselves. Because if you're going to suggest somehow that you have to assume something called racially polarized voting exists at all, you're implying something that you cannot verify. And I'm not putting this on you. When I say you, I'm talking more globally. I really appreciate you being here and trying to fill me in. Is there anything that you can say to me to get me to a better place where I understand that the intent of this is absolutely to prevent bad policy from being implemented that might effectively discriminate against any particular population. Because I'm not seeing it. What I'm seeing is a mechanism that will look for racial discrimination where it may or may not exist simply based on the results of an election. And I think that people don't vote by race. I really don't think they do. So anyway, that's my question, Mr. Chairman, and I'll leave it at that. And I hope we can have many more conversations to work on and craft the best possible voting rights bill that we can. Thank you.
Thank you. And I was writing down notes because I wanted to make sure that I addressed every part of your question. And so I think I'd start by saying, but by libel, I apologize for legalese. There's no crime that has occurred under Section 2. It's about, again, providing solutions to racial discrimination. So there's no criminal liability whatsoever. But then again, both the totality of the circumstances and the racially polarized voting analyses is essentially, that's exactly how you analyze a claim under the Federal Voting Rights Act. The difference here, what makes it better, is that it's actually explicitly written out instead of what occurs at the federal level, which is just a murky mess of federal case law. Under the CTBRA, it's clear to courts what exactly is supposed to be analyzed, and this has been an analysis that has been endorsed by the Supreme Court since approximately 1982. So this is decades, and this is even in most recent Supreme years, as the Supreme Court has changed the analysis. The Supreme Court has not endeavored to change this particular analysis. So it's actually quite standard. It's the results test that's laid out in the CTBRA is better because it's clearer, but it's also not unusual in both federal law and in the law reflecting other states that have passed similar voting rights acts. And then I would say, just reiterate that RPV is not assumed. Again, racially polarized voting only occurs after you've determined that divergence has occurred. It's not, if there is no divergence, then there's no RPV. And so we can't, neither of these tests assume anything except it asks if those conditions exist. And if those conditions exist, then racial discrimination has occurred, and that's simply the test. It actually does it attempts not to assume anything about the conditions of the voter. But I'm also happy to elaborate more offline or here in graph.
All right. I think maybe hopefully we can clarify a couple issues. I have a couple questions. So I wanted to ask you a little bit about the concept of racially polarized voting, and I'm going to try to summarize it, and you can tell me whether I've done it accurately. Based on your description, it sounds like, first of all, whether racially polarized voting exists in any particular case is based on statistical analysis. Is that fair to say?
That's absolutely correct.
All right. And so we're not actually looking into the hearts of individual voters. What we're doing is looking down, drilling down to the smallest geographic level we can, looking at the demographic data of, say, a particular precinct or particular precincts across the municipality, and saying, is there an uncommon alignment between a precinct's concentration of voters of color and that precinct's choice of candidates? Would that be fair to say?
But yeah, that's more or less correct, and again, neither of us are statisticians, but yeah, that's more or less correct. You go down to the precincts level, who did most people in that precinct vote for, what is the demographics of that precinct, and you can make educated inferences from there. And then there's also an entire part of the analysis that is probably past my pay grade to explain, but yes, that's more or less correct.
All right, I appreciate it. And would it be fair to say that in general, there's no assumption that racially polarized voting exists. That in general, it may be the case that there is no specific correlation between a precinct's concentration of voters of color and their choice of candidates. Is that fair to say, or their choice of candidate?
Yes, it's certainly possible that racially polarized voting doesn't exist. Yes, so I'll just stop there.
Yeah. So, but in a particular municipality, in a particular situation, a particular time, for whatever reason, we don't know that today, there may be a very strong correlation between certain precincts with high minority concentration and a particular candidate, and there may be particular precincts with a high concentration of non-voters of color or non-white voters, essentially, and another candidate. Is that accurate, more or less?
Yes, and I think, yes. And then I'd also just add that this is apart from the results of the election itself insofar that a candidate won. So just like bringing back the Obama example, just because Obama won doesn't mean that race wasn't extremely racially polarized. It was extremely, we know that 95% of Black people, for example, Black voters voted for President Obama. And we know that something like 60+% or more of white voters voted for the Republican candidate, or so I guess McCain and then Mitt Romney. And so but in both cases, President Obama won. So we also need to like make sure that nuance exists as well.
Okay. And so it sounds like racially polarized voting would only exist in particular situations where, for whatever reason, there is just a high correlation, a correlation higher than one would expect normally for the community between the race of the voters in a particular precinct and their choice of candidate. And there may be history there for why that is. There may be certain other factors that are in play, but basically what we're looking at when we're looking at racially polarized voting is a high correlation between a voter's race or other minority category and their choice of candidate, one that's out of the ordinary generally, and that is essentially determined by the statistics of voter preferences in particular precincts, or not necessarily precincts, but geographic areas.
Yeah, and it's typically like starts at the precinct level and goes to the whatever the challenged jurisdiction is, but in general, correct. And also just to reinforce that, courts are not going to find that racially polarized voting exists unless it's very significant.
Okay. And it sounds like from reading through the bill and from your testimony and the testimony from some other folks that the primary thrust of the bill is to prevent dilution of minority voting power or voting preference in those sorts of situations where there is racially polarized voting. So for instance, if there were a city that were 55% white and 45% Black, just to oversimplify things dramatically, and there was racially polarized voting, so a high correlation between white voter preference for a particular candidate and Black voter preference for another candidate, there's a concern that you have a situation where if there's an at-large system, meaning everyone was elected by the entire voting population in the legislative body, you could have 10 legislators at the local level who end up being the white preference and none from the Black preference. Is that really the primary concern of this element of the bill, would you say?
Correct. That's exactly right. At-large voting plus the existence of RPV, and then or the existence of conditions which are under the totality of the circumstances, and we sort of went over what those were, like a list of those that show that the system is operating to dilute the votes of minority voters and prevent them from electing the candidate of their choice.
And so then the remedy in that sort of situation that the court would order would not be necessarily money damages or that sort of liability. It would be essentially having the municipality institute a different system, probably a district system, that would allow the democratic preferences of the municipality more generally to be more accurately represented in their legislature. Would that be fair to say?
Absolutely. And that's assuming we even get to litigation, because one thing that the CTVRA has that the Federal Voting Rights Act does not have, which is an incredible feature of state voting rights acts, including this one, is the notice period and the ability for plaintiffs to negotiate with the municipality before we even get to court on a remedy that best suits the community. But assuming we don't get to, we make it past the negotiation phase and we have to go to court, the court would have to order a remedy again that best suits the community, and then also require public notice, another feature of the CTVRA that doesn't exist in the Federal Voting Rights Act, public notice requirement and the requirement that the public participate before any remedy is implemented.
And so I guess if in this particular scenario, it was an at-large system and they got a notice that they were going to be sued, they could say, well, actually, we'll institute a district system, and then conceivably the preferences of the Black voters in this hypothetical oversimplified municipality would be reflected, something closer to the 45% of the population that they represent. Would that be fair to say?
Correct. They would be required to implement a map together, and then that better reflects the conditions of that community. And then the municipality would receive a safe harbor period from legal action if the municipality is acting in good faith and implementing a solution before we even get to litigation through that notice period.
Well, thank you very much for your answers to all my questions and all the amplifying information as well. You've settled the rest of the questions at the committee, so we appreciate you being with us here today and contributing your testimony.
Thank you so much.
All right, thank you. Next up, we have Ann Miniski, followed by Robert Hale, followed by Joel Fishman. Ms. Miniski, whenever you're ready.
Thank you. Chairman and members of the Government Administrations and Election Committee. I am here to testify in regard to SJ 42, SB 379, and HB 1226. The Connecticut Republican Assembly is an organization which has members and friends, very diverse group, totaling over 500 Republicans and conservatives across the 8 counties of Connecticut. We stand firm in our principles and unalienable rights under the U.S. Constitution, as well as the rights and responsibilities within the Connecticut Constitution. I'm Ann Miniski, a resident of Connecticut for 25 years, former professional counselor and current president of the Assembly. Our Assembly holds fast to our principles and that of the sanctity of life. This is in opposition to SJ 42. We believe that the preborn child from conception to the end of natural life is a human being possessing the same unalienable rights as all other people and entitled to the full protection of the law. So I am firm no on adding SJ 42 to the Constitution. In regard to 1226, an act concerning state voting rights, I am testifying against this. I was kind of concerned on the alternative methods of election and racially polarized voting. And after hearing the young woman before me speak, I don't understand why we are discussing something that hasn't been proven as a problem in our society. We are in Connecticut. We are trying to, with the new election laws, provide additional ways that people can vote. And other than hearing about the long lines and possibly proper ballots for Spanish-speaking communities, I don't understand why there's problems there. And the third bill I am testifying on is in regard to an act prohibiting the use of private funds by the state and municipalities for election administration purposes. This is sorely needed. We've had outside funds from Center for Tech and Civil and Civic Life, also known as Zuckerbucks. So outside funds coming into our state and influencing elections. I'm wondering, there's notes on $331,000 that Hartford had accepted, and there's no sign of the funds being received or spent. So whatever happened to that money? And also right now we have a problem in the town of Greenwich where it seems like there's some of the citizens are upset about having Zuckerbucks added and other people who do not want it. So this seems like a bill that is in serious need of being approved. Thank you.
All right, thank you, Ann. It's good to see you. Are there any questions from the committee? Seeing none, thanks again for being with us.
Thank you. Have a great day.
You too. Next up, we have Robert Hale, followed by Joel Fishman, followed by Carol Rosello. Is Robert Hale with us? Oh, there he is. Whenever you're ready, you can begin.
Pardon me. Can you hear me?
Yes.
All right. Thank you. Thank you, Senator Blumenthal, Senator Flexer, and members of the committee. I'm Robert Hale. I'm an attorney in Glastonbury, and I'm testifying in opposition to SJR 42. I did submit written testimony Friday night. I typed it into the website, and then I did not see that come up by last night, so I added another written testimony, which is much longer, more well-researched. But I'd like to just supplement that testimony, both of those testimonies right now, and I'm sorry about the redundancy. First of all, I oppose this bill on legal grounds because it is deceptive and vague. Both the language of the ballot question is totally innocuous, does not even refer to abortion at all, when that is certainly the underlying purpose of this amendment. I think it's disingenuous and frankly shameful to try to keep our voters in ignorance by not informing them in the ballot question of what this bill is all about. Secondly, the language of the actual amendment further uses deceptive language and talks about the decision to continue or terminate one's pregnancy. This is mealy-mouthed language that the intent is totally deceptive. This is not ending one's pregnancy. This is about terminating another human life. And I would simply ask that if this legislature is going to legislate in this area, that it be honest about it and treat the voters with a little bit more respect. Further, the idea of inserting a right to privacy in our Constitution, it's a very complex matter, goes back to Griswold versus Connecticut, 1965, which was used as the basis for the now repudiated Roe versus Wade decision. It's very dangerous language to insert such a right into our Constitution without full debate. It is extremely dangerous. And what it would do is it would give power to the courts, take power away from the people and give it to the courts to govern these very, very important matters. This process should be kept in the legislature where it's open to debate. Our current law does guarantee the right to an abortion before viability. If the legislature sees fit to change that that law either to further protect preborn life or to liberalize the right to an abortion, so-called, right? It may do so. But to take that power away from the people and give it to the courts is extremely dangerous.
Excuse me, Attorney Hale.
Further,
I'm sorry to interrupt. Your time for testimony has elapsed. If you please briefly summarize the remainder of your testimony.
Yes, there is another bill before this legislature. It's in the Public Health Committee. It is far more straightforward. I don't agree with it because it proposes another constitutional amendment, but it is before the Public Health Committee. I think it's SJ4. I'm not certain. It says, shall the right to an abortion be placed in the Connecticut Constitution? I would ask this committee to scrap this bill and go forward, if you're going to go forward, with a much more straightforward and honest bill that informs the people and treats us with more respect. Thank you.
Thank you. Are there any questions from the committee? Seeing none. Thank you for being with us. Joel Fishman, followed by Carl Rizzolo, and then Susan Fernandez. Is Joelle with us? I do not see her. She here? Or no? Oh, never mind. Oh, so Carol, you're up. Whenever you're ready, you can begin. I see you there on the remote.
Thanks, and thanks for the opportunity to testify. My name is Carol Rizzolo. I live in Guilford, and I am the lead coordinator of Shoreline Indivisible, Safe Boat Connecticut, and the CT coordinator for Center for Common Ground. I'm speaking in support of SB 1226. My personal life is consumed with voting advocacy work on behalf of those whose voices who have too often been silenced. What drives me is actually my Jewish faith. Tikkun olam is a Hebrew phrase that I've known since my earliest of years. It comes from early rabbinic teachings. I was weaned on the importance of that. It means doing my part to repair the world. As a Jewish girl, my ancestors came to this country from Germany, Czechoslovakia, Austria, and Hungary. My family tree has many empty branches in it. I know intimately the cost of silencing the voices of those who dissent. The full phrase actually is Mipnei Tikkun Haolam, loosely translated to mean in the interest of public policy. It refers to social policy legislation providing extra protection to those potentially at a disadvantage. As I watch voter suppression tactics unfold all over the nation, I'm appalled. I've come to learn much more about the ramifications to those who don't look like me. People of color have long suffered at the hands of those in power in our nation. I'm not able to stand by and watch in silence as my friends and neighbors have their voices silenced. I've spent most of my adult life working in the sciences. I'm a data-driven adult. In my experience here in Connecticut, the stories of voter suppression or intimidation are often anecdotal. We need a well-funded, transparent, and available database that allows all of us to do the research and have hard data support what many of us believe to be true. Solid legal tools so that voters who face intimidation at the polls are able to have actionable recourse, a strong pre-clearance program to identify and fix problems before they lead to disenfranchisement. Our state is a welcoming state for many non-native English speakers. We need expanded language assistance so that all CT residents who are eligible to vote do not face a language barrier when choosing to have their voices heard. And as I write this, I'm reminded of the famous quote by German pastor Martin Niemöller. First, they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews. I did not speak out because I was not a Jew. And then they came for me, and there was no one left to speak for me. Voter intimidation and suppression is a slippery slope. Statutory changes that rob us of the richness of diversity in our elected politics, like those we see now in other states, are a profound disservice that threatens all of us. Our state should stand up proudly for equal democracy. It's time for Connecticut to become the leader in all aspects of voting rights. Thank you.
Thank you. Are there any questions from the committee? Seeing none. Thanks as always for being with us, Dr. Rizzolo. Great to see you, and thanks for all your work.
Thank you.
Next up, Susan Fernandez. Followed by Laura Copeland, followed by Patrick Grasso, I do not see Ms. Fernandez. So Laura Copeland, whenever you're ready.
Yes, hi, thank you. My name is Laura Copeland and I live in Ivoryton. As a recent resident of Connecticut, I can't believe that there are municipalities in Connecticut that would impair or dilute the opportunity for anyone to participate in the political process. As you can imagine, I'm thanking you for letting me speak in support of SB 1226. I do recognize that some municipalities, as was mentioned earlier this morning, have perhaps put things in place to suppress voting inadvertently. But we are seeing voter suppression being enacted, voter suppression laws being enacted all across this country, particularly in neighborhoods of color. Draconian ID laws, gerrymandering, long lines, reducing polling hours, reducing polling places. I fear for our country. I fear for our democracy. Connecticut should be a beacon of democracy for other states to emulate. Please pass SB 1226 to proactively protect and codify voting rights in Connecticut. Thank you.
Thank you. Are there questions from the committee? Seeing none, thank you very much for being with us.
Thank you.
Next up is Patrick Grasso, followed by Tony Marie Malizia. Mr. Grasso, you can begin whenever you're ready.
Chairman Flexer, Chairperson Blumenthal, and distinguished members of the Government Administration and Elections Committee. My name is Patrick Grasso. I'm a principal at Urban Mining, Connecticut, based in Beacon Falls, Connecticut. I'm before you today to testify in support of HB 6401, an act concerning the use of low embodied carbon concrete in state construction projects. Concrete is an essential building material, but the cement used to make concrete today contributes about 7% of our global greenhouse gas emissions, and we must find ways to reduce that carbon footprint. On the recycling front, the challenges of finding a home for single stream glass, porcelain, ceramics are frustrated materials management professionals and deep for decades. Often these materials are simply sent to out-of-state landfills. There's now a large-scale solution for our waste challenges using unwanted waste glass, porcelain, ceramics to create a cement replacement that dramatically reduces CO2 emissions while creating better performing concrete. Our material positive can replace up to 50% of cement in concrete with 4 important benefits for our state. 1, an ability to significantly lower the carbon footprint of concrete by over 40%. 2, a large-scale solution home for hard to recycle material. 3, reducing a stronger and more durable concrete, most notably a concrete with a much higher resistance to the damaging road salts that cause the chaos in our roads and bridges. And 4th, it's a product that's manufactured right here in Connecticut. We've created a perfect example of a circular economy. A load of local curbside glass is brought to Beacon Falls, turned into positive, and then used to build things like new schools in Darien and Torrington, a new library in New Canaan, and Deep's new Western headquarters in Watertown. With all this happening with locally sourced material, the transportation emissions associated with these projects are also reduced. Demonstrating our ability to meet the demand of large-scale low-carbon concrete projects in our region, positive is also being used to replace 40% of the cement in the new 2.2 million square foot JP Morgan headquarters building now under construction in New York City. With regard to HB 6401, state and local governments can play a critical role in setting an example for the use of low carbon concrete. Our Department of Administrative Services should be applauded for their decision to write low carbon concrete into our state bid specifications. The bill goes one step further to codify it across DAS and DOT. The bill would again show Connecticut to be the innovation leader it has always been. We look forward to working with the committee on this issue. If any members are interested, we'd be honored to have them visit us for a tour of the plant. Watching a pile of recycled glass turn into a product that has such important benefits for construction and our environment is an accomplishment we take great pride in. Again, thank you for your time and consideration.
Thank you, Mr. Grasso. Are there any questions from the committee? Seeing none, thank you for being with us today and contributing your testimony.
Thank you.
Tony Marie Malizia, Are you with us? Maya Ruthen?
Perfect. Yes, I'm here.
All right, whenever you're ready, you can begin.
Great. Good afternoon, Senator Flexer, Representative Blumenthal, Ranking Members, Senator Sampson, and Representative Master Francesco, and esteemed members of the Government Administration and Elections Committee. My name is Maya Roton, and I'm a student at Yale University and resident of New Haven. Although not a permanent resident of the state, I have voted in state and city elections. I'm here to advocate for SB 1126, an act concerning state voting rights in recognition of John R. Lewis. This bill would make voting more equitable and buttress protections against discriminatory voting practices. We all deserve the right to have our voices heard, and this bill would help make the diversity of our state better represented in our legislation and lawmaking. In recent years, the Federal Voting Rights Act has been weakened, especially impacting the rights of voters of color. Connecticut needs to step up to cement voting rights, as the federal government is clearly not doing so. Section 5 of the Voting Rights Act was struck down after protecting voters for over 50 years by requiring that states confer with the federal government before implementing voting changes. With voting discrimination and restrictive voting laws, the most privileged are often those who can maneuver through the many barriers to voting. We should all strive to have the diversity of our state represented in government, but this cannot be achieved if large sectors of our population are excluded. Black and Latino voters have primarily been targeted by restrictive voting laws. SB 1126 would strengthen language assistance for those who do not speak English, further enfranchising often disenfranchised groups. We often believe that simply because Connecticut is a northern state, voting was somehow less restrictive than in southern states. Historically, Connecticut was the first state to invoke literacy tests. Connecticut has not historically been a bastion of voting equality. However, sorry, what was that?
Sorry. Mr. Grasso, if you could please mute yourself. Thank you.
Oh, sorry. Historically, Connecticut was the first state to invoke literacy tests. Connecticut has not historically been a bastion of voting equality. However, with the Connecticut Voting Rights Act, we can make our state a national leader. Let's remake our voting laws in the democratic image we have of ourselves as a state, making our ideals into reality. Thank you so much for your time and consideration. I truly do hope you vote in favor of the Connecticut Voting Rights Act. Thank you.
Thank you. Any questions from the committee? Seeing none, thank you very much for being with us today. Next up is Stephen Mendelsohn, followed by Mary Ellen Perugini.
Yes, Senator Flexer, Representative Blumenthal, members of the Government Administration Elections Committee. I'm here in strong opposition to SJ 42, proposing a constitutional right to private amendment regarding a right to privacy. SJ 42 is deceptively worded, and I've submitted 7 full pages of written testimony, which you should have. I'll try to summarize in as brief as I can. It's a deceptively worded amendment that advertises itself to the voters as a right to privacy in the question presented, but is actually about a much more broad and different right to, quote, reproductive freedom, which is defined as including but not limited to things like contraception or abortion. And in my testimony, I point out some of these other things that it's going to wind up coming before our courts and perhaps acting in ways that people who may support the overall concept may be actually quite horrified by. I cite 2, I go into detail in 2 in particular. One is male circumcision and the fact that it would basically essentially declare in some way that an attorney can come before the court and say that an 8-day-old boy now has a reproductive freedom right to his foreskin in accordance with the views of European medical associations, and essentially criminalize things like Brit Milah. I'm Jewish, and in our tradition, this is a mitzvah. This is a religious obligation. And shockingly, it is not protected under current Supreme Court jurisprudence under the Free Exercise Clause. The governing ruling was a 1990 case, Employment Division versus Smith. Was written by Justice Antonin Scalia, who later told Rabbi Meir Soloveitchik and Orthodox Jewish attorney Nat Lewin over at Yeshiva University, quote, and I'll quote him, "If the practice is something that society does not want and is not intended to discriminate against Jews in particular, I think the law is perfectly valid." Justice Alito wrote in a more recent concurrence who advocate, and Alito advocates overturning Smith, but he only has 3 members of the court on his side yet, Fulton v. City of Philadelphia. Suppose that a jurisdiction in this country, following the recommendations of Medical Association in Europe, ban the circumcision of infants. A San Francisco ballot initiative in 2010 proposed just that, as did there was a public hearing in Massachusetts, which would have given 14-year jail sentences to doctors, Mohilim, and parents. A categorical ban would be allowed under Smith, even if though it would prohibit an ancient and important Jewish and Muslim practice. It also, and as I say elsewhere, even further, is our state's Religious Freedom Restoration Act would not protect here, because this is a constitutional amendment with a fundamental right which would supersede RFRA. So it is the perfect vehicle of a neutral, generally applicable amendment that would essentially invalidate the basic religious liberties. The other example I sent, I'll be very quick here, is it would also give men an equal right to abort parenthood. And as I notice here, very quickly, this is a man who got a woman pregnant and decided not to become a father. He's selfish, inhumane, a deadbeat dad. This is a woman who got pregnant and decides not to be a mother. She's pro-choice. And so by saying that this amendment is about equality between the sexes, affirming Article 1, Section 20, it would give an opening for men's rights advocates to say that they should have a right to disown fatherhood for the same period of time that a woman has a right to an abortion. I strongly urge rejection. Thank you, and I'm happy to take any questions.
Thank you for your testimony. Are there any questions from the committee? Seeing none, thank you for being with us today.
You're very welcome.
Is Mary Ellen Perugini with us? Is Jeffrey Daniels with us?
Yes.
All right. Whenever you're ready, you may begin. And if you could put yourself on video, if possible.
I did. There we go.
All right,
Sorry, it was a little slow. Chairperson Flexer, Chairman Blumenthal, and honorable members of the committee. My name is Jeffrey Daniels. I am the co-chair of the Legislative Committee of the Connecticut Council on Freedom of Information. CCO-FOI has advocated for government transparency and accountability since our founding in 1955. Our members represent leaders from the print, broadcast, and internet media, Connecticut Bar, the civil rights, civil liberties organizations, and open government organizations. I speak here today in strong support of RB 1221, an act concerning enforcement of violations of the Freedom of Information Act, and in support of RB 6906, an act concerning member participation during remote and hybrid municipal public agency meetings. We applaud the committee's attention to these important FOI concerns. 1221 would significantly enhance penalties for non-compliance with FOI orders. It is indeed a sad commentary in our times that we need this legislation. On a brief personal note, in 1975, while serving as Governor Ella Grosso's policy director, I was intimately involved in the negotiations and the passage of the Freedom of Information Act. There was spirited debate with the Judiciary Committee regarding fines. Legislators opined, surely, they said, public agencies would comply with any orders. To use a military reference, imposing higher penalties at that time proved to be a bridge too far. It was hard enough to pass the bill, and instead modest fines of $20 to $1,000 were adopted. Today, we see flagrant flouting of these orders. Last week, the city of Bridgeport bluntly told FOI commissioners the city would refuse to release information they previously were ordered to disclose. Their behavior has been repetitive. At the state level, some agencies, most notably the Department of Public Safety, often has refused or dragged its feet in releasing information, again, flaunting commission orders. The bill takes 2 actions. First, it would increase tenfold the maximum civil fine against a public agency. Second, Section 1B5 states that if after an appeal, an agency is engaging in practices of a pattern of conduct that constitutes an obstruction, the commission can seek additional relief, damages, and costs in court. This is a necessary tool. Regarding 6906, we support this bill, which in this era of Zoom and hybrid meetings would require that public officials who speak at a meeting be visible via the electronic media they are using. We should be able to see our public officials as they conduct business. We suggest potentially one change on line 83. It appears the requirement to be on camera when speaking is limited to municipal officials. Would it be just as appropriate for officials of all public agencies, if they are speaking, to be visible? Deleting the word municipal might accomplish this. Thank you for your attention, and I would be happy to answer any questions the committee may have.
Thank you. Are there any questions from the committee? Seeing none, I actually have one, which is that for SB 1221, which
Yes.
is the one for enforcing FOI. In addition to the increased fine, the possibility of injunctions, and the public reporting obligation, are there any other tools that you think that the FOIC should have to enforce FOI compliance that we haven't included in this bill?
Well, I think this tool is really excellent. I don't know if this would be a tool, but one additional piece is for large organizations, these dollar fines are really almost meaningless. The potential for daily embarrassment is a possibility, that the fine may not just be a one-time activity, but as other kinds of contempt violations are often done daily. So that would be an additional or a different kind of way to put more pressure on. The only other potential for it would be to create a more expedited process through the courts by some manner. So if they were going to move, particularly on a repeated violation, that it would not sit on the calendar for a long period and would be held pretty quickly.
All right. Well, thank you for your testimony.
Thank you.
All right. Appreciate you being with us.
Thank you.
Next up is Claudia Pilat, followed by Yanzi Velez. Looks like Claudia is not with us. Is Yanzi Velez with us? No. Beth McGillivray.
Hi.
All right. So Beth, you will be followed by Isabel Mulbauer. Beth, whenever you're ready, you can begin.
Thank you, Chair and distinguished members of the committee, members of the Government Administration and Elections Committee. I appreciate the time to support Bill SB 379. Connecticut should not allow solicitation, receipt, and use of outside private money to fund our election offices. Allowing outside organizations to fund our elections raises many questions for voters. With private money, Connecticut legislatures would need to oversee and take on more work to ensure to all voters that there is a nonpartisan organization, as well as watchdog future organizations from any allegiance to a political party. In today's highly partisan environment, you are setting Connecticut up for possible failure or new legal battles. In Greenwich, a grant of money from an outside organization had strings attached, asking for membership alliances and data sharing. It may start off slowly, but I warn this committee that these requests may change over time. Connecticut citizens deserve to know their elections are accountable to our people, not special interests. In Connecticut, we are fortunate to have a reputation of election integrity. Let's keep this status. Elections and other essential responsibilities of government should not be privately funded. Let's keep our politics and outside influences from our election offices. Let's keep the duties required of our government with our government when it relates to elections, so Connecticut doesn't have to rely on influence from private money. With more than half of the United States prohibiting this action, why should the state of Connecticut risk tarnishing its outstanding record of election excellence by allowing any organization, political or not, to gain influence in the registrar's offices and jeopardize its current success? Let's follow half of the United States ban and continue to exercise financial caution. Please vote to prevent private funds from the power to shape our electoral integrity. Thank you very much.
Thank you. Any questions from the committee? Seeing none. Thank you for being with us. Next will be Isabel Mulbauer, followed by Kimberly Fiorillo. Whenever you're ready, Ms. Mulbauer.
Good afternoon, distinguished members of the Government Administration and Elections Committee. My name is Isabel Mulbauer, and I'm the Voting Rights Advocacy Coordinator at Latino Justice PearlDef. I'm here to testify in support of Senate Bill 1226, an act concerning state voting rights in recognition of John R. Lewis. This bill is a step forward in remedying a long history of voter disenfranchisement in Connecticut. Latino Justice has a long history of advocating for the expansion of language access rights to ensure the Latinx community has equal access to the ballot box. We enthusiastically support the language assistance provisions in SB 1226 that extend beyond the Federal Voting Rights Act. Under the Federal Voting Rights Act, only 10 Connecticut towns are required to have language assistance. But according to the most recent census data, more than 275,000 Connecticut residents statewide have limited English proficiency. We can and should do more to improve access for our communities and make voting easier for language minorities. SB 1226 expands language access by lowering the population threshold requirements for municipalities to provide language translation, making language assistance more expansive. Not only does the bill require assistance at the polls, but will also guarantee that translated materials are available for voters, including notices and ballots. It is critically important that Connecticut meet the needs of language minority voters, including immigrants and Indigenous communities. Every voter has the right to be heard, regardless of their English proficiency. Uninhibited access to the ballot is the core of a representative democracy. As such, we must continue to ensure that all voters, including historically marginalized communities, are able to freely have their voices heard through their vote. Latino Justice calls on the Connecticut legislature to pass SB 1226, the Connecticut Voting Rights Act, to codify state-level protections for voting rights that are under attack nationwide. Thank you for your time.
Thank you. Any questions from the committee? Seeing none. Thank you very much for being with us and contributing your testimony. Kimberly Fiorillo. Kimberly Fiorillo, do not see you. Oh, no, there you are. Go ahead.
Yes, thank you, Mr. Chair, and thank you to the members of the General Elections Committee. I apologize, I'm not in a very convenient location, but I'm very grateful for this opportunity to speak on this bill. I support SB 379. This bill to disallow private monies to be used for our elections offices. This is a new trend that's happening across our country at the moment. Apologies, but I'd like to turn my camera off. This is a new trend across our country at the moment with private monies coming into our elections. The trend so far is for states to pass laws to stop this. And the main reason, of course, is that we all have a tradition of funding our elections through taxpayer dollars and not through private funding. And that's something we want to continue to protect. One thing I'd like to bring to the attention of the committee is that when it comes to political monies, which some of the bills you're looking at today have to deal with that. And we're always so conscious and careful to make sure that there's a lot of transparency in money donations to politics. But for our information from data from 2018, the money that goes directly to candidates, so-called hard dollars, it was about $5 billion. This is to candidates and to parties. But the money that goes to like super PACs or C4s, the dark money that we often are concerned about was actually only $130 million in 2018. However, the money that goes to public policy charities, 501c3s, where the donor receives a tax deduction, but the work is still in the area of politics. Although it's a 501c3, it's supposed to be nonpartisan, but that money is massive. It's $20 billion. And these nonprofit public policy charities are increasingly involved in elections. And this is the trend that we're seeing. And this bill, SB 379, addresses the need to ensure that elections in Connecticut are funded only by our taxpayer dollars. Thank you very much.
Thank you. Is there any questions from the committee? Seeing none. Thanks for being with us. Next up is Alex Peterson, followed by Fred Lorthoir. Alex Peterson. Ah, there you are. I'm sorry. So you're still looking at the computer screen. Whenever you're ready, you can begin.
Chairs Flexer and Blumenthal, ranking members Sampson and Mastro Francesco, and distinguished members of the GAE committee. My name is Alex Peterson, and I am the Director of Government Affairs for the Connecticut Airport Authority. The CAA is the quasi-public agency that owns and operates Bradley International Airport and 5 general aviation airports in the state. While we have only formally controlled our airports for 10 years, we have already secured several significant accomplishments, from the growth of nonstop routes at Bradley Airport to the private development secured at our general aviation airports. The CAA has leveraged its foundation as a nimble quasi-public agency to maximize our state's aviation assets. While the talented, hardworking staff across the organization drove these accomplishments, none of them would have been possible without the flexibility afforded by the quasi-public agency structure. Since the CAA's formation, the CAA board has approved and maintained a robust procurement policy to guide our activities. This policy has competitive bidding as a defining feature. Currently, we have an IFB out right now for a large lawn mower at Waterbury Oxford Airport, just to highlight that. The implementation of these procedures by staff have withstood the test of time and review by the auditors of public accounts and annual independent audits. The auditors of public accounts absolutely can and do review procurement policies. In fact, the testing can be quite rigorous, at times selecting up to 10 RFPs, sampling bid documents, and ensuring our process complied with our procurement policy. We've never had any findings. The CAA has severe concerns that Senate Bill 1223, by broadly subjecting quasi-public agencies to the State Contracting Standards Board processes, will delay our projects and leases and roll back the momentum we have been able to nurture. We have heard several instances of development deals that were stymied at our airports when they were managed by the DOT due to the onerous review processes of external organizations that did not possess the specific airport industry experience required to properly evaluate such deals. Let me be clear, under this bill, the board would have pre-approval rights over any contract deemed a privatization contract pursuant to section 4E-16. The rigidity of a one-size-fits-all system will affect each quasi-public agency differently, and it is impossible to accurately quantify the damage since many of the board's regulations for certain procurement methods and processes have not been articulated to date. Subjecting quasi-public agencies to the board is antithetical to all of our purposes and missions, and it will negatively impact the communities that rely on our services. The CAA understands the committee's interest in quasi-public agencies, and we do not provide this testimony in any way to suggest that we feel that we are above reproach. We want to be part of the solution, and we are hopeful that we can work with the committee in the coming months to identify ways to promote transparency and responsibility in the quasi-public agency system without undermining the very attributes that make us effective in pursuing our respective missions. I thank you for the opportunity to present this testimony. I appreciate your attention and consideration, and I would be happy to take any questions.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Thank you again for your time and your testimony and your patience today. We appreciate it.
Thank you.
Next, we will hear from Fred Lortinor. I apologize if I'm getting that wrong, Fred. And will be followed by Mary Deldon Nelson. Fred, welcome. The floor is yours, and please correct me on your last name. I apologize.
So I pronounce it Fred Lorthior, and however you pronounce it is totally fine. Chairman Blumenthal, Senator Robert Sampson, Representative Gail Mastro Francesco, hope I had that right, members of the Committee on Government Administration and other distinguished attendees. My name is Fred Lorthior. I'm a 26-year Greenwich, Connecticut resident, and I'm an elected member of the Greenwich RTM. I'm here today to offer support for SB 379, an act prohibiting the use of private funds by the state and municipalities for election administration purposes. As you're likely aware, the Center for Technology and Civic Life, or the CTLC, the Chicago, Illinois not-for-profit, offered Greenwich a grant of $500,000 in private funds for election administration purposes. It is as odd as it seems. Since Greenwich is one of the wealthiest towns in Connecticut, there are many other towns that have a greater need for this money. One needs to ask, why Greenwich? Since I'm an accountant who is well-versed in not-for-profit financial reports and disclosures, I reached out to the CTLC on January 10th to do some independent due diligence before Greenwich's RTM vote to accept or reject the grant. My goal was to draw my own conclusions rather than rely on what is often biased news reported on the internet and the media. I contacted Sophie Lehman of the CTLC to get documents regarding their finances and conflict of interest policy. I requested the following: tax returns, audited financial statements, annual report, conflict of interest policy. The tax returns are available, but was informed that the audited financial statements and the conflict of interest policy are, quote unquote, not publicly filed documents. Both the Greenwich Registrar of Voters, Fred DeCaro, and Mary Hagerty were included in return January 12 communication from the CTLC and did nothing to help me get the information requested. In layman's terms, hiding behind the phrase not publicly filed documents means we're not going to tell you and it's none of your business. The bigger problem here is that the CTLC's federal tax return, or Form 990 Schedule O, states that, and I quote, "The governing documents, conflict of interest policy, and financial statements of the center are made available to the public upon request." This lack of transparency, cooperation, and apparent willful noncompliance with the IRS is alarming. It's a big red flag that is high as his ceiling and as wide as this room. Is the CTLC trying to hide something? I don't know, and I don't trust them, and neither should you. I support SB 379 to prohibit the use of private funds by the state and municipalities for election administration purposes. Thank you. It is a privilege to speak here today. Would anyone like a copy of my communications with the CTLC and the relevant pages of their tax returns supporting documents? Thank you.
Thank you. Thank you for your time and your testimony. And just for clarification, the CTLC stands for what?
It stands for the Center for Technology and Civic Life.
Thank you. Thank you very much. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony and your patience today. Next, we will hear from Mary Deldon Nelson, who will be followed by Christina Bennett, who will be followed by Logan Place. Welcome, Mary. The floor is yours. Is Mary here? Mary does not seem to be here. Okay. Then Christina Bennett will be followed by Logan Place. Is Christina here? Welcome, Christina. The floor is yours.
Dear members of the Government Administration and Elections Committee, my name is Christina Bennett. I'm testifying in opposition to Joint Senate Resolution 42 as a liaison for the Family Institute of Connecticut. Our state was founded by men seeking freedom who created a constitution calling for equal protection under the law. But we know that not all men in this country have been treated equally, including the natives whose covenants were broken or the Africans who came to our shores in slave ships. Those people groups were considered subhuman, and violence was justified against them because of the color of their skin. Today, along with continued racial injustice, we see another form of discrimination based on size and human development: abortion. In a chemical abortion, a growing baby is stripped of progesterone, causing the child to be starved of nutrients and expelled from the body by toxic chemicals. In a surgical abortion, an unborn child is forcefully suctioned out of the womb by a powerful vacuum or dismembered piece by razor-sharp instruments. If my own mother hadn't walked out of her abortion appointment in Hartford, Connecticut in 1981 at Mount Sinai Hospital, my body would have been dismembered, my tiny arms and legs collected in a bag, and my frame incinerated into medical waste. It's gruesome to discuss, but important to know what we as a state are upholding. You can manipulate language to frame abortion as a right to choose, reproductive freedom, or bodily autonomy, but the reality remains that every successful abortion brings forth a dead baby, and very often a wounded mother and father. Equal protection under the law should apply to both the 20-year-old mother and the 20-week-old baby in her womb. Vote no to this amendment because the state constitution designed to protect against discrimination should not enable the death of human persons. Vote no because this amendment would support abortion at later stages in pregnancy to vulnerable populations. In our state, 70% of the abortions are covered by Medicaid for low-income women. Minors in Connecticut are protected by requiring parental permission to get a tattoo, have their ears pierced, or go tanning. But no such parental notification is even required if they pursue a chemical or surgical abortion. Minors are made more vulnerable to sex trafficking, abuse, and even hiding abortion-related complications because parental involvement has been discouraged. Vote no because most women cite financial reasons for seeking abortion and their needs are not being met. Our governor proposed giving $2 million to fund abortions for out-of-state women, while St. Agnes Maternity Home in West Hartford had to close after 100 years because of lack of state funds. And we're in a housing crisis. Our state constitution makes no reference to abortion, and it's troubling that anyone would seek to use the 14th Amendment, one created to give citizenship rights to Black Americans under the law to create a so-called right to privacy to kill a child. Connecticut lawmakers have coerced impoverished women to support abortion by offering free abortions. They've idolized abortion as an answer where women lack support, and they've used biased reasonings to convince Black women that abortion is in our community's best interest. Vote no, because our Constitution doesn't need to be butchered as these babies are being. Thank you.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
You're welcome.
Next, we will hear from Logan Place, who will be followed by James Farrell, who will be followed by Carolyn Bennett. Welcome, Logan. The floor is yours.
Thank you, and good afternoon, Senator Flexer, Representative Blumenthal, and members of the GAE committee. My name is Logan Place. I am a field representative for AFT Connecticut, where I represent educators, healthcare workers, and state employees, including approximately 3,000 professional employees at UConn Health. I'm here to testify in favor of SB 1223, an act concerning the State Contracting Standards Board. First, I would like to express my general support for this bill, as it will strengthen the Contracting Standards Board, which in turn will protect taxpayer money. It also takes important steps to protect public services and promote equity in the state. But I would specifically like to address the portion of the bill that closes a loophole that allows UConn Health to privatize services without submitting a cost-benefit analysis to the Contracting Standards Board. The current law does provide that all institutions of higher education, including UConn Health, are required to submit a cost-benefit analysis to the board before entering into a privatization contract. This ensures that privatization results in a benefit to the state and taxpayers. UConn Health, however, is able to avoid this safeguard by using the University of Connecticut Health Center Finance Corporation. The Finance Corporation is a statutorily created entity set forth in Section 10A-250 of the General Statute. The statute exempts many of the Finance Corporation's activities from review by other government boards and agencies. Although the statute creating the Finance Corporation was enacted over 25 years before the creation of the Contracting Standards Board, UConn Health has taken the position that the Finance Corporation is exempt from the board's jurisdiction, even though the corporation is effectively controlled by UConn and UConn Health. So what does this mean? It means that UConn Health, the state's only public hospital, can privatize services even if such privatization costs taxpayers more money and does not otherwise benefit the state. UConn Health provides essential public services by providing care to some of our state's most vulnerable residents and training the next generation of doctors and dentists. Privatizing such services should not be taken lightly, and it certainly should not be done unless a cost-benefit analysis shows it will result in a benefit to our state. This concern is not a hypothetical. UConn Health is currently privatizing certain radiological services without conducting a cost-benefit analysis by using the Finance Corporation to establish a joint venture with a private company. If this loophole is not closed, it could open the Pandora's box to privatizing our state's only public hospital without any mechanism to ensure privatization saves taxpayer money and otherwise benefits the states and its residents. UConn Health mustn't be allowed to use the Finance Corporation to evade basic oversight that every other state agency, including higher education institutions, are subject to. Thank you for the time and the opportunity to testify, and I'm happy to answer any questions you may have.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony. Next, we will hear from James Farrell, who will be followed by Carolyn Bennett, who will be followed by Aaron Good. Welcome, James. James, I see that you are online. Are you prepared to begin your testimony? Okay, James is not responding, so I will move on to Carolyn Bennett, who will be followed by Aaron Good. Welcome, Carolyn. The floor is yours.
Thank you. Members of the GAE committee, my name is Carolyn Bennett, and I'm testifying in strong opposition to SJ 42, which proposes adding a right to abortion to our state constitution. I find the lack of transparency in the proposed ballot language particularly appalling. Shall the Constitution of the state be amended to recognize a right to individual privacy and to prohibit the state from infringing such right without showing a compelling state interest? That sounds like we're being asked if we want the state reading our personal emails or not. Absolutely no voter reading that would have any idea that they are casting a vote having anything to do with abortion. If you're asking us to amend the Constitution, please show the voters the respect of being clear as to what you're asking us to vote on. It is just as important for the committee to clearly understand exactly what you're voting on as well when you're asked to support a right to abortion. Therefore, let me explain for you a second trimester D&E abortion procedure, which is legal in Connecticut. This is a straightforward medical description from a video I watched by an OBGYN who performed over 1,200 abortions. I recommend that all committee members watch the entire video linked in my testimony. As explained in the video, a D&E is usually performed between 13 and 24 weeks in the pregnancy. In the procedure, the abortionist uses an instrument to grasp and pull the developing baby's arms and legs, tearing the limbs from the child's body. He continues to grasp and tear out intestines, spine, heart, and lungs, finally crushing the baby's skull and removing the pieces. The abortionist then collects all of the baby's parts and reassembles them to make sure that all the pieces are there, and then the abortion is complete. Please understand that when you talk about abortion, when you support abortion, this is what it is: the violent destruction of an innocent, helpless human life. To quote Carrie Gordon Earl, a woman who had an abortion as a teenager, "The world is not a better place because of abortion. It's created a world where you're almost expected to abort if you're pregnant at an inopportune time. And it's created a society in which it's easier to push women to have an abortion rather than accommodate them and their needs as mothers. Abortion feels like your only choice if you want to keep your place in school or the workforce. That's not empowerment for women, that's bondage. Please oppose SJ 42. Thank you.
Thank you, Carolyn. Are there any questions? Okay, seeing no questions, thank you for your testimony and your time today. James Farrell, are you on now? Are you able to turn your camera and microphone on? James? No? Oh,
No.
Yep, I see you're working on it. Welcome, James. Are you able to turn your camera on?
No.
Okay.
I do have some words to tell you. I'm glad to speak to the chairman and the rest of the committee and everyone.
Okay, go right ahead, Mr. Farrell.
Okay. I believe parents should have a chance to voice their opposition to abortion. The statute, the infamous 1990 law repealing our therapeutic abortion law that allowed for abortion to save the life of the mother, should revert to the
Okay,
boys,
go ahead,
religious
Mr. Farrell.
circumcision, or favor of, can you hear me?
Yes, I can hear you.
Okay. Or favor a reborn person's reproductive rights should the child someday be defined as a person to be protected by federal law. I ask the committee members, and as your constituent, if I have it up there, to please vote no on Senate Joint Resolution 42. I'm speaking on opposed, I forgot to tell you. It's deceptively titled Resolution Proposing a State Constitutional Amendment Concerning a Right to Privacy. Actually, it would make abortion legal through all 9 months. You should vote no on 3 reasons. First, because it's wrong. It's killing. It's killing the innocent without due process. Secondly, it's not what most people want. Most people are against abortion, especially the third trimester. Most people, they're not pro-choice that much. I would say that thirdly, privacy means anything and everything. It can mean even be interpreted by pro-life judge to mean the opposite of what the proponents intend. Whether you're pro-life or pro-choice, there's middle ground for both sides. Common sense measures like parental notification are preferably objection rights. If this amendment passes, that will not be possible. It will greatly inflame what is already the most polarizing issue of our time. Please do the right thing. Please vote no on SJ 42. Thank you.
Thank you, Mr. Farrell. Are there any
welcome.
questions? Seeing no questions from members, I
I
appreciate.
did that all reading with one eye. All right, it's bad.
Okay, appreciate your time. Thank you, sir.
Yeah.
Next, we have Aaron Good, followed by Lydia Bennett. Aaron, are you on?
Yes, thank you, Madam Chairman. I'm with the New Haven Votes Coalition and also a member of the governing board of the Public Financing Program for mayoral elections in New Haven, which is called the Democracy Fund. And I want to comment on SB 1225 and specifically the democracy vouchers component of the bill. The democracy vouchers concept actually originated with 2 law professors in New Haven. We're proud of that. And last year, our board met with the administrators of the Seattle voucher program to learn more about it. I think Mr. Brandy from SEEC was at that conference as well. But it's not an exaggeration to say democracy vouchers is becoming the gold standard for public financing and the direction many of the 30 or so municipal and state public finance programs are moving towards. And the reason for that simply is it powerfully increases the number of small dollar donors. Far more than any other system that just uses grants or matching funds. So in Seattle now, 8% of voters are also politically engaged at a deeper level as campaign donors, which is the broadest base in the country for the funding of campaigns. Our CEP is a good program, but the percent of electors who are donors is maybe 1.5%. In New Haven, our program double matches all contributions under $30, but we've never gotten above 2% of electors as donors. So with democracy vouchers, you could triple or quadruple the number of small donors, which is one extremely important metric for evaluating the success of public financing. It's not, of course, the only valid metric, and it really depends on what we're trying to accomplish. So if we just want to increase the incentive for gubernatorial candidates to participate in CEP, simply raising the grant is fine. But if we want to take the democratization of campaign finance to the next level in Connecticut, then vouchers or a high multiple for matching funds is the way to go. And if you want to authorize, pay for a democracy vouchers pilot program in New Haven, I'm sure we wouldn't say no to that. On 1226, New Haven Votes supports Connecticut Voting Rights Act. It's not intentional or systematic discrimination that worries us so much as policies that have a disparate impact or unintended effective voter suppression. And our residents deserve a robust means of legal redress for those rare, unfortunate situations. And it's actually not just long lines at the polls. New Haven, we have an ongoing issue where 15 to 20% of our voters have a polling place that confusingly alternates from even to odd number years. And in the most recent redistricting, this problem was actually made worse, not better. So if this were happening in Georgia or Alabama, it would be called voter suppression and subjected to federal VRA scrutiny. One suggested modification, the public participation requirements for certain municipal redistricting plans in lines 241 to 265 should be applied to all municipal redistricting plans, not just going from district to at large. And in fact, should be applied to both redistricting and charter revision, because sometimes where this bill talks about redistricting, it really means charter revision. And I can foresee potential problems if that language isn't better clarified in the bill. Thank you very much and have a great day.
Thank you, Aaron, for your testimony. Are there any questions? Seeing no questions from committee members, thank you again for spending your time with us today. Next, we have Lydia Bennett, followed by Ned Jones, followed by Susanna Bennett. Lydia, are you here?
I am.
Great. You may begin.
Thank you. Members of the GAE committee, my name is Lydia Bennett, and I am strongly opposed to SJ 42 for several reasons. First of all, I take issue with the phrase, the fundamental right to reproductive freedom, which is basically another way to refer to a right to abortion. The problem here is that abortion is not and cannot be a right. A right is not a right if it only applies to me and I am unwilling to grant to others what I ask for myself. The so-called right to reproductive freedom cannot be a right if it protects the rights of one human being at the expense of the life of another innocent human being. And that is what abortion does. The reality is that once a woman is pregnant, she doesn't just have herself to consider, but also the child she is carrying. This fact is implicitly acknowledged when women are advised not to drink alcohol or consume drugs while pregnant for the safety of the developing child. My next concern is with the phrase, the state may not directly or indirectly deny, burden, or abridge such right unless justified by a compelling state interest achieved by the least restrictive means. Currently in Connecticut, abortion is only legal up to 24 weeks. Would that restriction then be considered denying or abridging the quote right to abortion? Would abortion then be legal up until birth? I have a niece who was born early at 31 weeks. Before she was born, the doctors planned to deliver early if the mother or the child was in distress. An inanimate blob of tissue cannot be in distress. My niece was just as real and alive inside the womb as she was once she came out of the womb. This bill could make it legal to destroy a child at that same stage of life. Lastly, I am opposed to this bill because of the negative generational impact abortion has on women and their families. Because as much as we don't like to say it, abortion does end the life of an innocent human being. And those who are involved in the ending of that life are left to grapple with that reality, whether they realize it or not. Pregnancy makes a woman a mother. Terminating the pregnancy by taking the life of the child cannot change that fact. So many women make this decision under pressure and high stress, and then are left to try to pick up the broken pieces of their heart, some for the rest of their lives. Let's not make constitutional the harm that abortion creates. Let's help men and women find hope and healing from their pain and spare that pain from others. Please oppose SJ 42. Thank you.
Thank you, Lydia. Are there any questions from the committee? Seeing none, thank you for your testimony. We appreciate your time.
Thank you.
Next, we have Ned Jones, followed by Susanna Bennett, followed by Ann LaMonica.
Thank you very much for this Thank you very much for this opportunity to support SB number 379, an act prohibiting the use of private funds by the state and municipalities for election administration purposes. The reason we're even having this conversation today is because in 2020, Mark Zuckerberg and his wife, Priscilla Chan, made a charitable contribution to the Center for Tech and Civic Life of $328 million, which was then distributed to election offices around the country. They made an additional charitable contribution to an organization called the Center for Election Innovation and Research in the amount of $69 million, excuse me. And in Connecticut, you received 59 of these grants in all 8 counties. $48,000 went to counties that Trump won, and 1.8 million went to counties that Biden won. And we don't know what happened to the 2.1 million that was given directly to your Secretary of State by the Center for Election Innovation and Research. We do know this, that 90% of all of the Zuckerberg grants in 2020 went to locations, jurisdictions that Biden won. 10% went to jurisdictions that Trump won. Now, outside funding of elections should be a nonpartisan issue. There should be no funds from any party supporters that are used to run our elections. They should be financed by taxpayers who elect the officials that give us the rules for the elections, and then the taxpayers should fund them. And now we have the Alliance for Election Excellence, which is the latest iteration of these outside grants coming into our election offices. And Greenwich received $500,000, which was recently approved. Also, the offer of membership in the Alliance. We don't really know who's funding this outside money. We know that it comes from the Audacious Project, which is primarily supported by Bill Gates and his wife, by the MacArthur Foundation, and by the Skoll Foundation. Now, 24 states have already banned outside financing of their elections. 6 additional legislatures did the same thing, but their governors vetoed it. Taxpayers should pay for our elections, not any outside influencers, because there's always a reason why a organization would come up with $500,000 for Greenwich, Connecticut, when their budget is only, I believe it's $450,000 anyway. So it essentially doubled their budget. This is merely an influence operation trying to get involved in our elections. And I just want to repeat, the financing of our elections should be a nonpartisan issue. We should all say no outside funding. It should come from our taxpayers to pay for our election. And I hope that you all pass SB 379, which would ban this practice in Connecticut. Thank you very much for this opportunity to speak to you today, and I'll entertain any questions that you might have.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Susanna Bennett, who will be followed by Ann LaMonica, who will be followed by Rabbi Nosen Leader. Susanna, welcome. The floor is yours.
Thank you so much, and thank you for the opportunity to share today. Before I get to my written testimony, I just want to say that I'm here in opposition to SJ 42, and I do take issue with the vague and misleading language of the resolution. It is about abortion, but the resolution, it does not convey that adequately. And I do oppose this resolution because of abortion. And abortion is not a right, it's a tragedy. And not only is it a tragedy because one child's life is lost, but it's a tragedy for an entire community. It negatively impacts the mother, the father, the grandparents, the siblings, the aunts and uncles, and a broader spectrum. I am here as a voice for all of them. I'm here to speak on behalf of anyone who has lost a family member to abortion, and to acknowledge your pain and to let you know that you are not alone. I know a beautiful woman who chose abortion many years ago, and she thought that she was alone in her pain and her grief. She experienced depression, nightmares, dreams about having lost a child, flashbacks, and increased alcohol use. But no one could pinpoint the root cause of her struggles. Not even her doctor acknowledged that it could be connected to her abortion. But someone finally asked her if she had had an abortion, and she found a Bible study that led her through healing and allowed her to grieve the loss of her child. So I'm here to oppose SJ 42 because I believe that in codifying the quote unquote right to abortion, we're codifying the pain and the grief that women and the entire family can experience, which is not adequately validated. And so I'm here to speak up for that and to acknowledge that this is a reality about abortion that we cannot ignore, and that these are effects of abortion that we cannot disregard and that should never be codified in our Constitution. So I ask the committee to please reject SJ 42. Thank you.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Ann LaMonica, followed by Rabbi Nosen Leader, followed by Melissa Mannion. Welcome, Ann. The floor is yours.
Thank you. The Connecticut Catholic Public Affairs Conference, the Public Policy Office of the Catholic Bishops of Connecticut, opposes SJ 42. I know that's not a surprise because it is extreme, vague, and misleading. Every person has a right to life, which is a fundamental right that makes all other rights possible. SJ 42 includes several undefined terms, the meaning of which are not incorporated by way of reference by federal or state case law, such as what is privacy? What is a compelling interest? A state court could interpret these terms anew, despite prior decisions and methodology. Is it the intent of this legislature to allow a court of unelected judges to rule in favor of restrictions for government interests that they find compelling and of utmost importance to the state? SJ 42, as it is drafted, puts the issue of abortion back in the courts and away from the legislature and the people that you represent. Of course, the General Assembly could always create laws to clarify or counteract a court's decision, which makes this resolution somewhat moot. This amendment qualifies abortion as a right by subjecting it to a compelling state interest. The right to life is not qualified by a vague, subjective, compelling state interest in the United States or state of Connecticut Constitution. Rather, the right to life shall not be taken without due process of the law, an objective standard. The right to life is unqualified by any state interest and should take precedence over a qualified right. And then I have some questions about the right to privacy, about what it includes. I think I understand why it was included in this, to cover medical records for HIPAA, due to HIPAA policies. But would this individual privacy extend to corporations, to partnerships, to trusts, to hedge funds, bank records, to cryptocurrency, to social media and mobile payment services accounts? In regards to search and seizure, would it provide broader protections than the Fourth Amendment? Would it place new restrictions on criminal investigations? Would it protect medical records, including vaccine records? Moreover, this proposed right to privacy that includes the right to abortion is fundamentally at odds with the right to life of the unborn and the right to the free exercise of religion. Does this amendment intend to override conscious rights of hospitals, doctors, and nurses who decline to take unborn human life? Finally, the designation to be used on the ballots is overly broad and misleading. It makes no mention of abortion, which dictates nearly a third of the proposed amendment. We invite you to come to our March for Life on Wednesday at noon. We're gonna have many speakers, and maybe you can see some of the people who are opposed to this and see their positive message. Thank you.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? I just have a couple of questions. Can you tell me more about the Connecticut Catholic Conference as an organization?
Yep, it's a public policy office. It's a 501c3. Well, the public affairs is a 501c4. The bishops of Connecticut, including Archbishop Blair, Bishop Cody, and Bishop Caggiano, and Bishop Hominicky of Stamford.
Okay, thank you. So the conference is the 4 bishops, and you are their public policy arm.
Yes.
The 501c4.
Yeah.
And it's run then by the bishops themselves as an individual. The conference is a body of people. I'm just trying to really understand.
Yeah, they're the board. They make up the board, and we are the.
You're the staff.
Yeah, we're the staff, exactly.
You're the
Thank
staff
you.
of the
Yeah.
board. Okay. And does the conference have a policy agenda? What are the other issues that you're advocating for here in the legislature?
Workers' rights. We've defended. We've worked for family medical leave, domestic workers. We worked with our social justice ministry office. All sorts of issues. I mean, we could list education.
Do you have a full policy agenda?
Yeah, I just don't have it with me.
Okay.
But it varies from year to year because it depends on, this year it's mostly a lot of life issues because we haven't had a chance to have any of our interests raised as bills, I guess.
Okay, so those other
there's
issues.
no other interest that there aren't any bills that we can support that we have to do a lot of defense this year. We're not in support of many bills, I guess is what I'm saying.
Okay, so is your policy agenda this year is more narrow than the issues you just listed, like domestic workers and paid family medical leave?
I think we worked with something on, I will have to check. David Reynolds covers the domestic workers and labor relations. I usually cover education issues.
Okay, so you have testified on education issues?
Oh yeah,
this
usually
year?
I testify on education issues.
And what are the education issues that the conference is advocating for?
For school choice, for sometimes a couple of years ago, we were more involved in what kind of things could be covered in a curriculum, such as African-American history. That was one of the, but that only pertains to state public schools. So we were just supporting that as a positive curriculum addition.
Okay, and is there any other entity that advocates for a Catholic policy agenda on behalf of Catholics in Connecticut other than yours?
Well, there's Catholic Charities,
Mhm.
which we work with too. And then our public social ministry office.
And this policy, the policy agenda is determined ultimately by the bishops?
Yes.
Okay, thank you. And seeing no other questions or concerns, thank you for your time again and your testimony. Next, we will hear from Rabbi Nosen Leader, who will be followed by Melissa Mannion, who will be followed by Evelise Correa. Welcome. I don't think the rabbi is responding.
Can you hear me? Can you hear me?
Welcome, the floor is
Yeah.
yours.
Hello, can you hear me?
Yes, the floor is
Hello?
yours.
Yes, it's okay, thank you. Okay.
If you-
Esteemed committee members,
Turn your camera on.
I don't have that capacity.
Okay, thank
I'm
you.
calling strictly by phone. Okay, my name is Rabbi Nosen Leiter, Executive Director of Help Rescue Our Children based in New York State. Help Rescue Our Children works with diverse partners in multiple states and with partners in Israel to secure rights of the frequently disadvantaged, including the preborn, the severely ill and disabled, and victims of child molestation and sexual exploitation. I'm testifying to request that the members of this joint committee reject the legislation at hand, J.R. 42, which proposes to insert a legal right to abortion on demand in the Connecticut Constitution. Our sages exhort us that during the culmination of the exodus from Egypt, which we celebrate in just a few weeks, even the preborn Jewish infants sang praise to God for his miraculous deliverance of the Jewish people from the Egyptian armed forces. Talmud Brachos, folio 50, quoting Psalms. This reflects the inherent, inalienable right of preborn lives. Abortion on demand is unequivocally and demonstrably against Jewish law, both in letter and in spirit, even according to the most lenient authorities. This is not encumbered with even a shadow of a doubt, contrary to whatever you may be hearing. Those who insist on ensconcing the mandate for mass murder of the preborn in legislation, and how much more so, into the Connecticut Constitution, would be best advised to comply with basic transparency protocol and reveal their agenda. Any such legislation must be clearly identified for what it truly is: the state mandate for the wholesale liquidation of preborn citizens. That needs to be articulated unambiguously in any ballot amendment, unlike the ballot amendment included in this particular legislation. In plain English, please do not obscure lethality under the guise of privacy, and please do not masquerade the license to end the life of an innocent victim as the right to privacy or the choice, the right to choice of the perpetrators and their enablers. Doing so deceives the public and thereby undermines the legislative legitimacy of any such ballot amendment and its legislative mandate, namely this bill. Furthermore, it establishes lethal precedent inasmuch as the road to genocide is paved with deviant definitions. Thank you kindly in advance.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you so much.
Next, we will hear from Melissa Mannion, who will be followed by Evelise Correa, followed by Raymond McDade. Melissa, welcome. The floor is yours.
Good evening, members of the committee. I am testifying in strong opposition to Senate Joint Resolution 42. I need to start by saying I am disgusted with our state's clear desire to be an abortion sanctuary. A sanctuary is defined as a place of refuge and protection. I strongly believe that that should start within the womb. Instead of being so concerned about enshrining a woman's right to end the life of her child in utero and making it part of the very fabric of the foundation of our state, why don't we focus on helping lives to thrive? Acquiring an abortion in Connecticut is as easy as ordering a pizza. You don't even need to be of legal voting age to decide on this life-altering procedure, despite the fact that my 16-year-old daughter needed not just my permission, but my presence for a small wrist tattoo. At the click of a button on my phone in the lobby here, abortionfinder.org gave me the names of 29 different providers in the state of Connecticut. Some can get me an abortion without even being in their presence. Meanwhile, The state is wrongfully attacking pregnancy resource centers who provide free prenatal care and necessities to moms in need. Last year, the standard of care and scope of practice necessary to perform abortions in the state was lowered to include nurses and PAs in an ability and effort to increase the state's ability to end the lives of the innocent in the womb. And now this. Now it is proposed as an amendment to our state's constitution. How careless at best and demonic at worst, to be in support of something so unnecessary. The fate of abortion is not at risk in Connecticut. As a matter of fact, I am out here fighting because it's far too pervasive already. Allow me to help you to understand why I care so much. I became pregnant at the young age of 19 under less than stellar circumstances. I chose life for my child. He is now 27 in Tampa and getting his master's degree. 3 years later, after becoming his mother, I got pregnant again. We were planning to have the child until I got scared. In an instant, I changed my mind, then looked this man in the face and told him I was having an abortion and there was nothing he could do about it. I changed our lives forever and not for the better. Abortion not only ends the life of a human, it can destroy the lives of mothers and fathers too. It's not something honorable. As we all know, Connecticut is nicknamed the Constitution State because of the fundamental orders of Connecticut served as a model for the U.S. Constitution. We also all know that the Supreme Court just overturned Roe v. Wade because we recognize that the ending of life should not be a constitutional right. In a country where life, liberty, and the pursuit of happiness are paramount, I implore you to think long and hard as the stain it would be on our state to go against that and to lift up abortion more than we already have in the state of Connecticut. I, for one, do not want all that blood on my hands. I implore you to vote no on SJ 42. Thank you for your time. I'm happy to answer any questions.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Evelise Correa, followed by Raymond McDade, followed by Anna Montalvo. Evelise, welcome. The floor is yours.
Thank you. I'd like to thank the committee for allowing me to speak today. My name is Evelise Correa. I am Executive Director of Good Trouble Advocates. And I'd like to begin with a public comment on an act concerning state agency complaints. I'd like to comment on this irony of the bill and once again ask that the Connecticut GOP and Craig Fishbein unblock me on Twitter.
Sorry for that, Evelise.
I'm sorry.
Please continue.
Okay, so
hold on one second. Sorry.
can I start over?
Yep, just hold on just 1 second. Can we just mute all of the Zoom participants right now? If you can do that, Madam Clerk, thank you very much. Evelise, go ahead. Sorry for the interruption. Okay. The hybrid is a challenge. And so I know you've seen both sides of participating. So
yeah.
Thank you for
Nope,
being
so
here.
I can
thanks
I
for your
can
patience.
sympathize. All right. I'd like to begin with public comment on an act concerning state agency complaints and whatever with social media platforms. I'd like to comment on the irony of this bill and once again ask that the Connecticut GOP and Craig Fishbein unblock me on Twitter and that Erin Stewart unblock me on Facebook on her public page, not her personal page. Also regarding SB 122, this bill is not only unnecessary, but makes it harder for the general public to access information with extra steps and more fees. This will have a chilling effect on public accountability, and I ask that the committee vote against this bill, which should have gone to public safety first. Finally, SB 1226, an act concerning the state voting rights recognition of John Lewis. I'd like to remind the committee that Barack Obama is half white, and his name's been brought up a lot today. Next, Connecticut was segregated by federal law, and I'll provide a history lesson. The Great Migration began in the 1920s and ended in the 1970s. During this period, Southern Black Americans moved from the South up north. Federal law written in 1934 as part of the New Deal segregated our state by race, negating the need for Jim Crow, Who needs their own water fountain when you have your own zip code? With the increase of Black Americans in Connecticut, we repealed county level government, leaving us with 169 municipalities and away from a regionalized government like Texas. Of course, legislators won't look for news of disenfranchisement in Hartford and New Haven, but there are news reports of them. I would assume that voters in the suburbs aren't calling their state reps because someone in Hartford or New Haven was disenfranchised. Forgive me if people who are forgive me if, state reps from, suburban areas are ignorant to these facts, but I have a couple examples of racism in voting. Having long lines in the cities in which your parents and grandparents were segregated into is a form of racism. Why are there only long lines in places where people of color were required to live in Connecticut? Next, having to explain to the children and grandchildren of those whose parents and grandparents' generations segregated my parents and grandparents' grandparents into Hartford, about the barriers we face is not only a form of racism, but it's insulting. Next, having to give free history lessons to elected officials who didn't read the bill is also a form of racism. Finally, I would request the removal of Latinx from government documents. You do not insert English into Spanish in order to make it more inclusive. And if the committee has any questions, I'd be happy to answer them.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee?
Oh, that's, I would like to make sure to put those 3 examples of racism on the record, because I know that question was asked a lot today.
Thank you. And thanks for your testimony. It now is on the record. Thank you very much for your time today. Next, we will hear from Raymond McDade, followed by Anna Montalvo, followed by Raphael Kalickstein. Raymond, welcome. The floor is yours if you're here. I don't know that you are, so I'm gonna move on.
I'm here. I'm here.
Welcome. The floor is yours.
Thank you very much. It's a privilege to be able to be part of this forum. I would like to just comment on SJR 42. I'm opposed to it. I think that the language, as many people have already mentioned, so I'm not going to beat this to death, but the language is unclear and deceptive. And I think we all have to be honest about the fact that this is a subject that's deeply divisive. People have very strong, passionate feelings about it. And the idea that it should pass directly to be included in the Constitution doesn't seem a wise way to move forward. Much better would be to keep it within the confines of the General Assembly. Is the best forum for discussion to occur, rather than place it in as a constitutional right that would limit discussion and debate for the future. And again, I have my strong feelings, as others do, about this issue. And I think a fair question would be to ask, do the people of Connecticut really want abortion available all 9 months of a woman's pregnancy, even those who might favor pro-choice? And I just think that this is an attempt to push something through that needs better discussion and offers a way for people to dialogue rather than make it a constitutional law. And I'll leave it there.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Anna Montalvo, followed by Raphael Kalickstein, followed by Representative Geraldo Reyes. Anna, welcome. The floor is yours if you're here, which I don't see Anna. Okay, so I'll try Raphael. Raphael, are you here? Looks like not. So it looks like it may be Representative Reyes. Oh, wait, Raphael, are you here? Raphael, if you could speak up so I know that you're ready to testify. Otherwise, I'm going to move on to the next person. Raphael, because I don't hear you, I'm going to move on to the next person. And you
Can you hear me?
Terrible echo. You may need to disconnect from the Zoom. Shut Zoom down and start back over again. Because you are on twice, which may be what's causing the echo. Raphael, do you want to speak? Okay, we're going to move on, Raphael, and hopefully you can disconnect. You are on the Zoom twice, so you may need to disconnect from one of them in order to be able to be heard. Okay, so try to disconnect one of the devices you're logged in with it. We're going to move on to Representative Reyes and let Representative Reyes have their turn. And then we'll come back to the other folks that we've missed. Thank you. Welcome, Representative Reyes. The floor is yours.
Thank you. Thank you, Madam Chair, Chair Blumenthal, ranking members and members of the GAE. I come here today in complete support of House Bill 6909. And I wanted to echo a little bit of the statements that were made earlier by newly elected Representative Annabelle Figueroa, who did her research and actually imposed the statement, which was what I was going to emphasize today, which is LULAC, the largest Hispanic serving agency of civic engagements in the United States of America, has banned the word Latinx in the year 2021. We have had a lot of conversation internally and externally on the word Latinx, and its origins could be as mystifying as a lot of other things in this world, but it is not a term that comes from Spanish origin. It is not a term that was comprised from the Spanish-speaking countries. It is not recognized in Madrid, the home of the Spanish language, officially. And I think that what happens typically in the United States, because language evolves and people get used to hybrids and whatever is easiest, and probably trying to fit an English word into a Spanish word. The Spanish word for a male is Latino, and for a female is Latina. And then depending on the item, it's either Latino or Latina, or it could be Latin, just plain Latin. It's always been an inclusive language. It's been around for centuries. And the fact that a particular group has decided to put an X on the end of an English word is not suffice, and is not does not make it Spanish, and does not make it inclusive. I want to bust a myth that this particular group of folks that were against the Latinx word are coming from a homophobic stance, and that couldn't be further from the truth. Our voting records have indicated that we have always supported the LGBTQ community. And in fact, many of the LGBTQ community folks that we've spoken with also don't like the word Latinx. So I come to you very simply looking that is just one of many different words that could be offensive or insensitive to a particular body. 98% of the Hispanics that are in this country either don't speak the language, either don't recognize the word, have never heard the word, certainly don't use the word. I've never used the word. And it is a very small group body of folks that actually use it. So I would just like to thank the GAE for the opportunity to testify on this bill, number one, and number two, to hope to have your support to pass this piece of legislation so we can vote on the floor. Thank you for the opportunity.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee?
Thank you.
Thank you again for your testimony, Representative.
Thank you, Senator.
Okay, so that ends our list of people who have signed up. So we're going to circle back to the folks that we missed, and we will start with Yancy Velez. I'm calling you first. We'll be followed by Mary Deldon Nelson and hopefully Raphael Calixtine. Welcome, Yancy. Please correct me if I'm pronouncing your name wrong, and the floor is yours.
Thank you very much. I appreciate the opportunity, Co-Chair Senator Flexer, and all the ranking members that are here today. as well the distinguished members of the Government Administration and Election Committee. I take this opportunity with the greatest honor to represent our communities and also the members of our organization. I am the New England Regional Director of Hispanic Federation, a nonprofit organization seeking to empower and advance Hispanic communities through the community's programs and legislative advocacy. Today's testimony also is informed by the coalition that we are part of civil rights, and the organizations that are members of the Hispanic Federation who works every day to improve communities' outcome and opportunity in the state of Connecticut. We believe that the right to vote is one of the most fundamental components of our democracy. Therefore, I'm here to advocate in full support of SB 1226, an act concerning state voting rights in recognition of John R. Lewis. The VRA was enacted to combat a wide range of barriers and burdens that excluded voters of color from electoral process, yet it has come under attack recently with provisions that avoid and eliminate the opportunity for everyone to go out and vote. This is why Connecticut must continue to lead and serve as one of the states with the best voters protection by codifying into law protections included in the VRA. We believe that this bill is significant because 1.4 million residents in the state of Connecticut who conform the rising American electorate, who are the single head of household women, voters under 34 years old, and minorities that define the census will gain protections that are not assured under the current state law. These measures have been discussed throughout the day. I have been there all day, and I appreciate of this committee to be willing and able to learn and educate themselves as well to get questions. But it is important that to highlight that for us, expanding language assistance for voters with limited English proficiency, it is substantial for electors to get out to vote. Research shows that ballots are already often confusing and complex even for proficient in English speakers, and that people with limited English proficiency face even greater barriers at the ballot. More than 275,000 Connecticut residents statewide have limited English proficiency, including immigrants and indigenous people. Under the federal voting rights, some of the towns are required to have language assistance, but there are voters in other places in our state who also need translation. And I could get a highlight that the top 5 languages spoken in the state of Connecticut is English, Spanish, Portuguese, Polish, Chinese, and they are conform of this number that I just mentioned. I believe that part of the questions that are arising today as part of all the testimony, really we can conclude that nothing stands in the way of Connecticut establishing its own Voting Rights Act. Similar state law has successfully enacted in New York, California, Washington, Oregon, Virginia, and they all have been able to create their own and necessary voter protections against intentional or unintentional consequences that contribute to voter suppression and those activities that reduce barriers that contribute to a lower voter turnout.
Thank you.
Today, I just want to say
the lapse. Can you please summarize your testimony? Sorry to interrupt you.
No problem. Thank you. Yes, I really just wanted to say that our efforts is to prioritize on voter protection in our democracy. So we thank you for the time and reemphasize once again that we just want to prevent and avoid future discrimination or voter suppression at state level. Thank you for your time, and we look forward to working with you guys.
Thank you. Thank you for your time and your testimony. Are there any questions or comments from members of the committee? I just have one question. Can you just tell me a little bit more about the Hispanic Federation as an organization, who you represent and what you do?
Yes, we are a 501c3 nonprofit organization. We are national, and we have been in the state for over 8 years. We are comprised by member of organizations who are local nonprofit organizations, mostly working with the Latino community, but also other community or BIPOC communities in the state. We do provide a series of programs that includes capacity building and advocacy opportunities for our members to raise their voices and the concerns of the communities that they serve.
Great, thank you. Thank you very much for that information, and thanks again for your time and your testimony today.
Thank you.
Next, we will hear from Mary Delden Nelson, who will be followed by Raphael Calixtine. Welcome, Mary. The floor is yours. Mary, we cannot hear you. You need to unmute yourself.
Thank you. Sorry. Thank you, distinguished legislators and senators, for this opportunity to speak. I would like to speak in opposition today, in opposition to SJ 42, constitutional right to abortion up until birth. I, as a scientist with a bachelor's degree in science in nursing, I wanted to talk a little bit about baby cells and how they're present in mothers' bodies during and after birth. And there's an exchange of DNA. And even this happens in spontaneous miscarriages. And I think that these are separate human beings. And according to the Harvard Science Review literature, this is a phenomenon that can last up into mom's bodies, the baby's cells, for 27 years. So to say that this human growing inside a mother's womb is not it doesn't have a constitutional right to life seems to me extraordinary. And I know that you say that there's separation of church and state, but some groups together in Satanists in Texas have said that abortion is their ritual and they would like to keep it. That seems pretty terrifying to me, given the historic American Birth Control League, which was established in New York City ghettos, in the Black and Jewish ghettos. And she believed that persons that lived like this, they were imbeciles, they were expendables. She was a great believer in eugenics. So what do we do with these babies that are aborted? Do we send them to the University of Pittsburgh so their scalps can be removed and placed on human mice? Because that's the experiments they're doing. And that is also, I can give you citations for that. It seems to me we don't have a constitutional right to do that. It's experimentation on humans. And I believe that that's pretty diabolical and pretty terrifying. When chromosomes come together, male chromosomes and female chromosomes, they form an entirely set of a new DNA, even at the embryonic level, even at the blastocyst level. So thank you for allowing me to speak. I've known people that have had abortions. I've had 3 miscarriages myself, and it's traumatic. And to say that it isn't anything else. And I don't judge people who've had them. I just don't think that we have a constitutional right to take human life. And that's something I'm very passionate about as a nurse who have seen live births and seen the miracle that babies are.
I'm sorry to interrupt you, but your time has elapsed. So
thank you so much.
Thank you.
Thank you for your time, and thank you for allowing me to speak. It's an honor.
Thank you. Thank you for your time and your testimony. Seeing no questions, thanks again. And our last person who's signed up to testify and is either present online or in person is Raphael Calixtine. Hopefully we can get the audio right this time. Or Raphael, if you want to unmute yourself. and turn on your camera. The floor is yours. Raphael going once, going twice. Speak now or literally forever hold your peace.
You can send us written testimony if you like.
Yes, we can take your testimony in writing. Okay, well, seeing no one else who is here or present to testify, I declare this public hearing adjourned. Thank you to everyone who participated.